2, 1, 5.
Recognizing a quorum of commissioners, I call the September 21st, 2023 meeting of the Cannabis Control Commission to order. This meeting is being held remotely pursuant to Chapter 22 of the Acts of 2022 and is being recorded. Commissioners Camargo, Stebbins, Roy, and myself are participating in today's meeting. All votes taken today will be by roll call. We have a full agenda today that I will generally summarize. First, we will formally be voting on the designation of an acting chair. Next, we will move into discussions on draft regulations regarding host community agreements, municipal equity, and marijuana establishment agent suitability. I anticipate this will be a live drafting session and edits will be incorporated following discussions in order to be voted on. I'll ask the commissioners wishing to comment or ask questions during any part of the meeting to raise their hand and in order to be recognized. So with that said, first we will go into the designation of an acting chair. Those initial comments. As we discussed on Monday, Shannon O'Brien has been suspended from her post as chair by the treasurer. Therefore, legally, she is unable to discharge the powers of that office, including, but not limited to, designating an acting chair. As the commission has not adopted a governance charter, the appointment of an acting chair is a decision that falls to the entire body. This is aligned with General Laws, Chapter 94G, Section 4. As Monday's vote designating an acting chair during the regulatory review process was not noticed, it is critically important that commissioners vote to affirm that vote now that it has been noticed. So what I would like to do is to have a really transparent, honest conversation that's also respectful as we move into this discussion piece. Do we have any comments from my fellow commissioners? Commissioner Stebbins.
Sure. Thank you, Madam Chair. I'm happy to make essentially the same motion that I made on Monday to continue to allow you to serve as acting chair during this regulatory process. If and by council acting GC Carter in, if that would be appropriate at this point.
I'll second.
Acting General Counsel Carter.
Yes, thank you, Madam Chair. I would suggest if Commissioner Stebbins would be comfortable making two motions, one related to affirming the vote that occurred on Monday, and then a second vote related to closing out of the regulatory process.
Commissioner, Roy, and I have a question, Acting General Counsel Carter. Closing out the regulatory process, what exactly does that mean?
I would defer to Commissioner Stebbins since it is his motion.
Okay, Commissioner Stebbins, do you mind providing some additional clarity, please?
Well, the new motion isn't mine yet, but okay. I appreciate Acting General Counsel. First of all, let me explain, my thoughts on the motion I offered on Monday. That was to designate you, acting chair is the chair to help the commission move through the body of work through this regulatory review period that we're still finding ourselves in. So I'm happy to make a motion to that effect and take that as kind of a first step. But certainly if you want me to do that now, I can certainly do that now. Acting General Counsel, what's your preference?
Acting General Counsel Carter.
Yes, I think I may have misunderstood the motion that was previously made. Commissioner Stebbins, I believe the motion you made is sufficient for our purposes here.
Commissioner Roy?
Okay.
Commissioner
Stebbins. Commissioner Stebbins, I didn't know if you were finished. You can finish before I go to Commissioner Roy.
No, go ahead to Commissioner Roy and then.
Commissioner Roy?
Yeah, I just would appreciate if Commissioner Stebbins could repeat the motion language.
Commissioner Stebbins?
Sure. I mean, without having the benefit of my notes from the other day, I can certainly make a motion to move to affirm September 18th, 2023's vote designating Commissioner Concepcion as acting chair for the final regulations review period.
There's a motion on the floor. Is there a second? And also, go ahead, Commissioner Roy.
Point of inquiry, does that mean that ends after today if we make the vote?
Commissioner Stebbins?
Sure, as I see it, it ends at whatever time I know we have time posted tomorrow if we need it. It ends at whatever time we've decided that, or whenever we take a vote on our final regulations.
Commissioner Camargo?
Kind of moves it to the promulgation process. Sorry.
Commissioner Stebbins, I just got confused by that last comment. Sorry. Do you mind explaining that again?
Sure. Obviously, our regulatory review period, unless I'm mistaken, really ends when we take a final vote on the current, red line draft regulations that we're viewing. That could be today. That could be, I know we've set aside tomorrow. That it could be, at whatever point tomorrow, at whatever point we wrap up our review and direct staff to go ahead and finish taking steps necessary to complete the promulgation process.
Commissioner Camargo?
Thank you. Good morning, everybody. I think we gotta, I don't want to make it too clunky or muddy the waters, but I think from Andrew Carter's email, in terms of just guidance for this morning, we have to just restate the same motion that we did on Monday. And just to keep it clean, I think Commissioner Stebbins, you should go ahead and make that motion that we did on Monday. And then I think we can take a new motion, sort of pass, like if we finish today at whatever time, pass what we finished today. So I'm happy to make a second motion for that, but I think we should at least get the first motion that was already done on Monday so that it is, so it's legit basically, and then we can go to the second motion.
Thank you, Commissioner Camargo. And I believe that is the correct interpretation. So there's two things that have to happen. One is reaffirming the motion that was made on Monday. The second is that motion carried until Wednesday. So now we are currently technically without an acting chair or chair. So we would have to decide amongst ourselves, the four commissioners, next steps that are in the best interest of the agency. Commissioner Roy?
So I just got confused a little bit by Commissioner Stebbins' language at the end. I think you had a question too. So is it at the conclusion of the vote? Because the promulgation date is much different. So that's a big distinction there.
I'll take a step back because that's a second. And Commissioner Camargo, thank you for that. The direction that you're suggesting, because I think that it's easier if we are sort of understanding what we're doing now. First is as I mentioned, we have to reaffirm Monday's motion. So Commissioner Stebbins, I'll ask if you can repeat the motion from Monday so that we can have it on record. It's been noticed. And for our purposes here, we can vote on that. And then we can have a conversation about what happens today. And then, what that motion might look like, what your thoughts are. Because I think, Commissioner Roy, you're asking about that secondary, sort of what happens from this point, if I'm not mistaken. Commissioner Roy?
Yes, I guess Acting General Counsel Carter. This is unusual to reaffirm a motion. Can you explain the necessity for that?
In General Counsel Carter?
Yes, if I may, Madam Chair, and thank you for the question, Commissioner Roy. It's an excellent one. So as you'll recall on Monday, it was not noticed, that particular vote. So we want to make sure that any decision made by the board is not open to challenge later. So it's just sort of closing the loop to make sure that what we have done has been noticed and is in compliance with the open meeting law.
So that vote was not done properly?
It was because it was new business, but that is why we are affirming it to make sure that we're closing the loop.
And how was the loop not closed?
Because it was not noticed, because it was not anticipated at the time of posting. So we're just making sure that we're doing everything by the book, because the board has been working incredibly hard to get these regs complete. And I just want to make sure that there is no avenue for challenge.
Thank you.
Thank you.
Commissioner Stebbins?
Sure. Thank you, Chair. So I put a motion on the floor, and I think just to answer the question that you, Madam Chair, have raised, Acting General Counsel Carter, since my motion on Monday was not anything that I had written down, is the I want to be clear that the motion I just offered would be sufficient to reflect the motion and vote that that was taken on Monday.
If I may, Madam Chair.
Counsel Carter. Yes.
Yes, I mean, my suggestion would be to move to affirm September 18th, 2023's vote designating Commissioner Concepcion as acting chair for the final regulation review period. And I believe that was the motion that you made, Commissioner Stebbins, but just for clarity, I wanted to just reread it into the record.
Okay, and that's the motion as I've expressed it at this point.
So then if there's a motion and a second, then we can proceed with a vote if appropriate.
So Commissioner Stebbins, do you have a motion?
I'll make it again. It's my motion to move to affirm September 18th, 2023's vote designating Commissioner Concepcion as acting chair for the final regulations review period.
Is there a second? I will second. I'll now do a call of the roll. Commissioner Camargo?
Aye.
Commissioner Roy?
Aye.
Commissioner Stebbins?
Aye.
The chair votes aye. We have 4 in favor, none opposed. The vote is unanimous. Commissioner Camargo?
Thank you, and good morning. Sorry, I was trying to get off of mute earlier. So I motion to designate Commissioner Concepcion as acting chair until the completion of the regulatory process for Chapter 180. And just my explanation for that is we still have to finish today's business. We're not sure it will go until tomorrow. We're hoping it won't. And then we have to do internal processes and reviews in order to promulgate the regs with the Secretary of State. So my motion is really to allow Commissioner Concepcion to act as acting chair until we have promulgated the regulations. That's my motion.
Commissioner Roy?
I just want to be clear. What is actually, Attorney Carter, what is the promulgation date, please, for the record?
Acting General Counsel Carter?
Thank you, Madam Chair. To Commissioner Roy's question, so our deadline is November 9th. That is when the regs must be promulgated.
So according
Commissioner
to Commissioner Camargo's motion language, then Commissioner Concepcion would be interim or acting chair until November 9th. However, there's still social consumption that is part of the regulatory process. So are you including that as well?
Commissioner Camargo?
Thank you, Commissioner Roy, for that clarification. And I will also say that we have to promulgate by November 9th, but I hope, I have faith that our team will promulgate regs before November 9th. And Commissioner Roy, it does not include social consumption. We are currently working on social consumption. Obviously, we've been at a pause the last 2 weeks in getting ready for these regulatory meetings, but it does not include the new language for social consumption. We still have a few more months before we can get to any type of review on social consumption. So thank you for asking. It also allows me to give the public an update on that. So I really, my motion really stands with what we have reviewed and edited over the last 3 days, and that we would complete that portion. I hope that answers your question, Commissioner Roy.
So I'm not in
Commissioner Roy.
favor of it. I'm not in favor of this motion. I'd like to be able to have a debate on the next public meeting on who should serve as acting chair. I think there are a lot of questions. I think the legislature has expressed concerns over the status of Chair O'Brien and the legality of her suspension and the letter we got. So I think there was a delegation memo. So I have a lot of questions that was sent on September 13th to all of us, delegating her authority in her absence to me. So we have a delegation memo, which you're saying that's not in effect. And so that was sent to all of us, I believe, on September 13th. And now we have a letter from the legislature questioning the legality of the suspension. So I am not comfortable getting past. I'd like to have this debate on public meeting on October 12th. And I'm only comfortable personally myself getting through today and tomorrow. And then we could have a rigorous debate, which I don't want to hold up today's work. So I'd like to have a rigorous debate on October 12th around this. There are a lot of questions. And I just feel that that's extending it way into November. And the legislature has questions around this. So I just feel it's in transparency. We really should just get through tomorrow or tomorrow, and then let's have a robust discussion on October 12th during public meeting.
Commissioner Roy, when you say the legislature, because the legislature is the entirety of the Senate and the House, are you speaking about the Senate and the House of Representatives?
I believe we all received a letter, a bipartisan letter with concerns, and I think that was one of them. That was, well, I know that was one of them. I just want to be
concise. I just want us to be concise here. Okay.
Members of the legislature. That's probably a little more accurate. Thank you.
Commissioner Camargo.
Thank you. Just a point of order, because we're getting into a discussion without having the motion seconded, so that we can then have a discussion. So I think that's the proper way of doing it, right? That's how we've done it, and that's how. So I want to just kind of bring it back, because we do have a lot to do today. But I do have a motion on the table, and I will repeat my motion. And the motion is to designate Commissioner Concepcion as acting chair until the completion of Chapter 180 and the promulgation process, obviously before either up to November 9th or before November 9th. And once that happens, we're just going to have to come back and sort of have that conversation. But that is my motion as it stands. I don't know if there's a second. Madam Chair, I think you can ask for a second. That's not my role to ask.
Thank you, Commissioner Camargo. Do we have a second? I will second the motion.
Commissioner Stebbins had his hand up.
Go ahead, Commissioner Stebbins.
Sure. I was going to suggest something after Commissioner Camargo's comments. It's helpful to have a discussion before there's a second, because then you're asking to completely set aside a motion if there hasn't been thoughtful discussion on it, and I appreciate that. If I might suggest this, and I know Commissioner Roy raised the point about the letter that was not addressed to us. It was addressed to the chairs of the Cannabis Policy Committee, but obviously we were copied on it. The situation with the chair is not ours to resolve. Our our goal here is to obviously continue the activities and meet our obligations as a commission. We had considerable discussion and debate about this on Monday. I think I expressed my opinion that Commissioner Concepcion, as you pointed out, we have had tremendous work around the governance charter. We need to get back to that. And also, you know, I think mention the precedent that we have in appointing the whoever is serving in capacity as secretary to fill in for the chair. Again, usually the chair had done that. And I know the motion's been made and seconded. It would be my proposal or my suggestion. We have regulatory review, which you, Madam Chair, have been appointed to help us conduct those meetings and move through this process. Between now and I think our next public meeting date is October 9th. There may be things that come up that staff need to return to us on as part of this regulatory promulgation process. I hope and anticipate that is not going to be the case, but I do think that some clarity about allowing you to continue to serve during this regulatory promulgation process, which we don't know when our internal staff work will be complete. But I also think we need to have some clarity when we open the meeting on the 9th to have a chairperson to be able to do that. So again, if this motion doesn't fail, I'm prepared to make another motion after this. But again, some clarity about wrapping up this regulatory work, which may or may not include staff having to come back to us, asking us to post a public meeting, asking us to review some final changes that they've come across. Is they're trying to get 900, 500, or 935, 500, 935, 501 to be concise and align. We've only been walking through, as we've pointed out, the changes on the adult use side. We are eventually going to task staff to go back and align all those changes on the medical side. I think we want to allow ourselves some space that if we need to come back and look at 935, 500, 935, 501, and I know we're under a tight time frame, we want to have, I think, the space to be able to do that. So my suggestion would be after this vote, if it doesn't pass, that we move to designate you, Commissioner Concepcion, as acting chair through the end of the regulatory process and to open our meeting on October 9th. We may have some clarity around the status of the chair at that point. We don't know. Again, that's not within our authority to make those decisions. But I'm trying to just think about how we can finish this process and be prepared to open the meeting, our next public meeting, which is scheduled for October 9th, but safeguard ourselves in that intermittent time period. If for any reason staff, as we finish this regulation process, has to come back to us and we have to post a public meeting.
Thank you, Commissioner Stebbins. I think that you've provided some really valuable comments. Our focus here at the Cannabis Control Commission is our job right now with regulations. I know that there are, external things that are occurring that are outside of our authority, outside of our abilities, outside of our responsibilities. And I'm not speaking to that. I'm choosing not to speak to that because I don't have, we as a collective, we're separate and aside from the treasurer and her appointing authority and whatever might be taking place in that arena. Right now, we are tasked with regulations and getting this job done. So if I could, just offer a suggestion now as we can talk a little bit more, but I just really want us to focus on the task at hand where we are right now at the Cannabis Control Commission. the fact that we do have a number of operators, municipalities, numerous stakeholders who are counting on us to be focused, to continue the work, and to get our jobs done. I saw Commissioner Camargo's hand up, and then I will go to Commissioner Roy. Commissioner Camargo.
Yeah, my only question is, I hear Commissioner Stebbins' point, and I know that we're always trying to look for the balance here because we just got to keep sort of moving and going through these regs. Is I obviously there's a motion on the table, and I know Commissioner Roy has a question, but I guess I was going to ask. I have the ability, since I put the motion, to withdraw the motion, or we can go through the vote, right? So I can wait a second until Commissioner Roy asks her questions.
Is that what you're, okay, Commissioner Roy?
Yeah,
I just want to make sure I understand Commissioner Stebbins' motion. Basically, the next public meeting in October, and I know we haven't voted on Commissioner Camargo's. I just need a point of clarity on Commissioner Stebbins. That Commissioner Concepcion will just open the meeting, and then we will entertain a vote to who will serve as acting chair. And I hear you, Commissioner Concepcion, or Madam Chair, but I think all of us here have a skill set that could also handle that. It's just, I think we all can, we all are experts in our field, and I feel all of us have the qualifications to be able to chair. So I think that we need an open discussion on the next meeting. I think it's not, you're not the only one uniquely equipped to do it. I think there are many of us on this board that could handle that. Thank you.
Commissioner Stebbins.
Sure, thank you. And it's great having our great team around supporting us. I had the October meeting date wrong, so we just clarify when that would be. I think I'm going to make the same mistake. I believe it's October 12th. I think I had mentioned October 9th. It's October 12th. So just for that clarification, again, we don't know where we might be at with respect to Chair O'Brien's status when we open that meeting. I think this is a good safeguard for us to put in just so we can have the authority to open that meeting and continue to do our business. I do want to make a comment. It is kind of separate and aside from this. I've said it during our public meeting among the four of us of how well I feel we have all been working together, and going through this regs is an exhausting process. It is looking at shells and maze and everything else. And there might be a tremendous amount of focus on the four of us completing and wrapping up this work this week. But I'm also mindful of the rest of our team that's out there every day is still doing their job. Those are our investigators, financial managers, licensing specialists, our lab investigative team. So I know the focus is on the four of us this week because of what we're doing and how we're responding to comments and concerns that are coming in through this regulatory process. But I just wanted to take that moment to notice the great work of our team who we don't see on camera every day that's still out doing the work on a day in and day out basis. So thank you, Chair.
Thank you, Commissioner Stebbins. I'll be really frank, and that's the benefit of us having this open conversation. We're not in an executive session. Everyone kind of hear where we are, what our thoughts are, but this is obviously not. It's an uncomfortable conversation. It's a little sticky. We're trying to just figure out amongst ourselves openly the best way forward. The reason why I seconded the motion and I'll continue to support the motion is I don't want to do this over and over again. We just had this conversation on Monday. We're back on Thursday. There's work to do. There'll be work to do in October. I would like to show some stability to where we are and what we're doing. And for that reason, I guess I don't really, maybe I'll pose a question for you, Commissioner Stebbins. What is, guess what difference, what changed between October and November, hypothetically speaking? Like, what is, I think I'm missing the, I'm not necessarily understanding what might change in terms of the dynamics. If we have a actual chairperson, then we have a chairperson. The conversation here is about an acting chair in the interim in order to continue the work of the Cannabis Control Commission. So I think I could use a little bit more clarity in terms of moving from the promulgation date to October.
I'm sorry if I might, Madam Chair.
Please.
Yeah, it's certainly an important question. Again, my suggestion was to help us move through this promulgation, the regulatory work that we're doing now, and allow us to set the stage for being able to open our public meeting on October 12th. You know, beyond that, you know, I guess it is a little tenuous, but can I give it some thought? I know Commissioner Roy has her hand up too, but.
Commissioner Roy?
Thank you, Madam Chair. Based on that statement, then one could have applied that logic to Monday. We had the secretary had been precedent. It had been done over half a dozen times. We had a delegation memo sent to all of us on while the chair, before the chair's suspension, which the members of the legislature are questioning the legality of, transferring her authority to me through a duration of her absence. So that was legally executed when she was before her suspension on the 13th of September. So there was, within her statutory authority, there's that. There's precedent that the secretary, we agreed on unanimously and has been policy and has been done a half a dozen times with no objection. So why the disruption on Monday? I think it's, you know, if you're going to apply that logic, let's apply it to Monday.
Thank you, Commissioner Roy. Commissioner Camargo?
Thank you. And thank you, Commissioner Stebbins and Commissioner Roy and Commissioner Concepcion, just for the discussion. Commissioner Roy, you said that, you know, we're all equipped to sort of chair these meetings, and we probably are. But I don't think everybody does. I don't think everybody wants to chair these meetings, right? It is a very challenging position, and you know, you got to manage all of us to begin with, right? And then you got to sort of manage the day-to-day and in terms of these meetings. So I think I hear you in terms of, you know, your comments of, you know, folks, you know, all of us are ill-equipped. You know, we could do a rotating, you know, decision, you know, option as well. I think to Commissioner Concepcion's point, and even us having this conversation here, we need to move forward. You know, there is some challenges right now, obviously, but we need to move forward. We need to be stable. And I'm going to repeat this again. We need to govern ourselves. And there are questions that, and those questions can be answered, but we need to be able to govern ourselves. And if you want to be acting chair, Commissioner Roy, put a motion on the table. Because I'm hearing you and I'm sensing that this is something that you want to do. And you are the secretary right now. In the next few weeks, we also need you as secretary in terms of your ability with the minutes, your ability to help with even the filing of some of this stuff. But you also have a role as secretary. But if it's something that you want to, you know, that you want to be acting chair, just put a motion out there. Like, we need to stop kind of going back and forth and sort of beating behind the bush. If that's something that you want to do, put a motion on the floor. So, and I respect if that's the process. But I think for the purposes of right now, I'll just say my motion stands in terms of designating Commissioner Concepcion as the acting chair so that we can move through the regulatory process, which includes probably the October 12 meeting. And right before the promulgation, the regulatory, the regs are promulgated, sorry. So I do have a motion on the table. We can continue the discussion, but I just wanted to bring it back to that because this back and forth is gonna stop us from getting today's work done. So that's my piece.
Commissioner Roy.
Thank you, Madam Chair, and thank you, Commissioner Camargo. I have a question for Attorney Carter, and I'm going to read something into the record. We received a delegation memo on September 13th from the chairperson Shannon O'Brien. Prior to her suspension, I will not be attending the December 14th, 2023 meeting of the Cannabis Control Commission. Pursuant to Massachusetts General Law, Chapter 10, Section 76, subsection H, the chair shall preside at all hearings at which the chair is present and shall designate a commissioner to act as chair in the chair's absence. I hereby designate Commissioner Kimberly Roy to serve as chair of the Cannabis Control Commission for the September 14th meeting and throughout the duration of my absence. Best regards, Shannon O'Brien. Attorney Carter, is that not legally binding? Is that what you're saying?
That would be
Acting.
correct. Oh, I'm sorry.
Go ahead, Acting General Counsel Carter.
Yes, that would be correct, Commissioner Roy. Because Chair O'Brien has been suspended, she does not have the legal authority to designate an acting chair. She does not have the authority to exercise the powers of that office until there is a change in her status by the treasurer.
Where does that say that?
Commissioner Roy.
Attorney Carter, thank you so much for that explanation. I just don't see that anywhere in statute talking to a suspension.
Commissioner Roy, I in the interest of time and what we have on the table, this is I know Acting General Counsel Carter provided that explanation on Monday as well, and he's restating what was stated on Monday. I think Commissioner Camargo has a motion on the table. I've seconded. I'll now call the roll. Commissioner Camargo.
Aye.
Commissioner Roy.
No.
Commissioner Stebbins.
No.
Commissioner Concepcion votes aye. The motion does not pass. Commissioner Stebbins.
Madam Chair, I'd like to put a motion on the floor, and that is to move to designate Commissioner Concepcion as acting chair through the meeting of the Cannabis Control Commission on November 9th.
Do we have a second? I will second the motion. I'll now do a call of the roll. Okay, sorry, Commissioner Stebbins.
Sure. And again, I appreciate all of the discussion. I think as Commissioner Camargo pointed out the other day, we are definitely in I hate to call it a pickle. That doesn't seem legally correct, but we're certainly trying to manage through this. Greatly respect the work of all of my colleagues, and I hope that once our regulatory work is done, we can get back to the work of finalizing that governance charter so these questions don't come up in the future. But thank you.
Commissioner Stebbins. Commissioner Stebbins has a motion that has been seconded. I will now do a call of the roll.
I have a question. Point of inquiry.
Commissioner Roy.
Commissioner Stebbins, that's different from the language that you originally proposed, where you said open the meeting on October 12th. Can you explain what happened?
If I might, Madam Chair.
Commissioner Stebbins.
Again, I appreciated the chair's point about the regulatory process. And again, we know that those regulations need to be promulgated by November 9th. So Commissioner Roy just trying to align that date, which seems reasonable with what I feel is consistent with the motion I made on Monday and the earlier motion I just made and the motion that's on the floor. So
thank you, Commissioner Stebbins. Okay. Commissioner Stebbins has made a motion. I have seconded that motion. I will now do a call of the roll. Commissioner Camargo.
I have a point of inquiry or just a quick comment. So, and I think Commissioner Stebbins, you might have answered this right now, but I'm sort of thinking. So on our October 12th meeting, we will then open the meeting with new business and go through this whole conversation again.
Commissioner
No.
Stebbins has changed the date to November 9th.
Okay, all right, thank you. I vote aye.
Commissioner Roy.
Inquiry. What is the date of our November meeting, public meeting?
No. November 9th.
Okay,
It
so
aligns. Somehow it
It
aligns. Sorry, I'm interrupting.
and Commissioner Stebbins, so I understand your motion language. On November 9th, Chairwoman Concepcion will open the meeting and then we will entertain who will serve as acting chair from there forward. Is that what you're proposing?
I'm proposing
Until-
Go ahead. Sorry, finish your point.
Until Chair, sorry, hold on. Until Chairwoman's O'Brien, we have clarity on her status. So could you explain that a little more, please, for me? I guess I'm.
Sure. Obviously, we first of all, and again, my own opinion, we have already said publicly we're going to have a meeting on November 9th. Those regular meetings, deal with license applications, renewals, and everything else. The agenda for that November 9th meeting has not been set yet. So I think that's something for all of us to, and obviously the chair post the agenda. But, my feeling would be starting that meeting. And if we feel that we need to add another vote at that point, and maybe, the clarity around Chair O'Brien's appointment might be cleared up by then. We don't know, just trying to get us through being able to open that meeting. And obviously we could use our October meeting to decide what we might want to see on the agenda for the November 9th meeting.
Thank you, Commissioner Stebbins. Commissioner Roy.
Thank you, Commissioner Stebbins. So are you requesting it be on the meeting now for November 9th, that we will have the discussion around the chair status? Acting chair, is that
Roy? Commissioner Roy, are you asking for a point of clarity on the motion?
Yes, because I'm confused I'm confused by he mentioned the November 9th agenda, and I just want to see if Commissioner Stebbins, he's asking for it to be placed on the November 9th agenda.
I'll be honest with you, in clear, again, I want to leave space, at least for me individually as a commissioner, as to what I would want to see on the November 9th agenda. It's a little under a month and a half from now. And again, that agenda doesn't need to be posted until 2 days before that November 12th meeting. So sorry to maybe not offer you any more clarity, Commissioner Roy, but.
Okay. We have a motion on the floor. It has been seconded. I will do this again just so we are very clear. I will call the roll. Commissioner Camargo.
I just want to say, Commissioner Concepcion, I was trying to get my hand up or my mute off before to second the motion, but it's okay. So I just wanted to say that for the record. I couldn't get to my mute button fast enough, but I wanted to say aye for this motion.
Commissioner Roy.
Aye.
Commissioner Stebbins.
Aye.
The chair votes aye. We have 4 in favor, none opposed. The motion passes. Okay. I will now turn things over to Acting General Counsel Andrew Carter to introduce the final sections of host community agreements.
Thank you, Madam Chair. My colleague Mike Baker will be leading this part of the discussion. So I would like to turn it over to him if the chair is comfortable with that.
Thank you, Attorney Carter. Attorney Baker, by all means, take it away. I think we have 2 pens left for host community agreements, but please tell us where we should be in our draft.
Sure. So I believe it's under Section 180, subsection 2I, which we're currently looking at. It's titled Prohibitions.
Attorney Baker.
I believe.
I'm sorry, Attorney Baker. I will pause you for one moment because I believe Commissioner Stebbins had some language in a section that he wanted to bring at the beginning of our conversation around host community agreements. And Commissioner Stebbins, you can correct me if I'm wrong, but I believe you wanted to begin this with your proposed language.
Thank you, Chair. I know that we were kind of held up on wrapping up host community agreements and everything related to that late yesterday because of the big pin I had, but I want to make sure we're going in order of these discussions, and I think Attorney Baker, correct me if I'm wrong, the other pin is before my pin. I do have the language. To your point, Madam Chair, I wanted to make sure it was dropped in so people could look at it as soon as we started this morning. So, but I think Attorney Baker, his pin might be in front of my pin. Okay. I know that's a legalese way of saying it, but
no, that's fine. Okay, Attorney Baker, please to
sure.
The
so
first pin. Yes.
Okay, so I believe it's H here. A marijuana establishment that seeks a name change or location change pursuant to 935 CMR 500-1041. They must submit respectively a new or updated HCA in a form and manner determined by the Commission. Upon submission of a change of ownership request for the transfer of a license, an applicant may propose a name change with the application submission. If elected, an applicant must submit an amended HCA.
Commissioner Stebbins.
Sure. I think in Attorney Baker, that was the proposed language that Council Lopez dropped into the chat yesterday, if I'm not mistaken.
Do you want me to read the, or I'll let, sorry.
Enforcement, Council Lopez.
Thank you very much, Madam Chair. Yes, this is Attorney Baker is correct. This is where the conversation left off yesterday, was the name change conversation. We were just getting around to figuring out language. I have put new language into the today's chat, if you would like me to read it.
Yes, please.
Okay. The new language would read, a marijuana establishment that seeks a name change pursuant to 935 CMR 500-1041 after execution of an HCA must provide notice of the change to the host community in a form and manner determined by the Commission. A marijuana establishment that seeks a location change after execution of an HCA must provide an amended HCA to the Commission. A marijuana establishment that submits a change of ownership request for the transfer of a license may be required to submit a new or amended HCA to the Commission.
Thank you, Enforcement Council Lopez. Commissioner Stebbins?
Sure. Thank you, Chair. I think this language reads a lot better. I think, I don't know and appreciate Enforcement Council's opinion on this. The second sentence, which begins with a marijuana establishment that seeks a location change after the execution of an HCA must provide an amended HCA to the Commission. I remember talking yesterday about this location change being within that same host community. I think we all know that if they decided to pack up and move from one community to another community, that starts the process all over again in terms of that relationship with the new host community. So I want this to be clear that this is only if they move locations within the same host community would they need to execute a new HCA.
Enforcement Council Lopez.
You're saying, I think I just heard you say, Commissioner Stebbins, that you're saying that the policy intent for you is that if an ME is looking to change a location within the same host community, that would be the situation where you would want them to submit a new HCA, but not for the scenario where they are changing to another host community?
Madam Chair.
Stebbins?
if they were moving to a new host community, in my mind, that would be starting that HCA process all over again, right? You need a compliant HCA that aligns with your location. As I was looking at this, a marijuana establishment that wants to move within the same town might have to submit a location change that seeks a location change after execution. It must provide an amended HCA. That might allow the town in the ME, based on that decision to move within the same host community, the ability to go back and say, well, now you're in this part of town, we have some different requirements or different issues might arise. I just want to make sure that second sentence, and it might be as simple as saying a marijuana establishment that seeks a location change within the same host community after execution of an HCA must provide an amended HCA to the commission.
Director Potvin.
Good morning, commissioners. Thank you, Madam Chair. Commissioner Stebbins, if I'm hearing you correctly, I think it's obvious that if they move to a new municipality, obviously there's a new party to a contract, so there would be a new contract. I think in that scenario, there would be a new HCA, not so much an amended HCA, a new HCA. Right. And I think where you're trying to go from a policy point of view, from what I'm hearing, is that if they're moving within the same municipality, they're changing locations within the same municipality, the HCA may not change, but could change. So I guess as a recommendation to that point, if that is where you're going from a policy point of view, is maybe changing the language that, essentially a marijuana establishment that is seeking a change of location may be required to submit an updated HCA I guess maybe it's a two-part issue. A change of location from a marijuana establishment moving from one municipality to another municipality must submit to the commission the new HCA between the parties. A marijuana establishment moving from one location within the same municipality shall submit an updated HCA if there are any changes by the parties. If there's any changes to the HCA, otherwise they wouldn't be required to submit it if it remains the same. Something like that. I know the wordsmithing, the wordsmithing at 10:30 in the morning is not great here. I promise to improve, but giving that option with delineated between within the same municipality or different municipalities, but within the same municipality, if there is a change to the HCA, they shall include that within their submission of a change of location, something to that effect.
Director Potvin, I see first for Councilor Lopez, but Director Potvin, can you repeat it one more time so we can all just make sure we've gotten the gist of the proposed language, please?
Absolutely. Thank you, Madam Chair. So this pertains only to the part of what EC Lopez submitted in her recommendation language in the chat. So changing that one sentence referring to a change of location, but separating it out into two separate sentences. Essentially, the first sentence would be a marijuana establishment that is seeking a change of location from one municipality to another shall submit the new HCA between that new municipality and the licensee. Second sentence, a marijuana establishment seeking a change of location within the same municipality shall submit an updated HCA if any changes to the HCA occurs between the parties.
Okay, thank you. Enforcement Council Lopez.
Thank you, Madam Chair. I'm happy to provide some updated language. I just want to note for the commission that given the many permutations that can occur in the real world when it comes to kind of whether these changes are big changes or little changes or should require an amended HCA or an updated HCA, I just want to remind the commissioners that there is a waiver process where licensees can seek individual consideration of their specific circumstances if regulation would impose an undue hardship on their particular circumstances in terms of the expectations that we set here. But with that in mind, I will put together proposed language and circle back.
Commissioner Roy?
Attorney Lopez, Madam Chair, would it be prudent to add any language around the model HCA could serve as an interim while the parties are negotiating or renegotiating?
If I may respond?
Yes, please, Enforcement Counsel Lopez.
Thank you, Madam Chair. Well, the reality is that when the amended HCA is sent to the commission or when a new HCA is sent to the commission, that is going to restart our review responsibilities. So that means we'll have to review the HCA, we'll have to confirm that it's compliant, we'll have to send a determination notice, and that determination notice will now include the option for the model HCA. So I think it all links back together, but I do appreciate that very smart point.
Thank you.
Counsel Lopez. Okay. Are there any other questions, comments, or concerns? Do we have consensus on the proposed amended language? Commissioner Stebbins?
Oh, I'm comfortable with that. And again, I don't necessarily see it as a change of policy for us. I see it as just a way for us to offer some clarification in this section as to what's required of both parties and making it clear you're jumping to another host community, as Director Potvin said, that starts a whole new HCA process. If you're staying within your host community, just moving cross town, that opens the potential for another process that might be undertaken.
Enforcement Counsel Lopez.
Thank you, Madam Chair. So new language then to put before the body. A marijuana establishment that seeks a name change pursuant to 935 CMR 500-1041 after execution of an HCA must provide notice of the change to the host community in a form and manner determined by the Commission. A marijuana establishment that seeks a location change to another host community shall submit a new HCA to the Commission. A marijuana establishment that seeks a location change within the same host community after execution of an HCA must provide an amended HCA to the Commission if there are changes to the HCA. A marijuana establishment that submits a change of ownership request for the transfer of a license may be required to submit a new or amended HCA to the Commission. I will note that the new sentence seeks a location change within the same host community after execution of an HCA must provide an amended HCA to the Commission if there are changes to the HCA. Well, there's a change, there's a location change. So I don't think that quite makes sense. So maybe that's something for the body to iron out.
Right.
You could just require them to provide an amended HCA.
I'll repeat that statement. A marijuana establishment that seeks a location change within the same host community after execution of an HCA must provide an amended HCA to the Commission if there are changes to the HCA. Commissioner Stebbins?
Question for Enforcement Counsel, and to your point, Rebecca, that might be something as simple as we had to change the address in the HCA. That would require us to get a new copy. So we could almost take off that if there are changes to the HCA, because there will be, right? Address and location. So, okay.
Director Potvin?
Thank you, Madam Chair. I think Commissioner Stebbins, where you were going with within the same municipality was some type of administrative efficiency, like if in the situation where it's within the same municipality, but the HCA remains the same, there are some HCAs that don't state an address, for example. Okay. And there, in fact, there might not be there's a potentiality, there's a foreseeable situation where if somebody's business is moving within the same municipality, the HCA might not change at all. So maybe in that type of situation, requiring them to submit an amended HCA would be administratively burdensome because there's not any changes. So you're forcing them to actually change it. You want it amended. So maybe I think I still would recommend that if there's any changes to the HCA, they should submit it. If there's not, maybe they could just attest to the fact that the HCA that they have is still in full force and effect and hasn't changed. Just thinking of the different permutations.
Enforcement Counsel Lopez.
Thank you, Madam Chair. I'm going to respectfully disagree with the Director of Licensing on this point. I think the language, if there are changes, will cause confusion. If a licensee is in a situation where the HCA does not include information about the location, they can submit a waiver seeking exemption from this requirement.
Enforcement Counsel Lopez. Do you have any proposed language?
I would agree with Commissioner Stebbins in removing the last clause if there are changes to the HCA.
Okay, so then that would read, a marijuana establishment that seeks a location change within the same host community after an HCA must provide an amended HCA to the commission, period. That is the new proposed language. Commissioner Stebbins, is that correct? Is that what you are suggesting?
I'm comfortable with that language again, and it might speak to Director Potvin's point that if anything changes in the HCA, you got to give us a copy of it. If nothing changes in the HCA, and HCAs, it sounds like, are different depending on the community, that I don't want to be the last one to impose an unnecessary administrative burden, but I think this language covers it.
Enforcement Counsel Lopez.
Just thinking of a bridge between my cherished colleagues' suggestion and the suggestion that I put forth, we could say a marijuana establishment that seeks a location change within the same host community after execution of an HCA may be required to provide an amended HCA to the commission, and that could cover the scenario that that the Director of Licensing has identified, which, you know, I want the commission to certainly have the benefit of his expertise, having seen a lot of these HCAs.
Thank you, Enforcement Counsel Lopez. I actually agree with that language. I see Commissioner Stebbins nodding, so I believe he agrees as well. Commissioner Camargo and Commissioner Roy, are you also in agreement with the proposed language? Okay, all right, so we have consensus. Thank you, Enforcement Counsel Lopez. Attorney Baker, we have reached consensus on this item. Can you move to the next item that we put a pin in, please?
I believe Commissioner Stebbins, do you have another issue within HCAs you would like to revisit?
Commissioner Stebbins.
Madam Chair, thank you. Yeah, and then hopefully we can wrap this section up and move on. This is under the section of commission review of community impact fees. Again, I have it in the hard copy version of page 75, where above waiver of host community agreements is the section that's making the authority for the commission to make a final determination on community impact fees. My hope and intention of some of the language that we started to discuss yesterday was around how do we reward good relationships? How do we reward good behavior? How do we avoid a unnecessary regulatory process for communities that no longer assess a community impact fee?
Commissioner Stebbins.
Yes.
I'm just going to pause you just so I can
Sure.
just ensure that everyone is on the right page. So in the hard copy, it's 74. I believe we're at C3, correct? C3,
No.
The commission may make a final determination.
Yeah, it's under that, but where I'm suggesting we add additional languages on the next page, page 75, adding a number 7, a new subsection 7.
Got
It would
it.
be
Okay, I just want to make sure we're
just-
following.
Thank you. Just above that waiver of a host community agreement.
Okay, please continue. Sorry to interrupt. Go ahead.
No, and I want to thank Acting General Counsel Carter and Enforcement Counsel Lopez for the language, which you see Grace actually dropped into the chat, which reads as follows: a host community and a marijuana establishment may be exempt from the CIF review and certification process set forth in 935 CMR 500.1804C if there is no dispute between the parties regarding the claimed CIF, and provided that the amount of claimed CIF otherwise complies with Mass General Law 94G Section 3D. The parties shall attest to their mutual agreement of a claimed CIF in a form and manner determined by the Commission. Again, I think this language, they could still, keeping in mind the interest in maybe seeing what claimed impact fees are or costs or the invoices, but this kind of takes us out of the role of arbiter where it's not needed. And again, it would be nice to have the regs reward that good behavior and that good relationship between a marijuana establishment and a host community. And I think this language speaks to that.
Thank you, Commissioner Stebbins. If we were in the room, I would look at 94G Section 3D. So I will just ask if this aligns with our reasonableness standards that we will have here at the Cannabis Control Commission. And maybe I direct that to either EC Lopez or, I'm sorry, Commissioner Stebbins, you were assisted by whom? Was it Acting General Counsel Carter?
Enforcement Counsel Lopez and Acting General Counsel Carter and I had a meeting after our meeting adjourned yesterday to rework some of the language I had proposed. And this is what their brilliant legal minds came up with.
Thank you, thank you, thank you. Okay, so either attorney, so EC Lopez or Acting General Counsel Carter, I just want to confirm the citation. So 94G Section 3D speaks to what?
Thank you, Madam Chair. I'm happy to take this one. 94G Section 3 is in general the section on local control. Subsection D is the subsection that covers the legislature's expectation that the parties will negotiate and execute a host community agreement and the host community's ability to include a community impact fee and all of the different required components of what that community impact fee may or may not be. So that's the reason why I suggested a general reference to that section.
Okay, thank you. Commissioner Roy?
Well, thank you, Madam Chair. I just have a question on, we're statutorily mandated to review, certify, and approve the HCAs, which stipulate all responsibilities. Without the ability to assess, the standard for reasonably related, and number 2, that the impacts are based on per statute on actual costs. How are we doing our due diligence?
Commissioner Roy, is that directed to Commissioner Stebbins?
No, EC Lopez.
Oh, okay, EC Lopez?
Thank you.
Thank you, Madam Chair. Commissioner Roy, would you mind restating the question?
Of course. So based on statute that the commission is to review, certify, and approve host community agreements, and all responsibilities and stipulations shall be in said host community agreement. And if we are creating a pathway where we are not able to assess all stipulations and responsibilities, including community impact fees for the reasonably related standard and per statute that they are based on actual costs, if we are unable to ascertain that, how are we doing our due diligence?
Thank you very much, Commissioner Roy, for the question. So this is part a legal question and a policy question. I can certainly respond to the legal piece of this. So the legislature, as you correctly point out, has required the commission to be involved in the review of every host community agreement, including the terms and responsibilities identified within that host community agreement. The CIF review is a separate review process that we certainly have the power to. The legislature has granted the commission the power to review, certify, and approve community impact fees. The legislature did not necessarily bind the commission or mandate that the commission review each and every community impact fee in the same manner that it did with the host community agreement process. So legally, there is space for the commission to explore the policy option that Commissioner Stebbins has put forth. But in terms of whether or not that would accomplish the goals of the legislature or this body, that is the policy conversation that I defer to the judgment of the board on.
Thank you, E.C. Lopez. Commissioner Roy?
Thank you, Madam Chair, and thank you, E.C. Lopez. And so just to follow up, if an amendment is sent and the commission is unable to, therefore the commission will be unable to ascertain if said community impact fees that are mutually agreed upon are reasonably related and number two, are based on actual costs. The commission will be unable to ascertain that. E.C. Lopez.
E.C. Lopez?
In terms of the policy proposal that Commissioner Stebbins is putting forth?
If yes, based on the language that they would just send in a form saying we mutually agree. I guess my question is at that point, is the commission unable to ascertain if they are reasonably related and they are based on actual costs?
So I certainly defer to Commissioner Stebbins to speak on his policy proposal in terms of whether or not the commission would retain its authority to review the CIFs.
Commissioner Stebbins?
Thank you, Chair. Just give me a moment. I'm thinking through Commissioner Roy's question. And it might help maybe if I give you, again, my kind of overall approach to this. Might involve just kind of stepping back for a minute. I think all of us appreciate that Chapter 180, after years of lobbying, years of getting the bill, to the table and finally enacted, that it was meant to address what I think we've all heard is question of treatment under the original statute, and for a community to collect monies that I think Commissioner Concepcion, you raised the language again yesterday of the original statute and what the requirement was for a host community. Chapter 180 gives us a lot more clarity into that, and I think was really designed, at least from my perspective, to provide some teeth and provide a process for both the host community and for a marijuana establishment to have the commission play a role in what I think is arbitrating that question of, is this an allowable cost? Is this a cost that I need to pay? Is this a cost that's directly impacting the community in which I'm operating in? And I think we've, through a lot of good work of your working group, we've created that structure and that format to allow those cases. And obviously, I think all four of us hope that this isn't the case all the time, that if there is an agreement, what's the process? And it's up to us, and I would envision it. And again, we've not seen a request come across our table to challenge a cost being claimed by a host community, but at the same time to think through the burden this might put on municipalities and communities, and on the commission as the regulatory body, that if there is agreement, I have no problem as a marijuana establishment. I think these costs are reasonable. I'm making that judgment somewhat in my own defense. in my own case or my own situation based on where I'm located, based on the relationship I have with the host community in which I'm operating in, I don't see any reason for the commission to then have to review and go through a certification process if the two parties to that agreement already are in agreement. Benefits for the marijuana establishment, they still have the avenue, they still have the opportunity to challenge those costs, and that's where we become an arbiter. Benefit for the municipality is they get paid faster if anything isn't going through an arbitration process or a review process, and it may hold host communities to being more definitive in assessing their claimed impacts in the invoice that they transmit to a marijuana establishment. So I just see this as a way, and I think I know, the root of your question, Commissioner Roy, is that taking us out of a role to establish that definition of reasonable fairness. But I think there's reasonable fairness in this, that if two parties are agreeing and they want to pay an invoice for their impacts on the community, they should have the right to do that without going through the next step. So I apologize. It's kind of a long-winded answer to your question, but I thought the background to the question might be helpful.
Commissioner Roy.
Thank you, Madam Chair. I guess my fear is someone with more resources, an MSO, would have the ability, let's say, to buy a community 5 ambulances, where a smaller, maybe equity licensee does not necessarily have that ability. And I feel that makes it a little uneven. If we restrict our oversight, what this does is restrict our ability to have oversight over the reasonable relatedness standard in the actual costs. So my fear is that an unintended consequence might unlevel the playing field, if you will. And your general concept is great, and I understand what you're saying. But my fear is it can undo the protections that were put in place by Chapter 180 if we are unable to ascertain reasonably relatedness and actual costs.
Thank you, Commissioner Roy. Commissioner Stebbins?
Sure. And Commissioner Roy, I certainly appreciate you bringing up the point, because I think as all four of us have traveled around the Commonwealth and talked to the industry, there is that, you bring up a great point, which is that potential unlevel or uneven playing field when it comes to MSOs and what they're able to do. I look at this as building in a safeguard for both players, both an MSO and a smaller player. Nothing in here, nothing in the motion I'm suggesting or the additional language I'm suggesting takes away any opportunity for a smaller operator. And, often we hear those smaller operators referred to as folks without those deep pockets. I don't think this takes away any ability of them to challenge a cost being imposed upon them. If they see something in an invoice they don't like, buck it up to us to be, to be certified. If they look at it and they have a great relationship with their host community and their host municipality, I want them to be able to continue that relationship. And again, I think these are regulations that actually reward good behavior and a good relationship, and don't unnecessarily burden the commission with seeing something that nobody's asking us to do anything about.
Commissioner Stebbins, would you mind, because we had a lot of conversation yesterday, so can you refresh us about the benefits of this proposed change? So do you mind, I know you spoke to it yesterday, do you mind just,
Sure.
Just giving us a brief summary of the rationale behind it?
Sure. And if you'll permit me, Chair, I'll do that in a couple different ways. First of all, thinking through the rest of the process that we've incorporated in the regs, and Director Potvin or Enforcement Counsel Lopez, correct me anywhere along the line if I misstate something. There's a timeline for a host community to submit an invoice to a marijuana establishment for impacts that they are claiming they've realized over the previous year of operation. The host community can look at that. They forward it on to us. There is some level of review that we would do to either certify the cost as reasonable or make a determination that they are not unreasonable, and we submit that decision back. If that invoice is reviewed by, and we're going to see a lot of these, if that invoice is reviewed by a marijuana establishment and they're like, these are all reasonable to us, I think that may also help, as I'm thinking about it, make that determination of reasonableness. I look at these costs, I agree with them, I want to have a good relationship with my host community. I'm still afforded every other right to challenge it, but to expedite the process, to expedite my ability to keep moving forward in my operation of my establishment, I feel that these are reasonable. I'm going to pay them, and I'm going to tell the commission I paid them, but there's no further role for the commission to take. And I'm not asking the commission to take any further action. And again, just final stipulation. I want to see the regs reward the behavior that we want to see. I want to see the regs reward good relationships that might already exist out there between host communities. And again, host communities who don't offer a community impact fee. So this is another way of hopefully drawing some clarity that somebody who sends a marijuana establishment an invoice with $0 then doesn't have to go through the administrative process of sending it to us and saying, $0, there's nothing for you to certify here.
Thank you, Commissioner Stebbins. And Enforcement Counsel Lopez and Director Poppin, I'll direct my question to both of you because you were both in the working group. Is there anything contained within our regulations as currently drafted that would prevent a operator from remitting payment prior to our review? Enforcement Counsel Lopez?
No, I don't believe there is, and Director Poppin, please correct me if I'm wrong, but I don't believe that there is anything that prevents the operator from paying the community impact fee and not disputing the community impact fee. The idea is that we review the community impact fee, we identify if it's reasonably related or not, and then the licensee has options. They can dispute the fee or they can pay the fee. Two enforceability aspects that I want to raise again, since the conversation is coming back around and the in-depth policy conversation is happening, are the points that I raised, I believe, yesterday or the day before. My memory's a little blurry, but the enforceability, just some enforceability considerations that the board should be mindful of as they continue this policy conversation is that by relinquishing our oversight and determination of some CIFs, but not all, that will result in a lack of uniformity in how that standard of reasonable relatedness is actually being enforced. So there will be differing standards between, something that we have said is just categorically not related versus what the parties have agreed to on this side as just, accepting it as being reasonably related. So there's a lack of uniformity that could result from that. And then additionally, in a situation where we receive the invoice and we receive the invoice where the operator and the host community have agreed, no, there's no dispute, but if we receive an invoice and see that there is an improper assessment of a CIF that is not reasonably related, at that point, the parties will have already submitted an attestation, so it may tie the commission's hands in terms of being able to take any action there to enforce the reasonable related requirement. So that would be something that, as you explore this policy, if you go in this direction, you will be making a policy choice to relinquish that enforcement and that oversight ability, and accepting that there will likely be a lack of uniformity in terms of what reasonably related means or how it's applied, depending on which licensee you are and which host community you're in, and how good of, even for licensees in the same host community, one might have a better relationship with the host community or feel less comfortable disagreeing with the host community than another licensee in that same host community. So it could lead to some disparate standards.
Thank you, Enforcement Counsel Lopez. Thank you for repeating those comments as well, because that's what stayed in my head. My fear is that we're creating sort of an avenue where it's a way to circumvent our reasonableness standards. And the reason why I asked about payment, if payment can be received, remitted prior to our review process, because Commissioner Stebbins, I hear what you're saying in terms of creating sort of an expedited process so that there's not that, a period of waiting for us to make a determination. And if I'm hearing Enforcement Counsel correctly, this doesn't prevent an expedited process to happen between that host community and the licensee. Commissioner Roy.
Thank you, Madam Chair. My question is for EC Lopez. In your best estimation, once the new regulations are promulgated and upon review starting after March 1st, if the commission identifies CIFs that are not in alignment with statute and regulation, and after submitting a determination notice, if there is still an issue, would the commission at that point issue a notice of deficiency?
Thank you for the question, Commissioner. I believe that we have a review process that is laid out and pretty detailed already in the regulations, which states that once we make a determination, sorry, let me just dig that back up. So we provide notice of the CIF determination to a marijuana establishment and a host community. The notice will provide the marijuana establishment with the following options. They can request an administrative hearing before an independent hearing officer to challenge our determination. Let's say that we agree with the host community that it's reasonably related. They would be able to challenge that, and the host community can seek intervention to be a part of that challenge. The licensee can always seek court intervention as well if they would like to seek independent review of the impact fees. And the licensee can also opt to pay. So those are the options available to the licensee.
Thank you, Lopez. Commissioner Roy.
Thank you, Madam Chair. So a follow-up to that would be, it is plausible that we could issue a determination letter for a CIF that we find non-compliant, but that same CIF could be put through because we wouldn't see it in the waiver or amendment or attestation. I'm sorry. So isn't that arbitrary and capricious if we would issue a notice of deficiency or a determination letter saying something is not in compliance, but that same CIF technically could get through based on this attestation?
Enforcement Counsel Lopez.
Thank you, Madam Chair. So Commissioner Roy, what Commissioner Stebbins is proposing is the option for the parties to be exempt from the review process altogether. So through that exemption, the commission would not be making a determination at all on that particular CIF. So the commission would not be as much at risk of a challenge of being arbitrary and capricious, because we're not making the judgment call on whether or not that CIF is reasonably related. That's something that we're leaving to the parties to decide among themselves. So I think there's not as much of a risk of us being challenged in that way, because they're not different decisions that we are making. However, to your point, the there's a high risk that it could open the door for disparate standards in what is or is not reasonably related, which could lead to an arbitrary outcome for the licensee who seeks CIF review through the commission versus the licensee that does not.
Thank you, Enforcement Counsel Lopez. Commissioner Roy, I see that you have language in the chat. Before we get to the language, I'll just state, Commissioner Stebbins, because of the reasons that Enforcement Counsel Lopez has stated, I believe the originally proposed language should remain, but I will pause there. I will let Commissioner Roy discuss the language that she has as well. So Commissioner Roy.
Thank you, Madam Chair, and I agree with you. I support keeping the original language as is, but if this body saw or so inclined to adopt Commissioner Stebbins' language, I would propose the following friendly amendment to that language. But if there isn't consensus to adopt Commissioner Stebbins' language, then I will withdraw that.
Did you want to state the? Oh, sorry. Commissioner Stebbins, maybe you can give it up.
No,
Commissioner Stebbins.
No, finish your question there, Commissioner Roy.
Okay, Commissioner Roy, would you mind stating the language that?
Of course, I don't mind. So, should I read Commissioner Stebbins? So so for context, we have the whole in its entirety. Yes. You think that's more appropriate? Okay. Okay, so this is the one from Grace, right? I just want to make sure I'm reading the correct one. Okay, yes. A host community and a marijuana establishment may be exempt from the CIF review and certification process set forth in 935 CMR 500-184C if there is no dispute between the parties regarding the claimed CIF, and provided that the amount of a claimed CIF otherwise complies with Massachusetts General Law, Chapter 94G, Section 3D. The parties shall attest to their mutual agreement of a claimed CIF in a form and manner determined by the Commission. My language. The Commission shall reserve the right to request, review, and approve all community impact fees for a reasonably related standard, including but not limited to that all community impact fees are based on actual costs.
Thank you, Commissioner Roy. First, Commissioner Stebbins, did you have a comment? Now, I see Director Poppin as well. Did you want Director Poppin to speak first, or do you want to offer your comments?
If you don't mind, let me, this question, and again, I think we're narrowing it down to this reasonably related, and I just want to go back to, I think a point Enforcement Counsel was making of part of our review will help determine, again, any contested claims or contested invoices that come to us. We're making that determination on what's in front of us as to whether it's reasonably related. If I heard you correctly, if a host community and a marijuana establishment don't contest their costs, there is agreement, marijuana establishment writes the check, pays for the services or pays for whatever impacts that they both agree they've had on the community, you're suggesting that is essentially establishing another reasonableness standard. I'm trying to think of where that might cause. I mean, we're arbitering a question or a challenge. We're implying our own reasonable standard. The reasonable standard for me gets changed if there's agreement. I'm trying to understand Enforcement Counsel and help me out. Parties agreeing establishes a reasonable standard. We're only creating a reasonableness standard as it relates to those invoices or those claimed impacts that is being challenged. So that's where I'm trying to understand where these two might be in conflict in some other type of legal case or legal challenges. It's kind of the question I'm getting at.
Director Poppin.
Thank you, Madam Chair, and Commissioner Stebbins. I think you you were just getting to my point. I see conflict between these two provisions. I see them directly conflicting with each other, at least initially reacting to this language. And I think the policy objective of where you were trying to go is, are we going to review these based on established policies and procedures? Or are we going to, or are we going to have an exempt situation where the parties agree? The proposed language that Commissioner Roy brought up is that the commission reserves the right to review these for reasonably related. I think negates your policy objective with what you were proposing, and also reserves the right, to me, will essentially still require us as staff to review every single community impact statement and invoice. Because reserves the right, initially that review is going to happen with staff, and therefore it almost is a presumption that we are still mandated to review every single one of them for reasonably related. So I think starting with whatever the policy objective is and the body wants to vote on ultimately is up to you. Is there going to be an exempt nature for a population that are agreeing to this, or is there not? But these two provisions together, I think, negates what you are trying, what you're proposing, Commissioner, at least from my perspective.
I agree, Director Potvin. Commissioner Stebbins?
I don't know if Enforcement Counsel Lopez wants to respond to that, but I'm happy to, Madam Chair, to move this along. I'll propose the new language. If there's a decision to adopt it, we can choose to adopt it or not. But and I know Commissioner Roy has her hand up as well.
Commissioner Roy?
Thank you, Madam Chair and Director Potvin. So part of the unintended consequence would be the commission is ceding its right and authority to via attestation by the two parties to have the right of oversight and authority over these. We will no longer have the right of oversight and authority via attestation of a mutual agreement between two parties.
Commissioner Roy, are you, is that a statement or a question?
Question, I guess,
Okay.
to Director Potvin.
Director Potvin?
Thank you, Madam Chair. I think just Enforcement Counsel Lopez, please correct me if I'm getting this wrong. The authority to review community impact fees is established in Chapter 180. The commission is not mandated to review community impact fees, which is separate and distinct from the actual host community agreement, which is mandated. In the proposal that I'm hearing from Commissioner Stebbins, if the parties are agreeing to the invoice amount, the community impact fee amount for a given year, and they are representing that to the commission that they agree, and there's a mutual agreement between the parties, the commission and staff would not review that based on the criteria in the law and the criteria and regulations for those particular invoices. So essentially, it's not that
Kyle, you muted for a second.
Oh, can you hear me now?
Yes, I heard it's not that, and then.
So I think, Commissioner Roy, the language that you're using is essentially, and please correct me if I'm wrong, and I'm sorry if I'm misrepresenting this, is we're giving up the authority, or we're giving up the commission's authority to review and approve and certify that community impact fee. I would rephrase it a little bit, and is we're not exercising our ability to certify it based on this policy if Commissioner Stebbins' recommendation is adopted as policy. We are as a policy, we would not be reviewing it.
Thank you, Director Potvin. I saw Commissioner Stebbins. I saw your hand up a moment ago. Did you still have your hand? Okay.
Yeah, I do want to make a point, but I don't know if Enforcement Counsel wants to respond to Director Potvin.
Enforcement Counsel Lopez.
I have no response to Director Potvin. I mean, I understand the way he's looking at it.
Okay, pause right
They're
there.
different.
Okay.
Oh.
Just because I'll go
sorry.
to Commissioner Roy and then I'll come back to you, Enforcement Counsel Lopez, just because I think that Commissioner Roy, you have a response to Director Potvin.
Yes,
Go ahead,
yes and
Commissioner
no.
Roy.
Thank you, Madam Chair. And thank you, Director Potvin. I think my question is more at EC Lopez, so if she can restate when I said would the rulings be arbitrary and capricious by the commission if we're issuing determinations on they could be the exact same community impact fee, and we're issuing notices of determination that run afoul of compliance for some and not for others, and they may have the exact same CIF. And then EC Lopez said, no, not necessarily on our ruling, but something could be vulnerable or open to questioning. Could you just repeat that part of it? And does that mean the commission is vulnerable in any way?
That's a good question. EC Lopez?
Thank you very much, Commissioner Roy, for that question. I would need more time to consider that, to be very honest with you, because essentially we're not the ones who are making the ruling and the determination that's leading to disparate standards or an arbitrary, capricious outcome, because we're not looking at the two licensees and making a different call so that the same expense is reasonably related for one, but not the other. So in that sense, my initial instinct is that the risk of us being challenged as having made an adverse decision or bringing in making an adverse action that is arbitrary and capricious seems low, because we are not making the decision in one case at all. However, as a matter of policy, it could lead to arbitrary and capricious outcomes for licensees if we adopt a policy of abstaining from oversight in one circumstance while holding on to oversight in another. Whether or not that could still expose us to legal challenge, and in other words, whether a public policy decision made by this commission that has the risk of leading to disparate outcomes that could be arbitrary and capricious could expose the agency to legal challenge is something that I would have to look into, but I raised the enforceability complications for this body to consider as they're making their policy decisions.
Thank you, EC Counsel. EC Lopez, did you also have an additional statement aside from responding from Commissioner Roy?
Well, yes, thank you, Madam Chair. Commissioner Stebbins had mentioned earlier, he had asked a question about if a licensee pays before the community impact fee invoice gets to the commission, is that not also introducing this, opening the door to another kind of potentially reasonably related standard based on the licensee paying? So that's a very fair point, and I thank you, Commissioner Stebbins, for raising it. There is the 30-day window between when a licensee gets the community impact fee from the host community and when the licensee has to share that invoice with us. As a working group, we did not discuss or consider or really contemplate a licensee paying during that 30-day window and what that would or would not do or mean for purposes of the review process. So that's something that is still an unexplored policy area in terms of where the commission wants to, if the commission wants to make a policy statement on that or not. Can the licensee pay? Can the licensee not pay in that 30-day window before the matter comes before the commission for an assessment and review of the community impact fee?
And Enforcement Counsel Lopez, what impact would that have for our operations here? And I mean, we would still review, we would still evaluate.
That's true. Yeah, we wouldn't. I think the difference between if the licensee were to pay within that 30-day window, we would still, under our process, still be looking at the impact fee, and we would still have the ability to issue a determination notice stating whether the impact fee is or is not reasonably related. So we wouldn't be giving that, relinquishing that oversight ability to make that call, which differs from the idea of an attestation where the parties do agree to the CIF and remove the CIF from commission review altogether. So thank you, Madam Chair. You raise a good point, and that's all I have to say.
Thank you, Commissioner Roy.
Thank you, Madam Chair. I have a couple of questions for EC Lopez. Would this run afoul then, or would it no longer be required for a licensee to transmit their community impact invoice to us 30 days after receipt? And per statute, Chapter 180, these are public records. So therefore, there does in some shape, form, or manner need to be an impact invoice, which the public will and should have access to. Therefore, it would show to the public as well that there's disparate treatment, and would that lend us to open up, make us vulnerable legally, or any challenges based on all of these, regardless of an attestation, is a public record, the impact invoice.
May I respond, Madam Chair?
Yes, EC Council Lopez, please. EC Council, I keep saying that. EC Lopez, please.
We can make it ECC. So Commissioner Roy, the proposal being made by Commissioner Stebbins is exempting, is limited to the review and certification process. It states that a host community and a marijuana establishment may be exempt from the CIF review and certification process set forth in 50184C. It does not seek exemption from the requirement that that information be transmitted either from the licensee to the marijuana establishment or from the marijuana establishment to the commission, which is set forth in 50184A.
Commissioner Roy?
Thank you for that answer. And I guess I'll just express my concern that I have reservations about our licensees having there be arbitrary and capricious outcomes. And that is my concern here. And disparate treatment is my concern. So this is where all of my questions are coming from.
Thank you, Commissioner Roy. I share your concerns. I think I'm in the same place we were thinking. Commissioner Stebbins?
Thank you, Chair, and I want to thank my colleagues for the good discussion. I do want to point out that whether we agree with the language I'm proposing at the end of the CIF review, we do make it available. We do make the option available in some of the previous regs that a community can still pay an impact fee while it might be contesting another impact fee. So are we going to then have to weigh in?
Commissioner Stebbins,
Sure.
Can you repeat that again? I want to make
Sure.
sure we're go ahead.
Sure. And I might get some legal help to find this. When under the allowances for a marijuana establishment to challenge an impact fee, and while that is still up for review and a final decision, we do allow them to go ahead and pay an impact fee that they don't disagree with. So now to look at an invoice, would the commission be in the position of, one, we're going to make a decision on the contested impact fee? Are we then saying we have authority to look at what right now in the other section we're allowing them to pay and judging that for a reasonableness standard? And maybe I can get some help in figuring out where that actually is in the regs section ahead of this. But
my interpretation of our regs as currently drafted is that we review every fee regardless on if it's if there's an assertion by either party about whether or not it's in compliance. We're making a determination on every item. And I'll look to Enforcement Council to add some clarity, just to, if there are any additional comments.
Madam Chair, I have no additional comments. That is correct. The current regulatory framework is that the invoices come to the commission makes a compliance determination and then provides notice of that determination to the parties.
And that is just across the board. Commissioner Stebbins?
And just for clarity, so that would be, again, a part of the invoice they want to contest, as
Everything.
well as we're going to make some determination on what they might have already paid. What if those become in conflict?
What if, so you're saying that a licensee has paid a fee that we deem unreasonable? Is that the scenario you're proposing? And you're saying what then happens?
What, so again, and I wish I can quickly find the section. I'm a host community, I get that. Or I'm the marijuana establishment, I get the host community's invoice. Item A, I don't want to pay for. So I'm going to contest that. I'm going to submit that and ask for some type of certification ruling from the commission. There's a second charge that, for whatever reason, marijuana establishment agrees to pay. Are we suggesting that whatever they ask us for, they're only asking for a decision of ours on what they're contesting? Or are we saying now that we have the authority to go in that case and contest what they might have paid?
We have the authority to make a determination on the entire package of fees.
So why we then why are we allowing that option for them to pay anyways at a time? I'm thinking about this through an operational process. But Director Poppin, I'm
Director
sorry,
Poppin,
I can't
yes.
call him.
Director Poppin, yeah.
Thank you, Madam Chair. Thank you, Commissioner Stebbins. That is a possibility where a licensee already has paid, say, let's use numbers for an example. The host community sends an invoice that's $10,000, and they pay the $10,000, and then they send the invoice into us, and we find, oh, we're only certifying $7,500. What happens in that situation where they've already paid that money? That is a dispute now that might have to be litigated. We're only in the business of certifying based on the authority granted to us. And if they want some type of reimbursement, that's a conversation between them and the municipality and possibly litigation. But I think in that scenario, though, based on these new policies, it might be something that's worthy of putting in a guidance document as kind of a cautionary tale or an advisement that the commission is now in the business of certifying these amounts. You should probably wait until the commission has in fact certified the amount and pay the amount that the commission has certified. So that's it. So licensees don't find themselves in that situation. So there could be some communication through guidance documents to advise them on the proper way of going about that. But there is still a real possibility that situation would happen. But in that situation, I think it's likely that either the municipality reimburses them at their own volition, or that it has to get litigated.
Thank you, Director Poppin. Commissioner Stebbins, do you have any additional questions?
If you'll just permit me, I'm trying to find that other section that I'm referring to.
Madam Chair,
Yes, Commissioner Roy.
may this be a good opportunity to take a 5-minute recess, and that way Commissioner Stebbins could look that up? And
Would you like to make a motion?
I do. I make a motion to recess.
Okay, we'll recess until 11:31. We'll do 5 minutes.
That's fine.
So
I'll
Much
second
appreciated.
that. I'll second that motion. Thanks, Commissioner
Okay.
Roy.
Thank you.
Aye.
Motion by Roy, second by Stebbins. Do I have an aye from Camargo?
Aye.
Commissioner Camargo, Commissioner Roy,
Aye.
Commissioner Stebbins? The chair votes
Aye.
aye. We are recessed until 11:31.
Thank you.
I see Commissioner Roy, Commissioner Camargo, Commissioner Stebbins. Okay, we are back. All right, perfect. 11:36. Okay. Now, Commissioner Stebbins, did you want to offer any additional comments?
I would, and
Okay.
and again, appreciate my colleagues' patience with this and the good discussion around it. And certainly hear concerns, thoughts that everybody has with respect to the language I want to include. I'm just mindful, even if I do not submit that language, I'm still just trying to verify that we don't have that piece that I was mentioning that could create the uncertainty for both our host communities and our municipalities and for the commission, but still not have any luck finding it. But if I can find it, I want to make sure that that's not putting us at risk or putting this process at risk either. Again, whether I offer the new language I'm suggesting. But I might give Enforcement Counsel Lopez a chance to do her legal magic and see if she might be able to find it.
Enforcement Counsel Lopez.
Commissioner, thank you, Madam Chair. Commissioner Stebbins, are you referring to the provision that says that this subdivision shall not be construed to require a marijuana establishment to pay a CIF if a marijuana establishment's payment obligation is the subject of a non-frivolous legal dispute, either before the commission or a court of competent jurisdiction? Is that the provision?
I think it is. Can you point out where that is in the regs?
That's so in our hard book, it's 73, page 73, and that's for a new subsection 8, old subsection 7. It begins a marijuana establishment that has agreed to pay a CIF under its HCA.
Okay, and I think we made some changes to that because of the changes in language that were recommended by Oh, sorry.
No, I'm agreeing with you, Commissioner Stebbins.
Okay, sorry. Yeah, that section, a marijuana establishment that is agreed to pay a CIF under its HCA shall annually pay any undisputed CIF, and again, we've had some change in language there. This subdivision shall not be construed to require a marijuana establishment to pay a CIF if a marijuana establishment's payment obligation is the subject of a non-frivolous legal dispute either before us or a court of competent jurisdiction. Again, I appreciate the thoughts and feedback on the language I want to propose, but through this discussion now I want us to go back and look at this piece, because I think we're creating the same kind of legal entanglement of I want to pay this part, but I'm going to have the commission again be an arbiter on this part, and wondering where that puts us at a commission. That are we going to continue to review that which is contested, or would we be required to not only review what's contested or needs to be certified, but then we're going to insert ourselves into a position of ruling on something that two parties have already agreed upon. So that's creating a little bit of discussion for me, at least. My concern about keeping that provision in.
Commissioner Stebbins, you're saying that payment is agreement. That's what you're saying. You're saying that I want to make sure I'm following you correctly. I can.
Well, sure, and I think this gets back to the point that Commissioner Roy, I think appropriately raised, which is this reasonableness standard. And I hear her when it comes to suggesting that if both parties agree on the cost and they're going to attest to it, does that impact our ability to establish that reasonableness standard? But here we're allowing for, or we're suggesting a marijuana establishment, again, can pay any part of the community impact invoice that they get. And they can still do that, even though there might be parts that they're contesting before the commission. And I want to make sure that we're not, again, inserting ourselves as an arbiter beyond a contested part, and whether we're stretching our authority to have an obligation to weigh in on the part that isn't contested, and in this case, has already been paid.
Enforcement Counsel Lopez.
Thank you, Madam Chair. I believe that the way that this is designed, so 4A is speaking to general requirements. So that subsection is stating that in general, the ME that has agreed to pay a CIF must pay it within a certain time frame. And that if they dispute it, then they have the opportunity to see that dispute through before they have to pay. Now, there's a difference between, and we discussed this as a working group, a claimed CIF means a CIF that is being alleged by the host community, but has not yet been certified by the commission to actually be a CIF. So this subsection is speaking to a marijuana establishment that has agreed to pay a CIF, having been certified by the commission as a CIF. Then once we make that determination and have certified the CIF, this is when they have to pay it. So the process, the review process comes first. The certification of the CIF, you have the claimed community impact fee, the commission's review, and then the commission makes a determination and can certify the claimed CIF in part or in whole. And then whatever has been certified by the commission, that is when the marijuana establishment's payment obligation kicks in, because it's been certified by the commission to be reasonably related to the costs imposed on the host community by the marijuana establishment. For the part of the claimed CIF that has not been certified by the commission as reasonably related, the licensee has the option to dispute that further. Does that answer your question, or
Commissioner Stebbins?
Yeah, and thank you, Enforcement Counsel. I'm reading, as I'm looking above that in the general requirements, though, it's talking about transmission, it's talking about receipt, it's talking about the sunshine requirements, talking about how a host community transmits the invoice. It's talking about the responsibility of the marijuana establishment to send it to us. But is there sufficient safeguards that this still comes, this last step, 7, comes after our review and certification? That seems to me to be a little unclear.
Enforcement Counsel Lopez.
Thank you, Madam Chair. So in this section, we did intentionally use the language of claimed CIF to speak to something that the host community is claiming, but that has not been reviewed and certified by the commission yet. And so if you could see subsection 2, it says on certification. So subsection 1, 4A1 says to qualify as a CIF, an impact fee claimed by a host community must be reasonably related. Okay. Subsection 2, on certification by the commission, a CIF becomes properly due and payable unless disputed by a marijuana establishment. And then what follows from there is that process of transmitting the invoice and then the invoice making its way to the commission. And throughout, and that phase of the process, it's still a claimed CIF, and that language is incorporated throughout the regulations because the invoice itself is only an invoice of a claimed CIF. Once we get to subsection A, claimed is no longer there, it's the CIF. But if, you know, I defer to the body in terms of whether or not additional language is desirable to hit that point home a little more.
Thank you, C. Lopez. Commissioner Stebbins.
Thank you, Chair. And thank you, Enforcement Counsel Lopez. So our understanding and our reading of 7 is post-review, marijuana establishment has agreed to pay a CIF to its host community. That's all kind of post-review. That's part of the reasonableness assessment we're making of all of it. We are actually giving them the go-ahead to make that payment, even though they still might be contesting part of the payment. Just thinking process-wise, it's not clear to me.
E.C. Lopez.
So subsection 8, old 7, new 8. It is a post-review scenario. So this is after review has happened. But when we conduct our review and issue the CIF determination, again, we could issue a CIF certification, certify a CIF that the licensee still disagrees with. And the licensee can pursue that disagreement through the administrative hearing process or through the courts. So that's why the dispute piece is baked into this, that there may be a scenario where we have issued a certification saying that some of the CIF or the claimed CIF is not in fact reasonably related. The licensee may agree with that. They may not, but there's also the scenario where we say that the host community did properly assess a claimed CIF. And in that situation, the licensee may still want to dispute that. And they would be able to under this process.
Commissioner Stebbins.
Sure, and I apologize. I appreciate the patience of my colleagues, and I'll try to wrap this up. And thank you for that explanation, Council Lopez. Just again, more for semantics, but clarity. At the end of the new subsection 8, should we make it clear that to pay a CIF, if a marijuana establishment's payment obligation is the subject of a non-frivolous legal dispute, either through the commission's hearing process or a court of competent jurisdiction. I think that might give it some clarity that it's not through our audit and review process. That's been done. It is now through a separate process before available to a marijuana establishment through the commission's hearing process.
Commissioner Stebbins, would you mind repeating that recommendation?
Sure. In the new subsection 8 under 4 community impact fees, the last sentence I would amend to read, this subdivision shall not be construed to require a marijuana establishment to pay a CIF if a marijuana establishment's payment obligation is the subject of a non-frivolous legal dispute, either through the commission's hearing process or a court of competent jurisdiction.
And the reasoning, so you're changing before the commission to a hearing at the commission?
Right. As I understand it, they've already come to the commission. They've given us their invoices. We've certified their costs. They're now challenging our decision on the certifications of the costs, and we do make allowances for that to go through a hearing process and not the certification process.
Got it. Okay, I understand. Are there any comments or questions from my fellow commissioners?
Let me just have a moment to read what they put in the chat.
Commissioner Camargo?
The proposed language that we have in front of us is the new subsection 8, correct?
That's correct.
Okay, give me 1 second.
I'll read it aloud now. So the new subsection 8 would read, a marijuana establishment that has agreed to pay a CIF under its HCA shall annually pay any undisputed CIF no later than the end of the current fiscal year or within 90 days of the date of the commission's CIF certification, whichever is later. This subdivision shall not be construed to require a marijuana establishment to pay a CIF if a marijuana establishment's payment obligation is the subject of a non-frivolous legal dispute, either through the commission's administrative hearing process or before a court of competent jurisdiction. Commissioner Roy?
Thank you, Madam Chair. My question is for our working group. We didn't add that in. Was that why?
We
Were we trying
did.
to say the
Sorry, go
the
ahead.
administrative hearing part in this section? Was there a reason why we didn't include that?
I'll let EC Lopez and Director Poppin provide their comments as well, but I believe this is what was meant. That was the intention from this section from the beginning. The words before the commission was about the administrative hearing. So this provides additional clarity. And I believe that's what Commissioner Stebbins, that's why he wants it to be just really clear that that's what we mean by it. But EC Lopez and Director Poffin, I'll welcome your comments as well if you have any additional.
No additional comments from me, Madam Chair. Thank you.
Any other questions or comments? Director, Commissioner Stebbins.
Thanks, Chair. And again, thanks everybody for the conversation and discussion around this. I'm happy to, I'm more reluctant to drop my language proposal for the end of this section, but appreciate the clarity that we can now find in this section. And we can move on.
Commissioner Roy?
Okay, that he kind of answered. Thank you, Commissioner Stebbins. You kind of answered my question. This is a separate and aside from the attestation conversation. Like they're not co-joined in any way, right? I'm just for edification.
Commissioner Stebbins.
No, and I want to thank all of you. I was thinking about the attestation piece. Is I think what we've regularly seen happen since all this work began on Monday is that it just begins to generate other thoughts or other questions about other things that we previously incorporated. So I again appreciate all the feedback from my colleagues and concerns about what I was hoping to achieve with my new draft language. But I think that in turn, conversation around that in turn allowed me, and thanks to Council Lopez, to go back and just clarify that section, which I was drawing in my argument on the new language. And now that we've added, she's helped me get some clarity on that piece of it. I'm comfortable with it. And again, I'm happy with this change. And again, I'll reluctantly withdraw the other language that I had proposed.
Okay. All right. So we've removed that pen. And now with this language, sorry, go ahead, Commissioner Stebbins.
That was a big pin. And again, thanks for everybody's patience.
It was a good conversation too. So with this language for Section 8, do we have consensus amongst all 4 commissioners with that clarifying language? So I'll look for, okay, I see head nod from Commissioner Roy, Commissioner Stebbins, Commissioner Camargo, and now we are in consensus. I almost want to clap my hands. This is the end of HCA. Like this section, we can now go into the next section. All right, Attorney Baker.
Yes, Madam Chair.
I will give the floor to you to introduce the next section.
Thank you very much. So the next section we have is 500.181, minimum acceptable equity standards governing municipalities and host communities. I believe we had talked about not going line by line for this section to expedite the process. So please let me know if there's anyone in subsection 1 here who wants to address this.
Okay, so the first subsection, there's a few ways we can go about this, because I understand we can go in order, or we can just the commissioners can direct our attention to the issues and concerns they want to raise. I'm thinking this through out loud just to figure out what might be easiest for us in the way that we operate, and for you, Attorney Baker. Do you want to go section by section, or what's easier for you and Mercedes as you're capturing the drafted language?
I think maybe to not miss anything, maybe we could just go down the line and, by section, and we'll try to just do it quickly.
Okay, all right, so you can introduce the sections. I will watch my fellow commissioners. If there are any hands raised, we'll pause and we'll have a discussion.
Thank you. All right, so up first is subsection 1. This section is governed by MGL. That's what the first start of the language. Are there any commissioners that would like to raise an issue for this one? Conversation? Seeing none, I will keep going. Subsection 2 here, MGL Chapter 94G, Section 4A. First reads. Seeing none. Subsection 3, equity standards for host communities to promote and encourage full participation in the regulated marijuana industry.
All right, let's stop there. Commissioner Camargo.
Yes, I know that Commissioner Roy, you just dropped some language in the chat, but I do have a question. I just don't know what this section is. Oh, it's for a future section.
Commissioner Roy's is for a future section. Commissioner Camargo, do you have a comment for this section?
I do.
Okay.
Thank you. I saw it quickly, so I wanted to make sure. So in this section, and I guess I could just read it, section 3, equity standards for host communities to promote and encourage full participation in the regulated marijuana industry. Municipalities are presumed to have met the Commission's minimal acceptable equity standards for promoting and encouraging full participation in the regulated marijuana industry by taking one of the following actions. 1, adopting an ordinance or bylaw to exclusively license a social equity business for an extended period of time. So I have 2 recommendations, questions as well, and I briefly might have talked about this before, but within this section, we say adopting an ordinance or bylaw. I recommend that we create a model ordinance. The commission creates one. It'll allow for more transparency and sort of fair standards across municipalities to meet the presumption of compliance. So I wanted to ask possibly Kyle or Rebecca in terms of their thoughts on that. So that's one part of that. And I have some edits on the language that was recommended. So that's the one part first on that, and then the second part would be, actually, let me do that one. Let me ask that question first before I go to the same sentence in terms of the what I want to suggest to add at the end.
Okay, so Commissioner Camargo, you're asking about 3A1, if the Cannabis Control Commission can create the ordinance or bylaw.
Correct. The model or okay. Yes, correct. That's the first piece in that.
Okay.
And I recommend it.
Okay, you recommend it. EC Lopez.
Thank you, Madam Chair. I believe, Commissioner Camargo, if you're asking about whether the commission can create a model document, when I hear that, I'm hearing a guidance document, right? Since guidance is really less of an enforceability issue, I guess I'm seeing this as more of a legal question, and I would defer to our Deputy General Counsel if he would like to speak on this first.
Attorney Baker?
Can you repeat the question one more time, Commissioner? Sorry.
Commissioner Camargo, can you repeat that?
Yes, can we create a model ordinance that municipalities can adopt, sort of a standard model ordinance or bylaw? I would say more of an ordinance, to just have, you know, a standard document or that will allow for transparency just throughout the municipalities, and something that we're looking at the same, you know, it'll be the same for everybody.
Commissioner Camargo, can I ask you a follow-up question?
Yeah.
Do you believe there's some ambiguity, I hate that word, ambiguity in the way that this is phrased? So this line leads that municipalities are presumed to have met our minimum acceptable equity standards by adopting an ordinance or bylaw to exclusively license social equity businesses for an extended period of time.
Yes.
And you believe that we need to have language?
Yeah, so let me explain, because there's two parts to this, and it's a recommendation. One is, I'll just say it out loud and then I can put it in the chat. It would then read, if we can create a model ordinance or bylaw, it would then read, adopting the model ordinance or bylaw to exclusively license social equity businesses, and then strike for an extended period of time. I was going to recommend for 3 years or until the goals of the exclusivity period have been met. And then I was going to talk about the goals. So let me just dump, I typed it up. Let me just dump it into the chat really quickly. But I guess my question stands, Madam Chair. You know, the first part is about the model ordinance and the, you know, the feasibility for us to create it. And to your question, Madam Chair, I think it will just allow for, you know, transparency, but also some fair standards throughout the municipalities to meet the presumption of compliance. So I think
I'm getting confused with the term model ordinance or bylaw. Like I'll let Attorney Baker, I'll give him the opportunity to respond as well.
Sure. I tend to agree with Enforcement Counsel here that this sounds like it would be best for a guidance document for language that would be a model ordinance that they could adopt. I don't know if it would make sense to put it into our regulations, but but obviously that's up to you.
Commissioner Stebbins.
Thank you, Chair. Thanks, Commissioner Camargo. And we had a lot of talk about model HCA in our last conversation. Is an option because we think it might make the process more efficient. I think laying it out as an alternative, and again, not to impose anything unnecessary on a host community, but I think to your point, Commissioner Camargo, we create a model ordinance similar to how we looked at a model HCA, that there's some understanding by the commission that we consider that in compliance with what our goals are. So if there's a way to add the carrot, I mean, again, not to take away from a community doing what they want to do, and individual communities might strive to do better in this respect than other communities, and I wouldn't want to take away that creativity. But if there was something that we agreed would meet our standards and we would be deeming it to meet this section, then I think I like the idea of allowing that. And obviously that's, you know, another document that we would need to create and approve. But yeah, I throw that out there as kind of a suggestion. I like the idea. I'd like the opportunity for a community to use that and adopt it, and right, keeping the process moving, streamlining the process, allowing them to incorporate ideas and thoughts this commission might have to show compliance with this section. But I like the idea of maybe, you know, offering both.
So I'll tell you where I'm getting a little bit confused. Though it's the word model. So instead of just saying adopting an ordinance or bylaw to license social equity businesses for 3 years or until the goals of the exclusivity period have been met, you're saying that instead of recommending that, we're recommending a model ordinance or bylaw, which I'm assuming would add additional terms beyond what's the language here.
Madam Chair, if I may.
Marco?
Yeah,
Please.
I think if you look at them separately, that could be helpful. For right now, whether it's if we adopt the model ordinance, to Commissioner Stebbins' point, you know, and whether it goes in guidance, it sounds like it'll go in guidance. That would be the first part of it. So I would look at it as two different things. One is basically giving the municipalities the option to have, you know, the municipalities can adopt the model ordinance in order to be presumed compliant. So it would be just that one section first, and us providing guidance on what that model ordinance would be. And I know we're using the word ordinance. I know we used a HCA model, so maybe it's a equity. I don't know if the name makes a difference, but I think that's the concept.
So this section speaks to a presumption.
Yes,
not a
correct.
requirement. We're
Correct.
saying that if you have this within, if your municipality has adopted this, we presume that you've met the minimum acceptable equity standards.
Correct.
And what I'm asking is, they can simply adopt, so you can adopt an ordinance or bylaw to license social equity businesses for 3 years and until the goals of the exclusivity period have been met.
Mm-hmm.
So that's one thing.
Yeah.
But you're suggesting a model, and a model, when I hear model, I'm interpreting that as having additional terms aside from what is being laid out here.
I know what you're
saying. So why
thinking.
not just take that model language out and just say what you want in the presumption here instead of saying create a model?
Yeah, I mean, that works too. I think that's why this is a good conversation. I know what you're thinking. I think it'll be good to hear other folks, or maybe from our legal team, but the concept is allowing, creating something, and I think Rebecca said it, through guidance that can support the municipalities in adopting this. So again, whether it's a guidance, whether it's I know again, we're using the word model, maybe it's something else. I don't want to say document.
I guess my question is, what do you want in the model? That, like, can we just pull what you would, like, what is the suggestion? That's why I'm kind of envisioning what you're saying.
I see. That's a good question. So I think part of the second piece to it, as I sort of have recommended it right now, for 3 years or until the goals of exclusivity period have been met. I think part of that model would include, and I kind of took out, because I read the word, I look at the word goals, and I'm saying, okay, so what are those goals? So I took out the goals of our delivery model, and I took out one of them. So this could either be in the regs or it can be in guidance. Let me just put this in here. So this is also part of it. And it's the goals of our delivery. So I'll kind of read it, except taking out, I think it's E. Right now it's translated into numbers, but it's actually letters. So And Madam Chair, the reason I'm saying this is because you're asking me what would I want to see in there. So this is what part of what I would want to see.
I think in my mind, I'm like, just eliminate a model and let's put, let's figure out what the link, but I hear you, and I know we're having a conversation, so go ahead.
Yeah, exactly. The host community shall develop criteria for evaluating whether the goals of the exclusivity period are met, which shall include but not limited to overall rates of participation in the regulated marijuana industry by people from communities that have been previously been disproportionately harmed by marijuana prohibition and enforcement of the law. Overall rates of participation in the regulated marijuana industry by people of color. 3, licensees or ABC. C, licensees granted to businesses with majority ownership comprised of economic empowerment priority applicants and social equity program participants. 4, or D, number of registered agents who are social equity program participants. E, or 5, financial. Oh, actually, I was supposed to take 5 out, so not adding 5. Sorry about that.
Thank you, Commissioner Camargo.
Yeah.
Commissioner Stebbins. Oh wait, Commissioner Camargo, did you have? Go ahead, you can continue.
Give me 1 second. Let me go back into our regs right now to look at the delivery language. Give me 1 second.
Okay.
Number of delivery licenses A, B, C, D. Oh yeah, actually, how I put it in the chat is what I recommend. I'm sorry. I took one out that was number of delivery licenses. So excuse me.
Okay. Commissioner Stebbins.
Thank you, Commissioner Camargo. Thank you, Chair. You made it, Chair, you pointed out some language that's interesting, which if you look right above this, municipalities are presumed to have met the Commission's minimum acceptable equity standards for promoting and encouraging full participation in the regulated marijuana industry by taking one of the following actions. 1, adopting an ordinance or bylaw to exclusively license social equity businesses for an extended period of time. I think to help meet Commissioner Camargo's goals, could we create a number 2, which goes back to her earlier language of adopting the model ordinance or bylaw to social equity businesses created by the Commission, and that kind of model ordinance might contain everything that she's including here, but putting that out as a new option number 2 as a step a municipality has taken that is presumed to have met the Commission's minimum acceptable equity standards.
Commissioner Roy.
Thank you, Madam Chair, and thank you, Commissioner Camargo. I just have a question on number 1, overall rates of participation in the regulated marijuana industry by people from communities that had previously been disproportionately harmed by marijuana prohibition and enforcement of the law. Could you explain how that could be sustainable since we only have 30 identified communities and there are 351 cities and towns in Massachusetts, and how this could be geographically equitable?
Commissioner Camargo.
Yeah, Commissioner Roy, I listed that right from our delivery and marijuana carrier criteria of evaluation. So that's why I included it in there. I lifted it right from that as.
So Commissioner Camargo, you're saying that's currently within our regs?
Correct. It's currently within our regs. I lifted it from the criteria.
Commissioner Roy.
And thank you for that. I just think that the stakes, for lack of a better word, are a little different this time. When those were promulgated, now we're talking about communities having to forfeit all of their community impact fees, and the standard is a little different. And so there is communities can be penalized, and some of this, we have 30 identified areas that need to set. Now, I know not every town's a yes town, but I'm just throwing out, we have 351 cities and towns, and this commission has only identified 30 areas. And if they can't meet that, then there was no penalty before, and there's a penalty now. So it's not apples to apples.
I will clarify. So there's no penalty if you don't adopt this. This is the presumption language. So I just want to make sure we're all on the same page. This is not language that's a requirement. It's just language that a city could adopt in order to meet the minimum equitable standards. Commissioner Stebbins?
Thank you, Chair. And this language, at least, obviously, we incorporate this language because this language is included in the delivery regs as the requirement. I think, if I'm reading from where it's coming from, Commissioner Camargo, this is what the commission itself would have had to review statewide to figure out whether the exclusivity period should still continue, right, for delivery license, delivery couriers, delivery operators. I think there's a way to get to this goal. And again, I think if we took the language Commissioner Camargo has above it and talks about the model ordinance being created by or being offered by the Cannabis Control Commission, make that as option 2. That again, if a community decided to go that way by adopting our model bylaw as an option, that would, in the eyes of the commission, we would presume that they're meeting their obligations under this chapter. So I think this is some interesting meat for the model bylaw, but I think there's I think what your goal, Commissioner Camargo, is, let's say an option is creating a model, adopting our model bylaw or ordinance. And if you do that, again, it's that kind of carrot that we laid out in host community agreements. It's like, adopt our model HCA, we're going to presume it's compliant. If you adopt our model ordinance or bylaw around social equity, we are presuming that you are in compliance with this section. So I think we might be able to use more concise language and then think about the meat of that agreement, which again might drift into that guidance phase, or at least another document that we'll have to write and approve at some point.
I like the idea of having that additional 2. I agree with that. Commissioner Camargo, what are your thoughts on if this was, so we had 1 and then had this as a second qualifier?
Yeah, that makes sense. I think fine to add the model in a new number 2, but if one we extend the period of time, I think in the 1 the period of time is still a little vague. So as it reads right now, adopting an ordinance or bylaw to exclusively license social equity businesses for an period of time. So the extended period of time is still vague.
So are you suggesting that read 3 years? Or until the goals of so what is, go ahead, I'm sorry, I don't want to jump ahead.
Yeah. It's okay. We're having a discussion. So I put in here in the model language, for 3 years or until the goals of the exclusivity period have been met. So again, an option, not a requirement. So we can also do what Commissioner Stebbins is saying. I understand what he's saying. I mean, that makes sense. I want to just bring us back to the extended period of time. Like, what does that mean? Extended period of time. That's a little bit. That's a little vague. So if we leave that one like that, it's a little vague. Again, not a requirement. They can decide what their extended period of time is, as long as in the number 2 we have that 3 years or until the goals of exclusivity period have been met. I think then that will balance it out, because extended period of time right now is very vague.
All right, Commissioner Roy, I don't know if I saw your hand or not. I'll ask if you had your hand up. No, okay. Commissioner Stebbins, do you have any additional comments or thoughts?
Just for clarification, Commissioner Camargo, you're okay with leaving in the existing number 1 that language that says for an extended period of time in, and then under number 2, a model ordinance or bylaw that we're going to create might have some different language to it, might speak to a 3-year period if that's what if a community chose to adopt our model.
If I may. Yeah, I mean, I would like to see it in the regs. I would like to see for 3 years or until the goals of the exclusivity period have been met, and possibly the goals in the regs. I would like to see it there just because it's a key place to have it. But I think however we come to a consensus for it to be in there, I'm okay with that. But I just think the importance of it is to lay it out. I think Commissioner Concepcion had asked earlier, about the model, like what's in it. And I know we're talking about guidance, but I think having it in the regs, again, it's not a requirement, it's a presumed to be in compliance. That would be helpful to have it on there. So I don't know, Commissioner Stebbins, let me think about it for a second, because I know you're introducing a number 2. So let me just think about it for a second while I look at the document.
Commissioner Camargo, I want to clarify.
Yeah.
Your preference is your preference is to revise number 1.
Mm-hmm.
Well, now we're considering a number 2 that would encompass the model ordinance language.
Mm-hmm.
Would you be amenable to having a number 2 with the model ordinance language and then a revision to number 1 that states that 3 years or until the goals of the exclusivity period have been met?
I mean, that's fine. Yes, to your answer. We could probably do it in 1 sentence, but if it's clearer in 2 sentences and the messaging is there, I'm okay with that as well.
Let me take a step back and give you the space to kind of just walk us. What is your, what are your thoughts and what is your recommendation?
Thank you. I'll go back to my original sort of proposal is what's in the chat. Let me just look at it again. What I wrote in the chat. Oh, sorry, Bruce, you just put something new. Okay, hold on. Let me just go back to, yeah. So adopting the model ordinance or bylaw to a licensed social equity business for 3 years or until the goals of the exclusivity period have been met. That would be my first preference, because it's all in there. Obviously, I want to make sure that we're clear on what model ordinance is or means. And then Commissioner Stebbins just put in there, adopting the model ordinance or bylaw created by the commission to license social equity businesses for 3 years or until the goals of exclusivity period have met. I like that, Commissioner Stebbins. And you're saying that's a number 2.
It's sorry, Madam Chair.
Sure, Commissioner Stebbins.
Sure.
Yeah.
That's my suggestion. That's what I was thinking through when I was thinking of that new number 2 language.
Commissioner Camargo.
Yeah, I'm okay with that number 2 language. I like that.
Attorney Baker.
Thank you, Madam Chair. So Commissioner Camargo, that still kind of leaves that extended period of time as being vague in the first one. So I didn't know if you might want to take the stem of what Commissioner Stebbins had just provided and put that into 1, and then do 2 as its own thing, which is comply with the model, and we'll deem that compliant. Sorry.
Commissioner Camargo.
Attorney Baker, I see what you're saying. Yes, it does still leave the number 1 vague. So thank you for bringing back that. And I think that also makes sense. If we can write it up and put the revision for 1 and 2 in the chat so we can read it, that would be really helpful.
Madam Chair, I'm happy to do that right now if
Oh, okay. And then once it's in the chat, Commissioner Camargo, I'll just ask you to restate it so we can all hear what that proposed language would be. Commissioner Roy?
Thank you, Madam Chair. My question is for Commissioner Camargo. I see that you lifted and shifted the language as you had previously stated from our regulations. I just have a question, and I'm just kind of perusing through them again as a refresher. Was it intentional to omit the part about, let's say, like we have the commission shall collect and report on data measuring? You don't want municipalities to collect data and report?
Commissioner Camargo?
Yeah, let me look at it, Commissioner Roy, because I definitely lifted it. And I took one out that just pertained to delivery, but give me 1 second. Let me go back into the regs. Thank you for looking at that. My regs. So many regs. Okay. So I think I see, Commissioner Roy. That's number 2. The commission shall collect and report on data measuring the criteria throughout the executive period. The commission shall, yeah, I think we can add that one on there. But we just have to change commission to municipality or host community. Let me, the license shall, let me drop this, Commissioner Roy. Thank you for that. So this would be section. So this is what I'm dropping in here. I know we're doing this all stuff in real time. What I'm dropping in here is would go as part of the goals, but we haven't talked about where the goals would go, whether in the regs or in guidance. I would love to see them in the regs. Give me 1 second. So what I just dropped would be part of the draft language around the host community shall develop criteria for evaluating whether the goals of the executive period are met. So that would be either number 6 or A, B, C, D, E, F, or a different section. But again, these are goals. Commissioner Roy, I think we're probably, that's like another portion of this piece that we can talk about where the goals would go.
Okay.
And collecting data, I think, is great. So yes.
So let me pause and let's do 2 things. So we have a revision to number 1. So let's see if there's consensus on the revision to 1. The new number 1, thank you, Attorney Baker, would read, adopting an ordinance or bylaw to exclusively license social equity businesses for an extended period of time for 3 years or until the goals of the exclusivity period have been met. I wonder if for an extended period of time should be stricken.
Strike. Yes, you could. I think we should strike that.
So then it would read, adopting an ordinance or bylaw to exclusively license social equity businesses for 3 years or until the goals of the exclusivity period have been met. Commissioner Roy.
I was on mute. Thank you, Madam Chair. And how do you ascertain that, right? Through collection of data? Does that need to be? How would a community ascertain that information?
If
it would have to be through,
met,
like it have to be through.
Commissioner Roy,
Commissioner Camargo.
Sorry, Commissioner Roy, are you asking, and I know we're talking about the goal portion, so should we wait to get to that part and sort of look at number 1 and number 2 and then talk about the goals and where it would go, again, whether in guidance or in the regs, just so that we're not too confused because we have a few things going on?
Commissioner Roy.
Thank you, Madam Chair. So you're classifying the other ones as goals. What are these classified as? So I can make the distinction in my mind. Like number
Sure.
1's not a goal. Like what are we calling it?
I don't think we're calling it, if I may.
I think so. If I understand what you're saying, Commissioner Roy, you're saying we're asking for, there's a measurement here. There's a measurement. We're saying until the goals of the exclusivity period have been met. But we're not, there's no language about sort of showing that about, Commissioner Camargo, go ahead.
Yeah, and I know where you're going, Madam Chair, but I think, I guess how I'm sort of seeing it in my head is just figuring out the language first so that we're in consensus with the language. And then I think we think about the operational piece. Commissioner Roy, to your point, that's why I was adding the goals. So there could be some language around direction to the goals or instruction or guidance to the goals. Because here it reads, or until the goals of the exclusivity period have met. Okay, what goals? Where are they? So I think that's the second part that we need to figure out and or write it in here. So we could add the goal. Yeah.
But the thing is, so these are two separate options. One is adopting an ordinance or bylaw, an exclusivity period. The second is the model. So, you know what? I'll take a step back, Commissioner Camargo. Let's go through two so we can go through the goals, and then maybe we can be some more clarity once we go through that. So go ahead. Can you just read for us what two would read?
So two, right here with Michael Baker's revision, adopting the model ordinance or bylaw created by the commission to license social equity businesses. Strike 4. Okay. Attorney Baker, was there something else that did you miss something on number 2?
I can, Madam Chair, if you
can read it. Attorney Baker, please.
Yeah.
Thank you. Sorry. Yeah, I can just read it for the record. So this could potentially be 1 and 2 here. So adopting so 1 would be adopting an ordinance or bylaw to exclusively license social equity businesses for 3 years or until the goals of the exclusivity period have been met. And then 2 would be adopting the model ordinance or bylaws created by the commission to license a social equity business, or is what I meant to say, because then you have 3 after.
Thank you.
Commissioner Stebbins.
Sure, thank you, Chair. Couple of questions or in one observation. These are, first of all, these are things that these steps are things that we are encouraging options that we are encouraging municipalities to adopt so that they can be in compliance with this section. As I look at the revised number 1 is provided in the chat. We're asking a community to adopt an ordinance or bylaw to exclusively license social equity businesses for 3 years or until the goals of the exclusivity period have been met. So essentially, it would appear to me that the community is adopting their ordinance or their bylaws with whatever stipulations that they put in, and that those stipulations exist until the goals of the exclusivity period have been met. I don't think that's a determination we can make. That's a determination that the local municipality is making. We've adopted this ordinance, we've adopted this bylaw to promote social equity businesses. Our goal is this during an exclusivity period. And once we reach that for that individual community, they then can decide that they've met their obligations. So I think that's kind of separate and standalone. If we want them to report that progress to us, that should become kind of a whole new reporting regulation. So that's an observation or a question I might have. The other part, and really looking to you, Commissioner Camargo, is if we're saying exclusively license social equity businesses for 3 years, are we hamstringing a community that might have wanted to say 5 years or 7 years or 10 years or indefinitely? So that's where I know we talked about clarification of an extended period of time, but I don't want to stifle a community's ability to say, we want to do 10 years based on our new municipal ordinance or bylaw. I'm not sure I want to constrain them either they want to be more aggressive than 3 years.
Yeah, no, I get it.
Commissioner Carmichael?
Yeah, if I may. Yeah, no, thank you, Commissioner Stebbins. Yeah, I get it. I think, you know, when you think about 3 years, you know, we all kind of know that it takes about 3 years for these businesses to kind of get up and running and hopefully show up some profitability for their businesses. Which is why I think the 3 years was a good start. But I'm also okay how Attorney Baker put it in here, and I know that it's still. I hear your question. I mean, unless we write for a minimum of 3 years, but again, this is presumed and doesn't mean that they have to. And I don't think it reads that you know, this is one option. They can do 5 years by all means. That would be great.
Mm-hmm.
You know, we'll actually really balance the playing field, you know. But I understand what you're saying.
Commissioner Roy?
Thank you, Madam Chair. I just, on number 1, pursuant to what? Commissioner Camargo.
Commissioner Camargo?
Yep. Let me go to number 1. I mean, I think pursuant to our policy discussion, right, and sort of the recommendation, and again, it is a presumed, not a requirement. So
Let me
go ahead, Commissioner Roy.
Is that what you were asking?
Not really. Well, sort of. Thank you, Madam Chair. How do they demonstrate? How does the community demonstrate that the goals of exclusivity have been met? Pursuant to what? How do they demonstrate that?
So how, when you're saying how, part of the goals that I sort of lifted was part of some of that process. How they do it on their end, I can't think for them, but at least we're giving them some criteria and some outlines in terms of goals. And I think that while we go through this section, at some point, and I think in the next page, or maybe on this, actually on the same page in the bottom, we get to a host community shall develop a plan. And we're talking about an equity plan. So I think the how is also part of that equity plan.
And that aligns, I believe, with what Commissioner Stebbins was stating about that being the determination of the municipality. I understand. So, okay, Commissioner Roy and then EC Council, Enforcement Council Lopez. So Commissioner Roy, please.
Thank you, Madam Chair. So pursuant to, and that's why I brought up the data collection, because it is weaved into our regulations and other exclusivity license types. And the reason I say that the data collection is important, because there may be some communities where they don't have any social equity applicants. And so the data collection is important to demonstrate how many or how many did not come to that community to become a licensee. So I think pursuant to what is important, because we want communities to show us we had this many social equity businesses come before our community, or we had 0. Like, we need to know. So
no, that makes sense. If I may, Madam Chair, just quick
and
back.
Commissioner Camargo, now I'm understanding why your original recommendation was to replace the original language with the model language. I think I'm understanding you a little bit better, but go ahead, Commissioner Camargo, please.
No, I was just gonna say to Commissioner Roy's point. Yeah, absolutely. You know, and obviously this is like, we're putting draft language here and having the discussion. Everybody has to be a part of this. I wasn't in the working group, you know, so I'm trying to add a little bit of beef to it. But yeah, no, absolutely, Commissioner Roy, I think data is so important. And I think about the towns that are still not there. I think about new towns. I'm always thinking about the long term, past us 5. You know, there may be new towns that come online and, you know, may have no clue how to do this. So I think having this in the regs sort of being more clear, less vague, and then allowing for that data collection. Commissioner Roy, absolutely, absolutely.
And we do have the data requirement within our draft regs as well. EC Lopez.
Thank you, Madam Chair. I just wanted to follow up on Commissioner Stebbins' concern in terms of whether or not the language that has been presented by Commissioner Camargo could have the effect of limiting what a municipality can do. And I just wanted to follow up with to note that the statute did speak to that. The legislature considered that as well. And the statute explicitly provides that a host community can establish procedures and policies beyond the minimum regulations established by the commission to promote equity.
Thank you, EC Lopez. Commissioner Camargo.
Yeah, Madam Chair, I was just going to kind of bring us back, which I think you were going to do the same thing. I think we have on the table, Mike Baker's 1229 draft of 1 and 2. And then I think the part after that is the goals. Again, I would like to see the goals in the regs, but I would leave it up to us in terms of consensus of whether they go in the regs or they go into a guidance. So I'm trying to put stuff in the reg so that we're not creating more guidance.
I understand, and this is a different impact. Regulations are mandatory, guidances are a little bit different. Commissioner Camargo, your recommendation now, I just want to make sure we're clear on the recommendation for the amendment here, is to have a 1 as revised by Attorney Baker and a 2 that speaks to the model ordinance or bylaw. Is it possible to read 2 with the goals in its entirety so we can hear what that looks like if it were adopted into regulations?
Let me re-edit so that I can put it all together.
Okay.
Give me 1 second. I gotta go into like a Word document, blah, blah, blah. Hold on. Real-time drafting. 1 second. Oh, okay.
While you're doing that, I'll go. I see Commissioner Stebbins. Commissioner Stebbins, please.
Thank you, Chair. And I'm anxious to when we get to that point, because I do like the point Commissioner Concepcion, you've raised, or Chair Concepcion, you've raised, and Commissioner Roy has raised about. I think at some point the Commission wants to see how successful these municipal efforts are and kind of what that data reporting requirements should be. So I'm anxious to look ahead in the regs and have that discussion. Again, I thinking about, hate to be called the process guy, but I'm thinking about the language that we're looking at for the new revised number 1 and the new number 2. Again,
sorry, I just sent you guys the wrong. Sorry, I'm editing. Sorry, I'm off mute and I'm editing live. Hold on. When we translate inside of our chat, the letters become numbers. So I was trying to redo it. Hold on, give me 1 second. Okay. My bad. Keep going, y'all.
Commissioner Stebbins, you were mid-thought. I tried to
let me finish. That was a surprise. That was great.
That wasn't on purpose. That wasn't on purpose.
I know. I look at that revised number 1 in I really would encourage us to go back to that extended period of time, because I don't want to lock a local municipality in. I also don't want a local municipality, and I understand this is one of many options, right? But allowing that municipality to decide for themselves. A city like Boston might decide for a longer exclusivity period. A smaller community, which might only really have the market appetite for one licensee, I think they kind of need that discretion to figure out what's the best timeline that works for their community. And again, I realize this is just one option that a community can adopt. I know Commissioner Camargo is talking about some of the evaluation criteria that we might incorporate into our model ordinance or bylaw, or that a local community, I'm thinking, might adapt of their own. I would encourage us to think about some of those measurements and putting them in guidance, because it is quicker for us to change guidance than it is for us to change regulations. And I'd want to give us the space and the flexibility as we're writing that new model ordinance or bylaw to consider what some of those criteria and measurements are, as opposed to formulating them within the regs. But just, I throw that out for consideration.
Commissioner Camargo?
Madam Chair, I'm trying my best to edit, but I don't know. I hear what Commissioner Stebbins is talking about, and I think, you know, the guidance documents are also heavily weighted, you know, in these processes. So I'm okay with that. It'll also give us time to sort of look at the goals. But I did add the goals in here, 1 through 6, and they should be A, B, C, D, E, F, G, but it keeps messing with me. And the last one, instead of saying the commission, it should say the host community.
Can you read it for the record so we can all hear
all of it? Okay. I'll read it, but I guess I also have a question. I'm hearing Commissioner Stebbins say that this possibly could go into guidance. Before I read that, is that correct? What he's saying?
He's saying that
okay, all right.
We might want to consider that, but I'm asking to read it so that we can actually hear and
absolutely
comment based on what we have.
Absolutely. The host community shall develop criteria for evaluating whether the goals of the exclusivity period are met, which shall include but not limited to A, overall rates of participation in the regulated marijuana industry by people from communities that have been who have previously been disproportionately harmed by marijuana prohibition and enforcement of the law. B, overall rates of participation in the regulated marijuana industry by people of color. C, licensees granted to businesses with majority ownership comprised of economic empowerment priority applicants and social equity program participants. D, number of registered agents who are social equity program participants. E, financial feasibility of continued participation in the regulated marijuana industry by communities that have previously been disproportionately harmed by marijuana prohibition and enforcement of the law if exclusivity period ends. And G, right? A, B, C, D, E, F. Wait, A, B, C, D, E, F. Number 6, it should read, the host community shall collect and report on data measuring the criteria throughout the exclusivity period. The host community shall begin evaluating whether the goals of the exclusivity period have been met at least 8 months before the end of the 36-month period to provide adequate time to consider whether an extension of the 36-month period is necessary. So we got to take that out. I just read that. We got to take that. We got to strike that last part out because that really is for delivery. Mike Baker, I think you're probably better at this. Can you re-edit this so that I'm not screwing anything up right now? And striking the commission and adding host community, and then also striking out evaluating the last sentence in terms of evaluating. I don't think we need that. Sorry, there's questions.
I know, and I have my own too. I see the hands. I might actually throw out a curveball. Because the more we go through this, I recognize that this is an opportunity for us to, you know, before now, municipalities didn't have to have any sort of equity provisions at all. It was only a mandate at the state level for the Cannabis Control Commission. And the curveball, I'll say what I'm thinking, this is live, we're talking, is I might be in agreement to your original suggestion, Commissioner Camargo, on having just this language instead of number 1. If we're talking about a presumption, if we're talking about standards, we're talking about sort of, this is like the gold star standard. If you are able to comply with this, then we will presume that you have met our equity standards here at the Cannabis Control Commission. And I appreciate that you pulled this from already existing regulations, because it would mean that municipalities have to align with some of our expectations that are already set here at the Cannabis Control Commission. So I'm just stating it so everyone knows where I'm thinking, and I will now go to my fellow commissioners who've had their hands up. So Commissioner Roy.
Thank you, Madam Chair. My question is for Commissioner Camargo. On number 4, the number of registered agents for social equity program. Oh, I see. Okay, so who are social equity program participants? So does that, so that list is like registered agents? Are you saying like if they work in XYZ community, you want to know how many SEP participants work in that municipality? And my question on that is, how does that work? Like, how does the municipality ascertain that information? And number 2, that list is fluid. So literally somebody could work for an ME for a week and leave to another ME outside of that community. Do they get credit for that week? Like, how does that work?
Commissioner Camargo.
Commissioner Roy, that's a good question. I think it's good that we're having the conversation. The how, again, I think we need to think it through. I know what you're saying. People have these jobs and they kind of come and go. So I hear you, but again, it was there as I think, again, like I lifted it and I read it and I almost striked it. I almost took it out and added it back in just because it would be a good point as an example, again, for the host community to at least have a ballpark estimate of, there's three operators in our town, and we know that there's at least 20 social equity, registered agents or whatnot. So, but I hear you. We got to think it through a little bit.
Yeah.
Commissioner Roy.
Thank you. Just to follow up, thank you, Madam Chair. I guess my concern is it will devalue the goal. In other words, if someone is a registered SEP participant, works in town A for a week and they leave, go to town B, so both are getting credit, and it might devalue the impact because, so I just don't, I guess that work needs to, you know what I mean?
Yeah, I get it.
You're not going to get the true impact, I guess, is what I'm.
Commissioner Stebbins.
Chair, thank you, Madam Chair. I appreciate this discussion. As I'm reading through these, and I know we pulled these from, again, what evaluation and assessment the commission is required to do as part of our consideration of the exclusivity period for the delivery operators and delivery license category. And I think they're all, in that case, it's great criteria for us to assess. I do have some reservations and might speak to Commissioner Roy's point of asking a smaller community to try to track down some of this information, which is actually information that we have because that's the way it's spelled out. Again, I go back to thinking our model bylaw and ordinance might be something that a lot of this can be baked into in guidance. And a couple of other points, I think is we look to the next section, which is about the components of a host community's plan. I think a lot, Commissioner Camargo, what you're looking for is considered in that section, as well as the data requirement. Is I was just kind of perusing ahead because I was looking for that data requirement. I think some of the things are already being set forth in that section. My other consideration, question, or chair is maybe now is a good time to maybe take a 20-minute break for lunch.
Okay. I'll do a little bit. Let's do it's 25 minutes, a little less than that. We'll break for lunch until 1:30. Commissioner Stebbins, do I have a motion to recess until 1:30?
So moved.
Commissioner Camargo, do I have a second?
Second.
Now do a call the roll. Commissioner Camargo?
Aye.
Commissioner Roy?
Aye.
Commissioner Stebbins?
Aye.
The chair votes aye. We have 4 in favor, none opposed. We are recessed until 1:30. Okay, it is 1:30. You're a little blurry, but I see Commissioner Camargo. We have Commissioner Stebbins. Okay, I see Commissioner Stebbins. Commissioner Roy. All right, we are all back. Let me just make sure we have Deputy General Counsel Baker to bring us to where we left off. Okay, perfect. All right, so we are all back. Deputy General Counsel Baker, would you mind refreshing our memories and just bringing us back to where we left things off, please?
Of course, thank you, Madam Chair. So we are on the municipal equity section. So it's 181, subsection 3A, and 3A1 is where we specifically left off.
Okay, perfect. Thank you. Commissioner Camargo.
Thank you. Can you see me now?
Yes.
Okay, I had to clean my computer camera lens. I did a little wordsmithing during the break and took a lot of our conversation into consideration, just so that we can sort of, I can put something more concrete out. But let me just drop in the chat. I took 1 and 2 and made it into one sentence. So my recommendation is that we amend number 1 to just look like this. And if I may, I'll read it.
Please.
Adopting the model ordinance or bylaw created by the commission to license social equity businesses for 3 years or until the goals of the exclusivity period have been met. So a few things taken in consideration, Commissioner Roy, are your questions about the goals, the data collection, how our municipality is going to do that. I think that we can do that through guidance and kind of work, after these regs are promulgated, to sort of figure out what we can put in that guidance in terms of the goals and how to guide municipalities. And then I won't recommend that we add any of that to the regs. And then again, just to remind folks that this is presumed, not a requirement, but a presumption of a requirement. So that's what's before us, and I wanted to just submit that as my final sort of amendment to this portion, number 1.
Commissioner Stebbins.
Thank you, Chair. Thank you, Commissioner Camargo. So are you suggesting that we drop 1 as it exists now?
Correct.
So just for clarification, we're not allowing any municipality to create any ordinance or bylaw on their own. Their only option under this section to be presumed in compliance is they have to adopt ours.
That's a good question, Commissioner Stebbins. And how we have it, how it reads now, adopting an ordinance or bylaw to exclusively license social equity business for an extended period of time. It's already saying that. It's just not, well, yes, it would be the one that we create. To your question, I'm reading what's on the regs now. But yes, I think that, and that was really the purpose of my amendment, was to create a model ordinance so that it's the same thing across, not the same thing, but the model ordinance would be something that all municipalities can have that comes from the CCC. So yes, to your question, yes.
Commissioner Stebbins.
Yeah, I'm not sure I'm in agreement with that. It doesn't, for me, it doesn't really follow kind of the case we've laid out for in the HCA process. And I would worry that, I can appreciate we're trying to get communities to adopt that higher standard, which might be in whatever model ordinance we create. I'm also a little reluctant to take away a community as large as Boston or as small as a community out in the Berkshires from trying to be creative in their own right. And I know further down, a lot of, we're requiring them to adopt a plan to help meet this goal as well. So I really like the option of one or two. I'm a little reluctant to adopt just one as it's been presented.
Commissioner Camargo?
Commissioner Stebbins, I hear you. Thank you for bringing that back to the forefront. So what would you recommend with what I have as, I think the key thing for me is having the model, it coming from the CCC, and having the, the 3-year exclusivity period language. So kind of what I wrote. So what would be your amendment?
Thank you, Chair. Again, I would leave one as we have it and take the language that you're recommending and make it number 2. And again, this is that section where, to get the language correct, we're presuming that a commission is meeting their obligations under this section by adopting one of the following, right? And we're giving them a couple of different options here. I would encourage us to keep the idea of a 1 and a 2 in this section. And maybe after we go through a little more thought or a little more review of subsection 2 that talks about what a host community shall develop in their plan to promote and encourage full participation, that we see that section first, and that may drive us to reconsider whether we need 1 or 2.
Oh, sorry.
No, I'm sorry, just finish up. I think there might be some pieces in that are going to help us realize the goals that we want for social equity among municipalities. But I think we need to read through that section after we finish this up, or after we consider this.
Commissioner Camargo?
So Commissioner Stebbins, I just dropped a remix here of 1 and 2 in our chat, if I may read it. Adopting an ordinance or bylaw to exclusively license social equity businesses for 3 years or until the goals of the exclusivity period have been met, or adopting the model ordinance or bylaw created by the commission to license social equity businesses. That's U's and I's point together in different numbers. Again, not a requirement, but presumption.
I think that reads fine. Sorry, Chair.
Okay. So Commissioner Stebbins, you're in agreement with the proposed language from Commissioner Camargo?
Mm-hmm.
Okay. Commissioner Camargo, I have no objection to this. Commissioner Roy?
Thank you, Madam Chair. I just want to make sure I'm understanding this. So 1 and 2 would be in regulation. And then when it goes granular on the goals, it will be in guidance. Is that right?
Correct.
Okay.
We're gonna have to work on a guidance document.
Okay, and then
who's volunteering?
Hold on, I see Enforcement Counsel Lopez has provided a friendly amendment. So do you mind explaining that amendment, EC Lopez?
Thank you, Madam Chair. Yes, I just suggest that we remove the commas around or bylaw so that there's no confusion that the model ordinance or bylaw is one document that will be created by the commission, and that the commission will be creating a model ordinance and a model bylaw. It's just for clarification.
Okay, thank you. Commissioner Camargo, were you providing some additional comments?
No, no.
Okay.
I think I was just waiting. I'm just hot. I was waving that.
Commissioner Roy?
Just for point of edification, thank you, Madam Chair. The municipalities don't license the businesses. We do. Am I reading that wrong?
Ah, that's a good point. You know what? You brought up something that we went through on Monday where we changed that word from license to an EC Lopez or, Attorney Baker. Do you mind reminding us what we've changed that when we're talking about the municipal process? And I'll go ahead, Attorney Baker.
I think you could say contract, adopting an ordinance or bylaw to
I guess I'm
exclusively
asking
contract.
what term we used, because when we were discussing this on Monday, we made an amendment. EC Lopez.
Madam Chair, I believe the amendment was permitting. We changed licensing to permitting. So that may be the word to consider here.
I would propose that we use the same language just for consistency and so that we avoid any sort of confusion. That was a good catch, Commissioner Roy. So are we in agreement for permitting? So the first one would read adopting an ordinance or bylaw to exclusively permit social equity businesses for 3 years until the goals of the exclusivity period have been met. 2 would read adopting the model ordinance or bylaw created by the commission to permit social equity businesses. Are we in agreement? Do we have consensus?
Yes.
Okay. All right, Commissioner Roy.
Yeah, I'm just rereading it just to make sure there's no other, I think it's good. I was just rereading it. Thank you for checking
Okay.
in.
All right, Attorney Baker, please bring us to the next section in the municipal equity portion of our draft, please.
Thank you, Madam Chair. So that amendment, just for clarification, I also want to connect with Mercedes on this to make sure that she captures it accurately. So we have a new 1 and 2, and so the current 2 is now going to drop down to 3. And if no one has any comments on the new 3, then we can go down to subsection B below, starting with notwithstanding.
Commissioner Camargo.
Yes, I have a question for section 3, number 2. If I may.
Yes, please.
That's what we're at, right?
That is that's
Okay,
the new
okay.
3. So
Okay.
just we said that. But
So
yes.
when we say creating a local approval process for equity applicants that is administered on a one-on-one basis where a general applicant may be approved only after social equity businesses has completed the local approval process. So my concern is local approval process. Like, what does that, what does that mean? And or should we say commenced operations on that?
Your question is what is being referred to when we say local approval process. EC
Correct.
Lopez.
Thank you, Madam Chair. A local approval process is a new definition that was created by the working groups. And I believe that's the definition that we modified where we changed it from host community cannabis licensing to host community cannabis permitting, but it's on page 12.
Let me just look at that for 1 second, because I'm also, thank you for that. I'm also just wondering, where a general applicant may be approved after social equity business has completed their, I mean, I would, again, it's a suggestion, a recommendation. I would want to see commenced operation, sort of in line with our, well, not in line with anything that we do, but sort of thinking about the exclusivity process, with our delivery drivers and that license, in terms of commenced operation. So let me just look at 12 for a second, but that's where my thought is.
Okay. Director Poppin.
Commissioner Camargo, I think this will address your question and maybe aim towards where you're going with your policy proposal. Just for some where Commissioner Camargo was going, the exclusivity period for delivery licenses, as of right now, it is tied to the date the first delivery operator commences operations. which starts that 3-year term, which started, I believe, on April 1st of 2022. Yes, I think so. It is tied to the commence operations, and right now the language in there that says operating, just for some clarity and just to inform the commission, so that they can make an informed decision on their policy proposal. Once a licensee gets a final license, they are essentially operating limitedly, like in the sense where they can obtain marijuana, they can start cultivating marijuana, they can start producing products, and they can possess marijuana. But really the full operations where they can actually engage in the wholesale or sale of products happens at commence operations. I wanted to just give you that a little bit of information so that could inform your decision.
Thank you, Director Potvin. Any other questions or comments? Commissioner Stebbins? Okay. Commissioner Camargo, so you propose the words local approval process and inserting completed the local approval process, and then instead inserting commenced operations.
Correct. Thank you.
Okay, so then it would read creating a local approval process for equity applicants that is administered on a one-to-one basis, where a general applicant may be approved only after a social equity business has commenced operations. Are we in agreement? So I will, Commissioner Roy, I see I had not. Commissioner Stebbins. Okay, we have consensus to change that phrase. Attorney Baker, let me know if you need me to repeat anything. I just want to make sure you and Mercedes are able to capture the change.
I believe we are all set.
Okay.
And if we're ready, we can move on to the next section, which is subsection, which is 3B below.
Yes, please.
Do any commissioners at this time have any comments for 3B? Seeing none, I'm going to keep moving to the next section, which I believe should be 3. Sorry, A, B. I think it should read C, but on my version, it's not reading C right now. So, but a municipality or host community shall adhere to best practices for HCA negotiations.
Our draft has the same, it needs to be fixed. So you're right, it should read C, but it's showing as B. Commissioner Camargo?
I just wanted to kind of ask Mike, where was he reading on our paper draft?
I skipped down below, so it's on the next page. So it would be the top of 77.
Okay, so I had a comment for back to page 76. A host community shall develop a plan.
Okay.
So I just want to kind of understand this concept a little bit, but also it reads, a host community shall develop a plan to promote and encourage full participation in the regulated cannabis industry by individuals from communities disproportionately harmed by cannabis prohibition, enforcement, and possibly impact those communities, and shall publicize its equity plan. So my question on the concept here is, so one is in the first sentence, a host community shall develop a plan. One is, should that be equity plan? Just so that kind of like out the gate, we know we're talking about an equity plan. And then I'm trying to think about, while we move into this section, the process for this equity plan. I know that the host committee equity plan shall encourage applicants, the next stuff that we're going into. So I kind of wanted to just get that, because part of me was thinking this equity plan from municipalities, I know they're going to host it somewhere and stuff like that. But did you all think that that equity plan would come to us for review as well? And if not, what would be the review process? Would we be able to look at that equity plan like we do positive impact plans or diversity plans?
So currently the regulations don't speak to our review process here, but you're right. This is creating, it's requiring that municipalities create their own positive impact plans to ensure equity as well. Are you, do you have a recommendation or suggestion in terms of us having a more a more active role in terms of reviewing and approving?
Yes, and I don't know what that would be, but I guess the conversations on the floor. I know it's one more thing for us to review, one more thing to upload, but I think that the reason we're here is because we don't know what the municipalities' equity plans were, or for many of them, they didn't even have equity plans. So I'm open to the conversation and or ideas of what would that process look like for us if we were to review and ask municipalities to submit, through their host community. I don't know how that ties to different sections, to us to review.
So I guess I have a couple of thoughts here, because there's a few things that would happen. First, I want to know, and I will ask Attorney Baker and Attorney Carter, as well as EC Lopez, I guess all the attorneys. I would ask you all sort of about our ability to approve or disapprove, for that nature, a host community's positive impact plan, whether that we would be operating within our authority. Director Potvin.
Thank you, Chair. If we go further down, I believe it is C. Host communities must adopt local rules or bylaws to comply with this section on or before May 1st, 2024, where that's the third May 1st, 2024 that Acting General Counsel Carter brought up yesterday or the day before. I'm sorry that the days are merging. Host community must submit an attestation in a form and a manner determined by the commission, affirming that has adopted local laws to effectuate compliance with this section and identifying the specific laws passed. So I think this does speak to where Commissioner Camargo is going, but not directly on point. And just as some distinctions between things that are existing policies, just at a high 30,000 foot level. We have some things that are notification requirements where our licensees or applicants are notifying us. We have some things like change of ownership, change of name, change of location applicable to licensees where it's not a notification requirement, it is a request and approval, and they cannot do said thing until they get that. So there's a couple of different tiers here to consider as policymakers, but there is already a notification requirement that they have complied with this section of the law. So, but ultimately, whether it's going to be a notification requirement or a request and approval, whether that can be actually implemented by statute, I will defer to EC Lopez or the legal team, but just differentiating those two things and just identifying that there is a notification requirement that already exists.
Thank you, Director Potvin. Are there any other comments or questions? Okay, Commissioner Camargo, so we have to develop the language to address what you are proposing. So in this section, you were suggesting both an approval process and what was, I feel like I'm missing a component.
Just the approval process. The other thing was just the beginning sentence, very small here, but a host community shall develop a insert equity plan. I know we say plan, and I know we say equity plan below, but as the first part of the introduction, that was the other thing. And then, you know, I think for us, the review process, you know, posting it on the website is not enough, right? That's for the public and whatnot. I think for us as a commission, being able to look at those equity plans from municipalities now moving forward with this new law would be very beneficial. And in guidance, you know, we can figure out, they don't have to be long.
Commissioner Camargo, Attorney Carter, I see you turned on your camera, so I want to see if you had any comments that you wanted to provide.
No, not at this time, Madam Chair, but I have rejoined the meeting.
Okay, awesome. Commissioner Stebbins.
Sure. Thank you, Madam Chair. Just picking up on, I think, the point Director Potvin made. Madam Chair, I reflect on your question as well. I don't know if we have an ability to review these plans. I think there's an outline of what we want to see in a plan. There's an outline of what is required to meet this section on or before May 1st, 2024. But I think that the section below it is where any interested person may file a complaint with us. And I think that gives us that wherewithal to weigh in on a plan that is not working or is not in compliance. Again, I'm just thinking of regulatory burden. If the host community has done everything we have prescribed, I question our ability to also review it because they're also in that sending it to us. We're hoping that the host community is telling us how they're complying with our regulations. And then again, I think there's teeth behind that if somebody doesn't think that plan is in compliance, that they can pursue a complaint through us. But I echo your concern, Chair. I'm not sure we have an ability to actually review it until somebody attests that it's not working or complains that it's not working.
E.C. Lopez.
Thank you, Madam Chair. I will just note in terms of the authority question, which I would certainly invite Director Potvin, Deputy General Counsel Baker, or Acting General Counsel Carter to weigh in as well. I will note that the commission in general has an obligation, even apart from Chapter 180, had a pre-existing obligation to establish procedures and policies to promote and encourage full participation in the regulated industry, equity participation, and to positively impact communities that were harmed. And that power was interpreted to apply to licensees. The legislature has responded now explicitly directing the commission to establish policies and procedures for host communities to promote and encourage and essentially engage in their own equity work on the local level. In the same way that the commission did interpret its statutory obligation to promote policies and procedures to promote and encourage full participation, and how that was originally interpreted as having the ability to review plans from licensees to positively impact communities. It would seem to me that that same statutory provision could be relied on to support the commission also reviewing the plan of a host community for that same purpose. Whether or not the commission wants to go in that direction as a matter of policy is, of course, up to the board.
Thank you, E.C. Lopez. Commissioner Camargo, I'll ask if, have you thought about any proposed language?
I have not, but we can come back to it or we can sort of flush it out. I think the question for me is, you know, how do folks feel about an equity plan, and the process as it comes to the commission and as we review it. So I think that's the big policy question. So I'm curious. Yeah, go ahead, Commissioner.
Commissioner
Oh, sorry.
Thank you, Madam Chair. What does a minimally acceptable standard look like? Commissioner Camargo.
You're asking in general, Commissioner Roy, for this section?
So I guess I just want to throw out this for us to contemplate. How do we do a one size fits all when we have 351 cities and towns in different geographic locations that I just would caution, yes.
Commissioner, I'm sorry, you confused me for a moment here.
Okay.
When you said a one size fits all, because we're not talking about a model here. So
we're proving,
you might just elaborate
right?
A little bit more.
So I guess maybe I need clarification. What are we proposing that the commission review exactly? What is the commission reviewing exactly?
It's essentially municipal positive impact plans.
They're equity plans.
They're equity plans, but I'm saying it in that way because that's how we understand it within the Cannabis Control Commission.
Right. Yeah, that's analogous. Thank you. Okay. And are we approving or denying or approving and issuing a notice of what happens? What is the action the commission takes? I'm confused.
Yeah.
Commissioner Camargo.
Yeah, Commissioner Roy, that's a good question. I think that's why I'm bringing it up. I don't have that answer. I think that's why I asked what would a review process look like. It would be, I think, up to us what the review process is. And then, you know, the same way we do positive impact plan, diversity plans. You know, we do send notice of deficiencies. I don't know, we would send a notice of the deficiency to a municipality. But I think we need to think about it. I think the scope here is being able to review their equity plans. A lot of these towns have zero equity plans, which is why we're here today. And some of them don't have the ability to do all that, or didn't have the guidance or the understanding of the marijuana industry. So I think that, you know, us having them sort of, again, I'm thinking out loud right now, having them sort of submit their equity plan as positive, as part of, you know, their host community package, could be the way to go. To your question, Commissioner Roy, how would we say, hey, this equity plan is, you know, is not acceptable? I think we have to think about that. What does it mean? I think really it's being able to review it, but I haven't thought past the, right now, the compliance piece as it relates to us. So up for discussion.
Commissioner Roy.
Thank you, Madam Chair. So we have, in the analogy was drawn with positive impact plans. So our licensees are mandated to provide the commission a positive impact plan and diversity plan with goals. And many of us as commissioners look at the renewals and we see a lot of them do not meet their goals. And there's no mechanism to enforce that. And I don't want to say it's a nothing burger, but in a way it is, because they don't meet their goals. A lot of folks. And what is the implication for a municipality? Because we're licensees, there's no punitive measure. Is there a punitive measure to hold up anything for a municipality? Because I guess I just need explanation.
Commissioner Camargo.
Yeah, I mean, that's a good question, Commissioner Roy. I think you're posing it to all of us as a body, you know. That's a good question. And I think that, you know, to your point, the nothing burger, you know, not everybody hits their goals at times. And I know that, you know, that's a thing. When people don't hit their goals, we talk about it in public. We identify those folks that have not, or we put some kind of condition when it comes to renewals to make sure that they're, you know, doing it better the next time. But I think, and, you know, again, it's up for discussion. You know, I think we had a long discussion earlier when Commissioner Stebbins was sort of trying to come up with the concept that we were probably talking about prior. But I think for this is that the important piece here is that we can see their equity plans, that we can review them, that not only are they posted up on a website, but that they're also coming to us and are on record. If they don't have great equity plans, what do we do? I'm not sure right now, but I would say, in thinking of having guidance for this, when we do create a guidance document, I would hope that we talk about give the municipalities guidance on an equity plan, because for a lot of these folks, and especially, you know, we talk about the smaller towns, you know, their legal teams obviously don't have too many people, but folks need equity plans, and they need, and we need to be able to see them. Otherwise, you know, why are we going through the process of having them create these plans if they're just going to post them on the websites and put them somewhere in City Hall, when we're the regulators and we have the power and the authority to make sure that they're meeting their equity needs. So I don't know. Team effort here.
Commissioner Stebbins.
Sure. Thank you, Chair. And I like these points. I think not to go back way too far into our regs, when it does come to a licensee or a marijuana establishment who's not meeting their diversity goals or their positive impact goals on a consistent basis, and I'll just look for a nod from Director Potvin. We do have the ability not to renew their license. It's baked into the regs. I don't think that step has ever been taken because we're still new into this process, but I believe it is a condition that we can turn to say why we might not renew somebody's license. Is that accurate? I want to make sure we're getting clear on that point.
Director Potvin.
Commissioner Stebbins, I might have missed a crucial element of what you were saying. But what as far as renewals, obviously, you know, from just a global standpoint, we want to see businesses succeed, and we want to see compliance, and we want to see renewals. We have, to my knowledge, we have never denied a renewal, but it has come to a point close to that, and especially in recent months, but rectified, and that's public knowledge. With that said, I guess what I'm hearing is the municipal requirement and how it's tied to the licensee's renewal. I would caution against that, but can you provide a little bit more clarity? I see your hand up, so Madam Chair, may I?
Yes, Commissioner Stebbins.
Sure. And again, I'm trying to have this conversation around where the commission has teeth, where we don't have teeth. And again, I thought Commissioner Roy raised a very good point of how, in the other side of our work, when we're renewing license applicants, and even though we haven't done it to this point, the authority still rests with us that we could deny somebody for a renewal if they are completely blowing off any of their obligations under a positive impact plan or a diversity plan, if we see it that way. But
Madam Chair, may I? Oh, sorry. No.
So, again, probably too much context around where we have teeth and where we don't have teeth. But speaking specifically to this section, I appreciate the work that was done, and I hear Commissioner Camargo about a plan that nobody sees in city or town hall. And again, I think sometimes this gets back to a community's bandwidth and what they have the resources to do. So let's establish the bare minimum. And again, not box or overburden a municipality by additional things that we think they ought to do. But as I look through the rest of this, first of all, we are laying out everything that we want to see in a plan. The host community must adopt those local rules by a certain date. They must submit an attestation that they have done this. They have complied with all of the things we're suggesting around the bylaws, plans, local ordinances, bylaws. They give that to the commission, affirming that they have done what we have asked them to do by that May 1st, 2024 date. And again, hopefully everything that we've told them to do is our best practice, is what we are encouraging. I think to Commissioner Camargo, your point, you do want to make sure that these plans are solid, that they're well thought out, that they're diligent. And I think all the language before this helps identify what we expect to see, or in some of what their options are, and some of it we're requiring for them to tell us. And then, an interested person may file a complaint, be that, I'm assuming, any member of the public in that community, a license applicant, a marijuana establishment may file a complaint with us alleging non-compliance with that equity requirement. So I think that, Commissioner Camargo, that gets to your teeth of, if there's a plan that one isn't being followed, or if there isn't a good plan that meets our standards, that we have the ability to go in, we have the ability to render judgment on that plan, according to the complaint. And then in some cases, if we go this far, we have the ability to institute a fine. In this case, it looks like against the host community. So I'm appreciating the discussion, but I just want to make clear that what else we have baked into the statute is addressing a loophole we don't want to create.
Thank you, Commissioner Stebbins. Director Poppin, and then EC Lopez, and then I see Commissioner Camargo. Director Poppin, please.
EC counsel, double counsel is because she's doubly good. With that said, so thank you, Commissioner Stebbins, for that explanation. And let me try to, I guess, provide some context or connect some bridges here between what you're saying and what Commissioner Camargo, I think what your aim is there is right now in the draft regulations compliance teeth. Again, that May 1st, 2024 date, that is where you're going to get to eventually, where they need to come in compliance with this section, the municipalities, host communities. Host communities in itself is a particular term too. So it's a defined term. So we got to remember that as well. And if they are not in compliance, there is an outlined provided for, as Commissioner Stebbins said, there's compliance teeth there. There's some real impact, which is one of those things is fines equal to all the community impact fees they've collected from all of the licensees. That could be a lot of money. That's also an incentive to come into compliance. With that said, Commissioner Camargo, what I'm hearing is you want them, instead of a notification requirement, it's essentially you want them to apply and get approval, request and get approval for their plan, which this might be a little bit out of the scope of how I can opine on this, but I guess to use that word again, this essentially, if adopted as a policy or considered as a policy, this is an added administrative requirement being imposed on a municipality that wasn't originally accounted for. I would defer to acting general counsel on this, but we faced a similar situation where in a couple of years ago, I guess at this point, where we had that delivery only license, and then we created a whole new license type, which was the marijuana operator. And that went it was determined that that went outside the scope. So we had to go through a separate and distinct regulatory process all over again, per the Secretary of the Commonwealth's office. So I think to that point is seeking and doing an approval of something like this. It might be problematic at this point, but even regardless of that, if municipalities do not come into compliance, the section that Commissioner Stebbins brought up, the non-compliance, we get notification of non-compliance of a municipality in this area, just like if we got a notification about a licensee being not compliant with any other section. We're going to look into it. There's going to be an inquiry. It may rise to the level of an investigation. It may rise to the level after that to an enforcement action, which is already accounted for in the draft regulations. So I do think there is compliance teeth established to promote municipalities to come into compliance with this section.
Thank you, Director Potvin. EC Lopez.
Thank you, Madam Chair. And just reinforcing Director Potvin's point, and just so the commissioners are aware, the legislatures seem to feel very strongly about the commission's ability to hold licensees accountable to promote and encourage equity and positive impact on the local level. In Section 3F of the statute, it specifically says that a city or town shall adhere to the commission's regulations regarding procedures and policies for promoting and encouraging equity participation. And additionally, it says that the failure of a host community to adhere to those procedures shall result in a monetary penalty to the host community equal to the annual total of community impact fees received from those operating in the host community. So the legislature took steps to explicitly give the commission teeth to hold municipalities accountable here.
Commissioner Camargo.
Thank you, Rebecca. I think to that power and authority, I think is what I'm thinking and why I'm bringing up the conversation. Because we haven't had, for some towns, there has been municipal equity and we applaud them. For other towns, there hasn't been for a lot of reasons. And I think that this is important because we do have the power and authority. We're kind of massaging through the options and how and administrative and all that stuff, but I want to remind us that we do have the power and we do have the authority, and HCA is one thing. Municipal equity is a whole other monster where we can, if wanted to, be helpful when it comes to equity and municipal equity. So I would encourage us to kind of push a little bit, and even if we have to kind of read through the stuff and maybe come back, but I think we need to think about it because how would we see these municipal equity plans? Do we go every month and go on the website and see who has them, right? So that's what I'm thinking. And I don't want to let this go right now just because this is key and we have the power and the authority to be able to hold these municipalities accountable. And again, I keep thinking about guidance, and I know, even here where we're at, it says a host community shall develop a plan to promote and encourage full participation in the regulated cannabis industry by individuals from communities disproportionately harmed by cannabis prohibition and enforcement, and to positively impact those communities, and shall publicize its equity plan in a conspicuous location at its offices and on their sites, on their websites. A host community's equity plan shall, right? So when I read that, that's really like how it's written right now. It's really just for municipalities. It's operationally for a municipality to create these plans and post them on the website. Like, that's it. So I feel that we do have the power and authority to review these equity plans. The compliance piece, Rebecca, I wanted to ask you, and I think you sort of mentioned it in some of the commentary that you've had, but, and I think Commissioner Stebbins talked about it a little bit, but what would be a compliance, what would we be able to develop in terms of a compliance for, let's say I'll give you guys a quick example. So the diversity plans right now, as the diversity plan is written, it's you know, there's two goals that you should be able to hit. So for these equity plans, they may not be perfect in the beginning. You know, we could do guidance where, you know, municipal equity plans could look like this. Here are some, you know, here are some suggestions. Here are some things that you can do. We're already putting some of it in here as we speak, and be able to give feedback and be able to review. I don't think we would ever say to a municipality, oh no, this is, you know, this is your, you know, we're not going to license your licensee because of this, right? So I'm just curious about what can we do from a compliance perspective if we were to sort of adopt the, you know, us seeing the equity plans and us approving them. What would be a compliance deficiency? I don't know, that we would be able to do. And I'm thinking out loud here. So just because I think that this is very important.
Commissioner Camargo, I'm going to try to paraphrase what I hear you saying. Right? Are you asking what consequences can have, or what teeth we have if? Yeah. Okay. And
we keep talking about the teeth. We keep talking about the teeth. Yeah. So that's my. And I know this is difficult because it's municipalities. But we're here. We have the power. We have the authority. And again, we're here because a lot of these cities and towns did not have an equity plan. And when we look at the numbers, and we're all talking about equity, we've been talking about this, you know, the last few months. How do we move the needle? We look at our equity numbers. You know, they're low, and they're low for a lot of reasons. You know, they've had a lot of hangups at the municipal level, access to capital, access to, you know, lawyers and lobbyists. You know, access to you know, all kinds of stuff, right? So like, you know, this is again, future impact, but part of why we're here is because a lot of these municipalities didn't even think through this, you know, they couldn't. And quickly, you know, your big operators came in and, you know, they came in, they did what they did, and we're now playing catch up with equity licenses and equity participants in all these municipalities. So I just think there's a real opportunity to think about supporting municipalities, right? This is not a punishment for municipalities. This is how do we support municipalities through their equity plans. So.
Thank you, Commissioner Camargo. Yeah. Commissioner Rice, see your hand before I ask you to provide your comments or questions. Do you know, EC Lopez, Attorney Baker, Attorney Carter, Director Potvin, do any of you wish to respond to Commissioner Camargo and her question around the teeth, the consequences if there's a plan that does not meet the expectations of the commission? EC Lopez.
I will certainly defer to Director Potvin since his team is already kind of in the business of reviewing the kind of parallel universe plans that currently exist, which are diversity and positive impact plans. But I would just note before turning it over to Director Potvin that, you know, Commissioner Camargo, this is part of the compliance implementation process. And this is part of thinking that through, and this is part of preparing and having time. So this law it's a significant overhaul, not just for the municipalities and the licensees, but for the commission as well. It has given us it's expanded our oversight powers significantly, including oversight regarding the equity actions or inactions that are occurring on the local level. And so it's difficult to speak to what that will look like before the ink is dry on what the standards are. And just all I can say is that we as a agency have to prepare to implement that. So what the draft regulations provide now is a complaints process, an investigation process, and a fines process, and administrative hearing process, which is consistent with how we handle these matters now.
Thank you, C. Lopez. Commissioner Camargo.
Is there some kind, I'm just thinking through, is there some kind of attestation process that we have when the municipalities, would that be a place to kind of find a yeah, would that be a place to sort of change and not change, but maybe modify the municipality or host community attestation form or whatever it is with this as part of this? And I'm not speaking clearly because I'm just thinking out loud here. But I guess that's a question for Kyle.
Director Poppin.
Thank you, Madam Chair. To your point, Commissioner Camargo, obviously municipal equity is a huge piece, and there is some real significant teeth there for compliance. And I agree with everything that EC Lopez just said. But to your point specifically about the attestation, that is provided for right now already in the draft regulations under C, where our host community must submit an attestation in a form and a manner determined by the commission, affirming that it has done what we are requiring them to do. So one, we'll have that on record first and foremost. That doesn't go far enough. However, if they haven't done that and we get a complaint or we do a spot check as we develop out these policies and processes, we have teeth to enforce this law, and there are real consequences for municipalities, especially then too, if they're attesting that they've done things and they haven't. That raises the game a little bit too. But there's significant teeth, but that attestation part is provided for already under C.
Thank you, Director Poppin. Commissioner Roy?
Thank you, Madam Chair. My question is probably to Director Poppin, because you had alluded to, and I'm going to read from Chapter 180, Section 25, subsection B, and I know you already read it, but please indulge me. The failure of a host community to establish procedures or policies pursuant to subsection A shall result in a monetary penalty to the host community equal to the annual total of community impact fees received from all MEs or MTCs operating within the host community to be deposited into the Cannabis Social Equity Trust Fund established in Section 14A of said Chapter 94G. Now that's the teeth, right? Director Poppin, that's the teeth, substantial teeth. Who would assess that forfeiture of funds, and where would it, what government agency determines they're not in compliance to assess this penalty, and where do those, and I know where the funds go, but what government agency determines that?
Director Poppin.
And I would ask that EC Lopez help me out if I'm wrong. But the non-compliance with the commission's regulations for a host community, it would be the commission.
Who tells community ABC you need to deposit all your community impact fees to the Social Equity Trust Fund? Us?
That is my I believe so. Not being on the municipal equity working group, that is my understanding. And it probably will include some type of notification to the municipality. But before that, it's also a little bit of a back and forth that's provided in the draft regulations to give them an opportunity to come into compliance, because ultimately we want them to adopt these policies. We want them to comply, just like we want licensees to comply. So there will be a little bit of a back and forth, and a hope and a desire, and a very sincere desire for the municipality to come into compliance. But if they're still not doing it, inevitably, I do think that it's probably the commission that would issue some type of notice saying, you're not in compliance. This is the history. Here's the facts of everything. This is the amount that you are to be fined, and this is where it goes. But then I think at that point, that's where we stop.
Okay, I have a follow-up question now. Because earlier, Director Poppin noted some complications if we were to review, approve, and disapprove of equity plans, municipal equity plans. But we have the ability to assert that a municipality is not within compliance, and then they're susceptible to fines. You sort of alluded to the fact that we might be going further and it might take an additional step. I got a little bit lost there, so I wanted to kind of bring us back to figure out, because I know the conversation is all coming, it's around this conversation about whether or not we can approve or disapprove of these municipal equity plans. So do you mind just kind of restating that and telling us about why there might be some complications and limitations with our ability to do that? Yes, Director Hoffman. Yes.
Thank you. I do want to clarify this. It's not my opinion that the commission does not have the authority to do those things. That is not my opinion. I think we do, and I think the commission as a body could adopt policies to do those things. The concern that I was bringing up is not so much a policy, but a process and procedure. Essentially, changing this requirement at this stage where we are right now, changing it from a notification requirement to a regulatory requirement of municipalities to submit information for approval might rise. And again, I defer to legal and acting general counsel to opine on this, or Attorney Baker. It might trigger a need to do a separate and distinct and second notification and public hearing and public comment period based on the procedures laid out by the Secretary of the Commonwealth when a government agency is promulgating regulations. So essentially, it would stop right now, hypothetically, and again, I will defer to legal. Once the body approves this draft regulations, the hypothetical scenario, which was analogous to the delivery situation a couple of years ago, required us to do another notification to the Secretary of the Commonwealth, another notification to the public, another public comment period, which could be 30 to 45 days. I'm not sure exactly on the procedure. It could prolong the promulgation of the policies that you have before you right now.
And that is because while we are talking about municipal equity, and this is tied to municipal equity, is essentially a significant change. And again, I could be wrong, and that's why I'm deferring to legal. But we are requiring municipalities now to get approval, to submit a request and get approval before they do something. That might be a significant change that might rise to the level of outside the scope of where we were and what we put the public on notice, including the municipalities at this point. I could be wrong, but that's the concern. It's not so much that if the commission has the authority to do it. That's not at all. It's a concern of process, not policy. Okay. Acting General Counsel Carter.
Yes. Hi, Madam Chair. When we think about the regulations, right, and the process that we are undergoing, we put out a draft which invites comments and invites feedback for the public and for stakeholders to participate. So when we think about changes to the final regulations, it is most prudent for us to stick within the scope of the draft regulations and issues connected, because the most critically important thing is that there is a notice requirement, and we want to make sure that we are not inviting risk of challenge later. The other thing, right, of course, is this body sets its own schedule when it comes to promulgating regulations. Generally, I mean, in this instance, we do have a statutory deadline, but if there is a desire amongst the board to work on other issues after this promulgation process has been complete, that is completely within your purview to set that schedule.
Acting General Counsel Carter, I understand that. I'm very clear on that. I think the thing that I can use some clarity on is this being outside the scope. I don't necessarily, and again, I welcome any sort of guidance here, but it's hard for me to see this as analogous to the two delivery licenses and the creation of a completely new license, which Attorney Potvin, Director Potvin referenced. So do you mind I guess essentially I'm asking about a threshold for scope. How does this fall outside of the scope when we've accounted for, I'll call it the municipal equity plan within our draft regulations. We've required the publication of those municipal equity plans. So my question is, how does this fall, or why would it fall outside of the scope when the creation of that plan is already considered and has already been released within the draft?
If I may, Madam Chair.
Please.
Yes, so the scope ultimately is set by this board. And if you are comfortable with the notice that has been put out there, and I think there has been a reasonable amount of notice, it's more of just flagging the issue for your contemplation as you set policy. But it sounds to me like this is further development of a particular regulation, which does fall within the scope. We just want to be very careful about threading that needle. Because as we know, so much work has gone into this process thus far, and we want to make sure that we are continuing on very sound footing.
Okay, I hear you. And I agree. That's why I wanted to be really clear about this. And I'm trying to, because we require the development of this plan, we require the publication of this plan. The additional step here would be that we would receive it and evaluate. Am I correct in my understanding? I guess I'm okay. I see your head nodding. Commissioner Roy?
Is this something that could be subsequently folded into social consumption when we begin that endeavor? Could we revisit this, and therefore that's a separate promulgation process because that's next on the docket? Can that be somehow put into that scope to not jeopardize this process right now?
Acting General Counsel Carter.
Yes, and thank you, Commissioner Roy, for that point. I think that what you're speaking to is somewhat analogous to the way that Director Potvin brought up the delivery issue. So the way that the board previously operated, out of an abundance of caution, we did hold additional hearings, we did continue the process, and that was really to reduce any risk of challenge in the future. So I think ultimately where we find ourselves is a level of risk appetite. And I think the other issue is in previous iterations, we did not have the same time constraints that we find ourselves in. The last time we had a statutory deadline was for the entirety of the regs, which is the initial promulgation. So in that instance, everything was in scope. So we do find ourselves in a little bit of a different situation here. But ultimately, this is a question for the board, as you are the agency's leadership, and ultimately this is your call to make.
I have one follow-up question, and then I think I saw, maybe I saw Commissioner Camargo's hand. I might have seen one of my fellow commissioners' hands. That is helpful. It is helpful to keep that in mind. I am wondering if, short of an approval process, if we were to include the CCC receiving those plans, so there's language here about publishing them in a conspicuous location within the host community's offices and on its website. If we also included that we could receive it, that it should also be submitted to the Cannabis Control Commission, are we well within our scope? And I see Director Potvin, please.
Ultimately, I will defer to Acting General Counsel Cotter, but that is along with what Acting General Counsel was just saying. Risk appetite is is exactly where I was coming from. And out of an abundance of caution, at least at this stage where we are, I think the risk is significantly reduced at this point if the commission chooses to do a modification of the requirement where there's an attestation that needs to be sent, an attestation along with verifying documents in the plans as a package being sent to the commission. Where the risk increased was creating an approval process where that in itself is not, the municipal equity piece is not outside the scope. The modification of the process, which could be significant enough for municipalities or anybody in this, that could rise to the level where the concern increases. But the proposal that you just said, it definitely significantly reduces the risk, in my opinion.
Thank you, Director Potvin. And thank you for flagging this, because it's helpful, I think, for us across the board to understand this and to not, do anything that would jeopardize like our entire process that we've been doing for so long. Director Potvin.
Yeah, just as one follow-up, because it was a great point, and I forget, I'm sorry which commissioner brought this up, so my apologies, but the commission does and has announced that they plan on doing further regulatory changes after this current process. And right now, as it's outlined, is that municipalities need to come in compliance by May 1st of 2024. I don't see anything in the next regulatory cycle, if there's proper notice, where you could possibly, as a policy, promote this in a much more risk-adverse situation.
Okay. Commissioner Camargo?
Thank you. Thank you, everybody, for the collective thought process and just kind of really thinking this through. I think it's important. I know that the delivery example is a little different because that's like a whole license, and I don't know all the details that went into that. So I think I'm hearing you in terms of the risk, and obviously we don't want to be challenged at any point right now. But I also know that at any time, us as commissioners can bring up a regulatory change. And I know that after we get, 1 or 2 days rest and after we promulgate the regs, that we're gonna start over in terms of the next batch of stuff that we want to take care of. My question is, could we include in here the municipalities sending the plans? Like, they're going to post them on their website. Can they send them to us as a, FYI or an attachment, so that we can see them, and that we have the option to review them, and then come next regulatory round, we can add the approval process, and once we think about it a little bit, understand it a little bit better in terms of compliance, put it out for public comment. But I don't want to miss the opportunity of seeing these equity plans. It'll start giving us an idea of what municipalities are doing, what they're thinking about, and it also holds them to that standard of, like, sometimes, oh, the commission's not going to look at my website. No one's going to come into City Hall.
Commissioner Vergara, you don't have to go there. I just suggested that. We just got, yes, that's essentially the suggestion that I proposed. Thank you, because for us to receive it.
Yeah, you see me looking up, so I'm just thinking out loud right now. So thank you for pausing me for a second.
That is exactly that's where we were going. That is the consideration or the idea that I proposed, and Kyle, Director Potvin, responded that would be more aligned with what we already have in our draft regulations, and he proposed having it combined with the attestation component.
Yes.
So yes, that's my long-winded way of saying yes. That's what we were going through now.
Yeah, and Madam Chair, if I may, I apologize. I did hear that. I did hear the conversation. I just, for my own, I wanted to reiterate it and sort of talk about it out loud. So thank you. Yes, thank you.
Okay. So Director Potvin, do you mind telling us where within the regs? I just want to make sure we get this in there. We have some proposed language and that we can continue after this consideration is complete. But Director Poppin, where in our regulation should we be looking for that language?
Thank you, Madam Chair. For Attorney Baker and also Mercedes, it is 500-181 3C as it's in the current form. It reads right now, host communities must adopt local rules or bylaws to comply with the section on or before May 1st, 2024. A host community must submit an attestation in a form and manner determined by the commission, affirming that it has adopted local laws to effectuate compliance with this section and identifying the specific laws passed. The modification that I would propose that would be in line with the discussion that just occurred is essentially the host communities must adopt local rules or bylaws to comply with the section on or before May 1st, 2024. A host community shall submit an attestation in a form and manner determined by the commission, affirming that it has adopted local laws to effectuate compliance with this section and identifying the specific laws passed. In addition to the attestation, the host community shall submit all plans, and I'm trying to just cover all of these sections to make sure that we are all plans and all plans, bylaws, ordinances, policies that are required under this section that demonstrate compliance with this section or some way, shape, or form. I will defer to the other lawyers in the room to clear up that language, but it's essentially connecting the attestation with the submission of all the information to the commission as a package, so that at least we are notified of that they've complied with it. And then also at that point too, while there's not an application or an approval process, we will have this information and it will allow us to consider next steps as outlined in 3D as far as the complaint and the possible non-compliance.
Thank you, Director Poppin.
You're welcome.
You just did a lot of mental gymnastics there, a lot of mental work. So thank you. Appreciate this. EC Lopez, I don't know if I just saw your hand raised. No, okay. All right. So there's a few things. Yes, Commissioner Camargo.
Just for clarification, I also had asked to insert equity plan.
That's what I'm doing now. Yes. Okay. So I turned this back. I just want to go through what we've done thus far. Okay. We're on 76 under 3.2. Inserting the word equity before, so it would, like, host community shall develop an equity plan. That is your recommendation, right, Commissioner Camargo? Is for 2 to read, a host community shall develop an equity plan to promote and encourage full participation in the regulated cannabis industry by individuals from communities who've been disproportionately harmed, so on and so forth.
Yes, if I may, I don't know, this is wordsmithing, but may I, madam?
Yes, please. Okay.
In the same sentence at the end, it says, and to positively impact those communities and shall publicize its equity plan. So it's we have it there twice now. We could take off equity from that one, or we could leave it on there. It's really, for the wordsmithers here.
I would suggest leaving it in there. Okay.
I'm okay with that. Yep.
Do we have consensus on inserting those edits? Under 2, a host community shall develop an equity plan. Commissioner Camargo, Commissioner Stebbins, Commissioner Roy, are you okay with that? Okay. All right. The next edit is it's a typo. 77 B should read C. So it should say C, a municipality or host community shall adhere. Then we go to D and then E.
Chair.
Yes.
Madam Chair, if
Yes,
I may,
Commissioner Marco.
if I
Yes.
may, we're doing pretty well, and I applaud us. I kind of wanted to just suggest, because at least for me, this section is very important. I wanted to ask Attorney Baker and yourself if we could read through this. I think to Commissioner Roy's point yesterday when we were going through host community, you know, we've looked at this, but I think reading it out loud one time today would be very helpful. And I only ask because I think we're doing well on time, but this is so key, and there could be things that, you know, we may be missing.
Okay, we can read through it. Let me just finish this first, and then we'll do a read through. Okay, so C, D, E is what the remaining section should read. That's more of a it's a smaller edit, and I'll look for nods. I think we're okay with changing the letters. Okay, so now the new D, and I see Rebecca has inserted language. Rebecca, would you, E.C. Lopez, would you mind reading the new language for subsection D? Do you mind reading it in its entirety, how it would read in our regulations, please?
So how it could read is host communities must adopt local rules or bylaws to comply with this section on or before May 1st, 2024. A host community must submit an attestation in a form and manner determined by the commission, affirming that it has adopted local laws to effectuate compliance with this section and identifying the specific laws passed. In addition, a host community shall submit its equity plan and any other documentation of its compliance with this section.
Thank you, Attorney Lopez. My only edit here is that it should read a host community shall, not a host community must. And that's the second line. My fellow commissioners, I see a thumbs up from Commissioner Camargo, Commissioner Stebbins and Commissioner Roy. Are we in consensus here, or are there any additional comments, questions, or concerns? Okay, we are in consensus. All right, so now let's go back to 76 and Attorney Baker. One second. Let's go back to 75. Attorney Baker, can you read this section through before we continue to the next component, municipal equity?
Page
Madam Chair,
77.
would you like me to start from 1?
Commissioner Camargo, was your recommendation to read the entire section? What section were you requesting?
Moving forward from where we're at, let's start reading. Does that make sense?
Yes, it makes sense. So you're saying beginning at 4,
Correct.
read line by line. That is your, okay. All right, Attorney Baker, please proceed to the next section and we will read the lines by line.
Sure. So just before we get to 4, I believe we didn't address E yet, the new E. So I just want to ensure that if there's anyone else that wants to speak to this subsection. It does not appear that is the case, so I'll go down to 4. Equity standards for host communities during HCA negotiations with social equity businesses and licensed applicants and individuals and entities pre-verified by the commission.
Okay, let's pause. I see Commissioner Camargo has a comment, please.
I'm sorry. I'm sorry to do this. I was confused. I would go back and read through the numbers have changed now, but we finished in a host community shall develop, and then A, we just finished that. I would start at in our paper document, page 77. B, a municipality or host community shall adhere to best practices for HCA negotiation.
Commissioner Camargo, are you asking us to read from there? And it's the new
Yes,
C.
please.
So B is now
Yes.
C, but you're
The
asking
new
that to be
C,
read.
correct,
Okay.
from the new C. Yes, thank you, and yeah.
All right, Attorney Baker.
Sure. So the new C is a municipality or host community shall adhere to best practices for HCA negotiations with licensed applicants that have been designated as social equity program participants or economic empowerment priority applicants, including but not limited to the following. A host community shall develop a standard evaluation form or use a form developed by the commission that scores components of an application. The evaluation form shall include consideration of equity in the overall evaluation score, which must comprise not less than 25% of the total evaluation score. This equity component shall include 1, whether an individual, entity, or license applicant is pre-verified or verified pursuant to 935 CMR 500-1017. 2, whether the license applicant is a social equity program participant. 3, whether the license applicant is an economic empowerment priority applicant. 4, whether a license applicant or pre-verified individual or entity has a prior marijuana-related criminal offense or conviction. 5, whether a license applicant or pre-verified individual or entity is part of an area of disproportionate impact as identified by the commission. Or 6, a pre-verified individual is, this is a little, so 6 reads, a pre-verified individual is or a majority of a pre-verified entity or license applicant entity comprises of individuals from Black, African American, Hispanic, Latino, or Native American or indigenous descent. So I think the way it's reading for me on that last sentence, we might need to just slightly tweak.
Hold on, let me read that one again. A pre-verified individual is, comma, or majority or of a pre-verified entity or licensed applicant entity comprises of individuals from Black, African American, Hispanic, Latino, or Native American or indigenous descent. You are right. It should read a pre-verified individual is, comma, that's correct, or a majority of pre-verified entity or licensed applicant entity. Strange, okay.
No. You know, before. No. Edit. Opening comment, after comment, before.
I'm glad we're reading.
Me too. Me too. Try this again. A pre-verified individual. Let me try this way. A pre-verified individual or majority of pre-verified.
Rebecca, I think you're off mute.
Sorry.
It's okay.
It's
We're just
okay.
hearing you talking to
I kind of
yourself.
like hearing her think. Oh, wait a minute. Attorney Baker, do you want to try to take a stab at amending this?
I am attempting that in my head right now.
Okay, we can all do it.
I will.
My head is just down, so if someone is waving, just tell me you're waving. Hold on. I wonder, so a pre-verified individual or a majority of individuals within a pre-verified entity of Black, African American, Hispanic, Latino, or Native American or indigenous descent. Say this again to make sure that makes sense. A pre-verified individual or a majority of individuals that doesn't make any sense. Jeez. Okay, hold on.
Madam Chair, if I may.
Yes, please. Enforcement Counsel Lopez, save us.
I put some language in the chat that might help. It reads, a pre-verified individual is of comma, or a majority of a pre-verified entity or licensed applicant entity comprises of individuals that are of, comma, Black, African American, Hispanic, Latino, or Native American or Indigenous descent.
Or a licensed applicant entity comprises of individuals that are Black, African American. Attorney Baker, what's your, does this align with, look. I know this does get to the goal of the working group, I can say that, but I just want to make sure that it's okay in the way that it's written for our regulations.
Madam Chair, I just put in what I attempted to redraft as the language here for 6. Again, that's just what I'm taking away, and appreciate Rebecca's suggestion as well. I wasn't in the working group to know exactly what this provision was getting at, but I think that this might be along the lines.
Well, it's to say that either the individual is of African American, Black, Hispanic, Latino, or Native American or Indigenous descent, or the entity is comprised of a majority of people who identify as those, one of those or multiple categories. So that's what we're trying, the language should read to include individuals who are of Black, African American, Hispanic, Latino, Native American, or Indigenous descent. I think Rebecca's language is closer, so let me read this again. A pre-verified individual is of, or, comma, or a majority of a pre-verified entity or licensed applicant entity comprise. Okay, so here's another, okay, hold on. Rebecca's new language. A pre-verified individual is of Black, African American, Hispanic, Latino, or Native American or Indigenous descent, or a majority of a pre-verified entity or licensed applicant entity. I'll make my attempt now. Bear with me. So I've put into the chat, a pre-verified individual is of Black, African American, Hispanic, Latino, Native American, or Indigenous descent, or a majority of a pre-verified entity or licensed applicant entity is comprised of individuals that are Black, African American, Hispanic, Latino, Native American, or Indigenous descent. Okay. Any questions from the commissioners? Commissioner Stebbins.
Thank you, Chair, and thanks for the clarification in the language. If I might, can I go back to the intro paragraph to see, I think we're missing something. It says a municipality or host community shall adhere to best practices for HCA negotiations with licensed applicants. It says that have been designated as social equity program participants or economic empowerment priority applicants. Are we missing social equity businesses from that introduction paragraph?
Yes, we are. Our original draft included a third category, but this was a change, and you are spot on, Commissioner Stebbins. We now need to edit this so that it accurately includes that third category of individuals who would be eligible for our social equity program. So you are correct.
If I might, I would just, after license applicants, if we can just state that are social equity businesses or have been designated as the rest of that sentence.
Yes. I'm in complete agreement. Enforcement Counsel Lopez.
If the objective is to obtain to capture the individuals pre-verified, they're not yet social equity businesses. So you might want to consider instead saying, municipality or host community shall adhere to best practices for HCA negotiations with individuals or entities that have been pre-verified pursuant to 935 CMR 500-1017, comma, and license applicants that have been designated as social equity program participants or economic empowerment priority applicants, because those two groups fall within the definition of an SEB, a social equity business.
Thank you, Rebecca. EC Lopez.
Or actually, you could also add, no, actually, my apologies, license applicants that have been designated. So license applicants aren't SEBs yet. So I think we also have to add SEBs and the pre-verified group in there.
Repeat that whole, repeat the final recommendation, please.
Okay. Adding in individuals or entities pre-verified pursuant to 935 CMR 500.101 subsection 7, comma, social equity businesses, comma, and license applicants that have been designated as social equity program participants or economic empowerment priority applicants.
You all okay with that? Commissioner Camargo, Roy, Stebbins?
Hmm.
Okay, all right. That was a key catch. Thank you, Commissioner Stebbins. Okay. Attorney Baker.
Thank you, Madam Chair.
Can you now repeat? Oh, sorry, go ahead.
I was going to ask if Mercedes could repeat it. I just want to make sure that she captured the wordsmithing there.
Okay.
Thank you. I was just going to ask Attorney Lopez to put that in the chat for me. Thank you.
Good job, team.
It's in the chat. Thank you.
Okay, awesome. Okay, now, Attorney Baker, can you repeat or actually just restate section C? We'll just continue from there, but with the edits, and then we can continue throughout the municipal equity section.
Okay, I'm going to read this in piecemeal, so I'm sorry, but bear with me. So now it's subsection C here. A municipality or host community shall adhere to best practices for HCA negotiations with individuals or entities pre-verified pursuant to 935 CMR 500-1017. Social equity businesses and license applicants that have been designated as social equity program participants or economic empowerment priority applicants, including but not limited to the following. A host community shall develop a standard evaluation form or use a form developed by the commission that scores components of an application. The evaluation form shall include consideration of equity in overall evaluation score, which must comprise not less than 25% of the total evaluation score. This equity component shall include: 1, whether an individual, entity, or license applicant is pre-verified or verified pursuant to 935 CMR 500-1017. 2, whether the license applicant is a social equity program participant. 3, whether the license applicant is an economic empowerment priority applicant. 4, whether a license applicant or pre-verified individual or entity has a prior marijuana-related criminal offense or conviction. 5, whether a license applicant or pre-verified individual or entity is part of an area of disproportionate impact as identified by the commission. Or 6, a pre-verified individual is of Black, African American, Hispanic, Latino, Native American, or Indigenous descent, or a majority of pre-verified entity or license applicant entity is comprised of individuals that are of Black, African American, Hispanic, Latino, Native American, or Indigenous descent. Two, in circumstances where a host community imposes a cap on the number of marijuana establishments or MTCs.
Attorney Baker, sorry, let me jump in for a second because I realized that I didn't ask if there was consensus on the edits to the language there. So let me just make sure before we keep going. Commissioner Camargo is a thumbs up. Commissioner Stebbins, are you okay with those edits? Commissioner Roy, okay. Attorney Baker, please proceed.
Thank you, Madam Chair. So 2, in circumstances where a host community imposes a cap on the number of marijuana establishments or MTCs that may obtain local approval to operate, if a host community later decides to allow additional marijuana establishments or MTCs, at least 50% of those licenses, but not less than 1 license above the previously established cap, shall be reserved for social equity businesses, license applicants, or pre-verified individual or entity that have been designated as social equity participants or economic empowerment priority applicants.
I have a question here, and that's in light of our the changes that we had around when we cite CMR 500.101 subsection 7. If we also need to cite that here, because according to AC Lopez, that there's an additional step for you actually to be certified as a social equity business. So what I'm proposing is instead of the phrase reserved for social equity businesses, that we insert reserved for individuals or entities pre-verified pursuant to 935 CMR 500.1017.
Madam Chair, could you repeat that one more time, please?
Sure. So in under 2, I'm suggesting that we strike the term social equity businesses and insert individuals or entities pre-verified pursuant to 935 CMR 500.101 subsection 7. So I will just want to copy it and paste it. It's restating the term that's used in 1, and we're inserting it here instead of using the term social equity businesses. Let me make sure you have that. Okay, Commissioner Roy?
What happens to a community if they have a cap and they issue, let's say, 2 more licenses in the town and no social equity business or any of those identifiable groups apply? What happens to the community in those 2 licenses?
Well, under this, it would have to go to at least half of those, would have to go to a social equity business or SEP or EEA.
But we can't compel them to apply in a community. And if none of them apply in the community, what happens?
Well,
We
you're
can't
saying
compel.
if they lift the cap?
No, yeah, so if there's a cap and then a ABC community adds 2 licenses, ideally one should go to one of these groups. But what happens to a community if no one applies from said groups? What happens to those 2 licenses? If no fault of the community, what happens?
Make sure I'm understanding the question correctly, because we're saying in the event that a cap is lifted, and you're saying that there is now a new cap for only 2?
Pick a number, any number, say they add more licenses and we want to encourage folks, but if we can't compel, and if no one in these identified listed groups apply in a community, are those licenses therefore they cannot, what happens to if it's a no fault of the community, no one applies, what happens to those licenses?
Let me read this section out completely.
Or
let me read this out just so we're all on the same page, and then I can give you like a more comprehensive response. Okay, so a municipality or host community shall adhere to best practices for HCA negotiations with licensed applicants that have been designated. Read the new language, sorry. A municipality or host community shall adhere to best practices for HCA negotiations with individuals or entities pre-verified pursuant to 935 CMR 500.101 subsection 7, social equity businesses and licensed applicants that have been designated as social equity program participants or economic empowerment priority applicants, included but not limiting to the following. In circumstances where a host community imposes a cap on the number of marijuana establishments or MTCs that may obtain local approval to operate, if a host community later decides to allow additional marijuana establishments or MTCs, at least 50% of those licenses, but no less than 1 license above the previous established cap shall be reserved for social equity businesses, licensed applicants, or pre-verified individuals or entities. I know we're changing the term social equity businesses. So we're saying that if there are caps, there's a community that has a cap, they decide to remove the cap. And your question is what, Commissioner Roy?
my question is, they remove the cap and at least 50% or no less than 1, we are saying should go to one of these listed groups.
Right.
If in said community, none of these listed groups apply, what happens? Okay, it's like no fault of the community, but no one applies. So now these licenses sit in limbo, like, so.
It's not saying a 1-to-1 basis.
No, it's saying 50%, no less than 1.
Right, I'm saying it's not saying a 1-to-1 basis, so it doesn't preclude a license or an operator from receiving an HCA in that community just because there's not an equity license also applying it. So, okay, let me clarify that. It's not 1-on-1. The other thing is that what this would do is there would have to be a reservation. So the cap is removed and let's say that host community opens it up. There's no, if they reinsert a cap, that's one thing. If they have a number, let's say they want to open it up to 4 more businesses and you're saying I guess I'm trying to follow.
Can I rephrase it? Can I rephrase it?
Yes, please.
Okay,
yes, please.
Thank you, Madam Chair. A town opens the cap. They lift the cap and they issue 2 more. They have 2 more. Based on this, if I'm understanding it, at least 1 has to go to one of these said groups. Is that
Right.
correct?
Mhm.
Okay, okay. If none of these said groups apply to the community for one of those two, what happens? Are they
Well, I
not able
guess
to?
technically you could expand the cap.
What if they can't? They don't want to. What happens?
I think I know I'm losing you. That's where you're saying they choose not to expand it to allow for other operators?
I'm saying there's only a limit. The town can only handle 2 more for whatever reason. If it's my understanding that one, based on this language, would go to one of this said groups, okay, which is great. But what if none of said groups want to establish a license in that community? Is that town, therefore, they cannot issue a license to any other group? Like they're limited. If one doesn't apply, if they don't award one, then there's none, if none of said groups apply in that community.
And then they have the option to expand.
Maybe the town doesn't have the geography to put 3 or the population. What if they can only do 2?
But you're saying that there aren't any equity applicants.
What if that's the case? What happens to those municipalities with those
Me,
2 licenses?
I'll let some of the other commissioners offer their comments or opinions. Go ahead, Commissioner Camargo.
Yeah, I was just going to ask for a legal interpretation of what's in the document right now.
Do you mind expanding on what you're asking?
Yeah, no, I'm asking, like, we're interpreting it how we're interpreting it. I think Commissioner Roy has a question, so I'm just curious how, because we all interpret things differently. I know what she's saying, but I'm just curious from a legal perspective how they're, how it's written right now, how they're interpreting that.
Madam Chair, sorry, no, I'll defer to Kyle. It seems that he has his hand
Director
raised.
Potvin.
Thank you, Madam Chair. There's definitely, and again, I would invite conversation about this, but there is definitely one way to interpret this. If the cap is increased in the situation that Commissioner Roy is talking about, hypothetically, they now can issue 2 more licenses, and this provision is in effect. Essentially, they could issue 1 license to a business that does not fit within one of these designations. And then hypothetically, the other license that they could issue would not be able to be issued. They would not be able to contract with another business unless they met those qualifications. So in that situation, Commissioner Roy, where I think you were going, is essentially they will have a license or a host community agreement. Essentially, they will not be able to give permission as part of the license application process right now with the HCA to another business until somebody comes to them and fits within one of those qualifications. That's how I'm reading it. That's one interpretation.
Commissioner Roy, do you have a proposed change?
Well, we all received an email, feedback, past the deadline. So I want to make sure that this is recognized, because we received a second email that there was concern that this testimony wouldn't be considered by commissioners. And I think everyone knows, from the MMA what I'm referring to. So,
yes.
right. So I just want to read some of their testimony so we can deliberate over that as a body. Okay. So the draft regulations, it says, should the draft regulations provide an option for or could the draft regulations provide an option for a retention period during which licenses are held and reserved for social equity applications, after which time, if none then apply, they can be issued to other establishments or individual entities. Does that make sense? You want me to reread it?
Yeah, it makes sense. Do you have a proposed change?
Well, I want to just take the temperature of my fellow commissioners and see if there's agreement that we should have a retention period, which are reserved for this as proposed. And if that expires and no such applicants come forward, then they can be issued to other individuals or entities or applicants.
Commissioner Camargo?
Madam Chair, I was going to ask for just a 5-minute break to speak to legal on this matter.
Okay. Commissioner Stebbins, did you want to make your comment now, or did you want to wait until we return from a 5-minute break?
I'm happy to make a motion for a 5-minute break, and my comment or question can wait.
Okay, so 5 minutes, we'll be back at 3:31. So Commissioner Stebbins, can I have a motion for a 5-minute recess, please?
So moved.
Commissioner Camargo, can I have a second? I'll do a call the roll. Commissioner Camargo? You're muted, Commissioner Camargo.
Aye. Aye.
Commissioner Roy?
Aye.
Commissioner Stebbins?
Aye.
The chair votes aye. We are in recess for 5 minutes until, what is that? 3:32. Yeah, thank you. wave around. Got a little bit further than 3:32. Is everybody in the room? Hi, Commissioner Roy, Commissioner Camargo, Commissioner Stebbins.
I am here. Sorry about that.
Awesome. So we're all here. I also have in front of me that MMA letter that you referenced, Commissioner Roy, and I'm glad that you drew our attention to it because that was some really good points that you raised. I think that's also a good time to thank all of the stakeholders for the engagement that they've had throughout the process. So I want to take a moment to thank the MMA as well as Mass Eon, because they submitted written verbal comments, but they also held that regulatory review process, the panel for us, where we discussed things at length and we heard a lot of the members of the MMA and their concerns. So I'm glad you brought that up. And Commissioner Camargo, thank you for printing out these hard copies so that we all receive them as well. Commissioner Roy. You're muted.
Thank you, Madam Chair. In the spirit of fairness as well, I'd also like to read an email from Kevin Gilmack, if I may, as well.
Yes.
Okay. And we just received that. Dear Chair, Concepcion, and Commissioners, I'm concerned that the only comments from stakeholders added to the record are those from MMA seeking to undermine equity policies. Your policy requiring municipalities that change their caps to reserve at least half for equity businesses is a critical tool for advancing municipal equity in line with your powers under the law. If a town doesn't have an equity applicant, it is because it has utterly failed in its equity efforts, and a sign that if it wants to fill that cap, it should improve. The hypothetical concern about unused licenses pales in comparison to the dire stats on the existing ratio of equity to non-equity licensees across the state. Should this hypothetical problem ever arise, the Commission should consider waivers or address this issue at a further regulatory review session, just as you may do with the very sound and seemingly related policy enhancement to change equity plan attestations to reviews. To the department, from 1 to 1 at this point would seem a material change from the published draft. Thanks, Kevin. So I just wanted to enter that in the record too.
Okay. Thank you, Kevin. And thank you, Commissioner Roy. Commissioner Stebbins.
Thank you, Chair. Just thinking through this question, because we want to try to anticipate questions that might come up from these communities, large, small, in between. We might give some consideration in the social, for a community to propose something to us in our social equity plans, how they might deal with these individual situations. I appreciate Kevin's point very much, right? We're trying to even the playing field. We're trying to get more social equity businesses and our SCP and EE program participants into the industry. But I'm thinking of what that mechanism might be, and I keep kind of going back to what a community's social equity program plan that they're going to give to us might look like.
Commissioner Roy, you brought up an idea, and this is probably the MMA's idea of tweaking this so that there's a time frame or a time period where essentially that restriction is dissolved or removed because of an inability to attract equity businesses. Have you had any thought in terms of that time frame?
I have not, and I guess my concern is if that provision as it stands, would it be able to hold up to legal scrutiny the way, like to protect the Commission? Would that provision as it stands be able to hold up to legal scrutiny? And that's the question that I put before my colleagues. And if we think for a minute it might not, then maybe this other provision, and I don't have a time frame in mind, so this would be the debate. Or discussion.
Counsel Lopez, Director Potvin, or Attorney Baker. I welcome any of the three. Okay, I see Enforcement Counsel Lopez to and Director Potvin. So either to sort of give us some additional guidance in terms of any legal implications if we have the authority, other things that we should be mindful of. EC Lopez, please.
Thank you, Madam Chair. I would invite any of my lawyerly friends to chime in here. However, I would say that, authority isn't as much of a question here. You do have the authority to promulgate policies and procedures to promote equity. The legislature was very clear about that. What the time period is a policy decision for the commission to make.
And my apologies, Attorney Carter. I didn't realize you were still there. Yes. So also, if you have any additional comments as well.
Yes, if I may, Madam Chair. I think the question as it relates to timing, and this is also to Commissioner Roy's point and EC Lopez's point, is that is the matter before us for the policy debate. So I think that ultimately your comfort level is up to this board.
Commissioner Roy, was that did that answer the question that you had?
I think so. So it would withstand legal scrutiny, I guess is the answer. This provision would withstand legal scrutiny as is. I think is that the answer?
Attorney Carter?
Sure. As Councilor Lopez said, it does tie to the statute. So, of course, any reg that we promulgate, right, there is some degree of challenge, and but the work of this board, right, is to make sure that what we promulgate is consistent and within our statutory authority, and that is the safest place for us to operate.
Commissioner Roy?
So, Madam Chair, did you propose a question to the group about a time length in the retention period?
Yes, but I was asking you just because I know that you offered this. I just wanted to know first from you if you had something in mind, and then I'll open it up to Commissioner Stebbins and Commissioner Camargo as well.
I don't have a quantifiable time period in mind. I would defer to my colleagues to have a discussion if they're so inclined.
Commissioner Camargo, Commissioner Stebbins?
If I could be fully honest, which we all are, try to be, I need a break.
Let's take a break.
I think we need a little bit of break. This is a key question, and I think we're going to go as long as we can tonight. So I can give you a more definite answer, Commissioner Roy and Concepcion, if I could think a little bit, at least, again, to add my 2 cents, but I need a break.
Okay. Commissioner Camargo, how much time are you proposing?
Well, I don't know. I mean, I don't want to be selfish. I don't know if other folks need a break too or want a break. If folks don't want a break, we could take a 5-minute break, but I would leave it open to the colleagues and to yourself.
I'm thinking about taking probably a little bit over a 15-minute break. So until 4:15, and then we can complete municipal equity. Probably take another break before we go into suitability. Get into suitability, and then we'll sort of take a temperature there about whether or not we want to have the closing considerations at that point. But for now, I think we should take a 15-minute break. I agree with you, until 4:15. So Commissioner Camargo, do I have a motion to recess until 4:15?
So moved.
Commissioner Roy, do I have a second?
Second.
I'll call the roll. Commissioner Camargo?
Aye.
Commissioner Roy?
Aye.
Commissioner Stebbins?
Aye.
Chair votes aye. We are recessed until 4:15. I will see you guys soon. Commissioner Roy, Commissioner Camargo. Oh. It doesn't have to take down it. It's a battery here. Okay. Where were we? Attorney Baker, bring us back to where we left off in
Sure. Thank you, Madam Chair. So we're on subsection 2. In circumstances where a host community imposes a cap. That's where we left off.
Thank you. Oh, so page 77, C2.
Yep.
All right, I'll open this up again. Are there any comments, questions that fellow commissioners want to make at this point? Commissioner Camargo.
Sorry. I don't know, Madam Chair, what your next direction will be for us, but I would say, I know this one we're thinking it through and we're kind of letting it air out. I would also recommend that if need be, we can put a pin on it and finish the section, kind of read through the section and come back to it. Maybe it'll give us a little time, and reading through everything else, it'll allow us to figure out the balance with this specific section.
Okay. No, I agree. I think this is an important one. It's a major conversation. I think we need to flesh it out more. So we'll put a pin in it for now. Attorney Baker, with that being said, can you go on to section D, please?
Yes, thank you, Madam Chair. So D, as it stands now, reads, and again, this was changed before, so it reads, host communities must adopt local rules or bylaws to comply with this section on or before May 1st, 2024. A host community must submit an attestation in a form and manner determined by the Commission, affirming that it has adopted local laws to effectuate compliance with this section and identifying the specific laws passed. And then I have, in addition to the attestation, the host community shall submit all plans. Actually, I think Mercedes has different language, but 1 second, going back to the chat. Sorry. In addition, host community shall submit its equity plan and any other documentation of its compliance with the section.
Thank you, Attorney Baker. My one note is the very beginning, the second line where it says a host community must, it should be edited to read a host community shall submit.
Okay, that is noted in the correct version. And if commissioners do not have any issues with this section, I could go to subsection E here. Okay. E reads, any interested person may file a complaint with the Commission alleging noncompliance with an equity requirement under 935 CMR 500-181. 1. If the Commission substantiates an allegation of noncompliance with 935 CMR 500-181, a host community shall be fined after first receiving notice and an opportunity for corrective action pursuant to 935 CMR 500-310 and 935 CMR 500-320. The host community shall be fined an equal amount to the annual total of community impact fees received from all marijuana establishments and MTCs operating in the host community during the prior calendar year. A, the commission shall afford a host community a right to a hearing pursuant to 935 CMR 500. B, all fine.
Hold on, Attorney Baker. I see Commissioner Camargo. I believe you had your hand up.
Just Attorney Baker, you kind of came out the gate really quick. You're reading what section right now?
Sure. So we are in the last subsection here, but of 3.
Of 3. Perfect. Okay. We're not.
And
Okay.
so
Thank you.
it was D originally, but now I believe it is E.
Got
and
it. Yep.
reads any person. So
Thank you so much.
of course. And if there are no questions, I'm just going to keep going from where it was. So I'm on the A, B, and C. So A, the commission shall afford a host community a right to a hearing pursuant to 935 CMR 500. B, all fines collected shall be deposited into the Cannabis Social Equity Trust Fund established in Section 14A of Chapter 94G. C, the commission may publish a list of any municipality or host community that has been assessed a fine fine for equity noncompliance. Or D, fine assessments pursuant to this section shall take effect no sooner than May 1st, 2025. And if there are no further considerations for the section, I can move down to subsection 4 of the Municipal Equity 181. That reads, equity standards for host communities during HCA negotiations with social equity businesses and licensed applicants. Social equity businesses, licensed applicants, and individuals and entities pre-verified by the commission. A host community shall prioritize negotiations of HCAs with equity parties. The equity party in a negotiation of an HCA for an application for licensure is a licensed applicant that has been designated as a social equity program participant, an economic empowerment priority applicant, or both. The equity party in a negotiation of an HCA for an application for renewal of a licensure is a social equity business. The equity party may also be an individual or entity pre-verified pursuant to 935 CMR 500-101-7. See Commissioner Camargo.
Yeah.
Commissioner Camargo, please.
Thank you. Equity parties. So a host community shall prioritize negotiations of HCAs with equity parties. It's the first time that we hear equity parties. Does it need a definition? Or is it assumed?
And first, Council Lopez. I think you're muted.
My apologies. Are we in section 4A?
Yes, we are in 4A.
Yeah. So thank you for the question. I will just note this is the first time that we're introducing the term. We followed we did a similar structure for the host community agreement section, that once we get to the part of the regulations where we're talking about negotiations between parties to a contract, we do lay out who the parties are for purposes of this section. And that's the reason why equity party was introduced in 4A for the first time, because we're spelling out for these negotiations on this HCA between the two sides, who are the two sides. That way we don't have to necessarily say, you know, all of the different potential equity parties, which here would include SEBs, licensed applicants, STPs, EEAs, etc. So that was the reason why we chose the term equity party and spelled out kind of the landscape of who is in these negotiations in 4A. So I just wanted to provide you with that background.
Thank you, E.C. Lopez. Commissioner Camargo, did you have an additional question, or did that address your?
Yeah, I guess my question is to the body. Is that sufficient as it reads and as it interpreted by, you know, Like, do you all feel like that's enough? Just, I guess I'm asking just because we all interpret things differently.
Well, no, it spells it out here. So that section describes what an equity party is.
Yes.
Maybe I'm confused by the question.
No, I'm
You might
sorry.
be phrasing the question.
No, I'm sorry. I know it's defined here. And I hear, Rebecca, what you're saying. I'm good with it. I just wanted to make sure that that we're all on the same page. I guess it makes sense to everybody. I know it's in here, but just want to make sure that it being here is sufficient and it doesn't need a definition. Sounds like that's what Rebecca said. Yeah, okay.
Sorry. Are there any other questions or comments from Commissioner Stebbins or Commissioner Roy at this point? No? Okay, all right.
Sorry,
Commissioner
Chair.
Stebbins?
I'm just wondering up above where we talked about under, I think, the new C, we talked about municipality or host community shall adhere to best practices in HCA negotiation, and we added social equity business. Do we need to do that here as well? I know the social equity business is mentioned in the next sentence, but
Commissioner Stebbins, when you said we need to do this here, do you mind stating where here is?
sure, in 4A, where we're talking about prioritizing negotiations of HCAs with equity parties. The equity party in negotiation of an HCA for an application for licensure is, again,
Yes.
this is up above in C is where we made sure we reference social equity business. And I just want to make sure we're not missing that down here as well.
I agree with you. But I'll also see if there are any additional comments from anyone else as well. But I believe we should also include the same language. I'll ask EC Lopez. Actually, I'll read this out loud. Most communities shall prioritize negotiations of HCAs with equity parties. The equity party in a negotiation of an HCA for an application for licensure is a licensed applicant that has been designated as a social equity program participant, an economic priority applicant, or both. EC Lopez, do you mind restating the language that you provided previously around pre-verified individuals and social equity businesses? I want to make sure that we continue to mirror that same language throughout to avoid any confusion.
Is the concern that the last sentence is not clear enough to note that an equity party is also a member of that group?
Oh, I see. I'm going to stop. Okay, sorry. And it says the equity party in a negotiation for an HCA for an application for renewal. But is one speaking? Oh, I see. We've had so many conversations in the last few weeks, and we talked about this. I do believe we made sure that it was included, but Commissioner Stebbins, I'll just ask you to just take another, just review it one more time to see if that language aligns with what you want to make sure is covered.
Madam Chair.
Yes, Commissioner Stebbins.
Sure. I'd look at that sentence that begins with the equity party in negotiation of an HCA, but then it goes on to state for an application for renewal of licensure is a social equity business. Is that Enforcement Council? Is that too limiting? Saying that they are, the way I would read that is somebody already has to be a licensed establishment and they're going for renewal, but then yet they're negotiating an HCA. That I might be reading that incorrectly, but that seems a little confusing.
I just see that Director Poffin has turned on his camera, so I'll give him an opportunity to. No? Okay, just kidding. So, yeah, Commissioner Stebbins, I guess my question is, so renewal of licensure will involve potentially renegotiating an HCA or, I mean, yeah, it will involve potentially renegotiating an HCA. So I guess the question is, a license applicant is not going to be renewing anything because they're still a license applicant. Social equity business is a marijuana establishment, and it's a marijuana establishment comprised of individuals that either qualify for SEP already or EEA or both. So for that reason, we put that the equity party in a negotiation of an HCA for a renewal application would be a social equity business. But is there some other group that's missing that you would like to include?
Commissioner Stebbins.
Sure. I appreciate that explanation. Thank you. Then I'll go back to kind of my previous question, which is, are we missing including social equity business as we had amended up above in that first line, which says host communities shall prioritize negotiations of HCAs with equity parties. The equity party in negotiation of an HCA or an application for licensure is a licensed applicant that has been designated as a SEP program participant or economic, and I'm not sure we need to add empowerment there, but economic priority applicant or both. So in that sentence, I'm wondering if we're missing an appropriate reference to a social equity business like we had amended up above.
Madam Chair.
Director Poppin.
Thank you. I'm caught up, and thank you to my outstanding colleagues. And my apologies for returning late. So my understanding, Commissioner Stebbins, we're talking about equity standards for host communities during HCA negotiations with social equity businesses and licensed applicants. And essentially, it is 500-181 4A that you are talking about, where a host community shall prioritize negotiations with equity parties.
Right.
That is not a defined term as it is not capitalized. However, I think it was intended to encapsulate social equity businesses by the Municipal Equity Working Group, but I will defer to Chair Concepcion. However, the following sentence does go the equity party in a negotiation, and that it does further on designate social equity program participant or economic priority applicant, which I do agree. It probably should be amended to be economic empowerment priority applicant or both. Because of and this is where probably more likely than not, this is a policy determination by the commission, is whether pre-verified or verified social equity businesses, as the title of this subsection, the section outlines, whether you as a board want to adopt a policy to include in that section verified social equity businesses and or pre-verified social equity businesses.
Director Poppin, I'll jump in. I think I hear what you're saying, Director Poppin. Commissioner Stebbins, I think what you're pointing out is a drafting error. And so the intention was to also include social equity businesses or those who will qualify. But I see that the way that this reads, we're talking about two scenarios. One is for licensure, which I read as being the initial licensure. The next thing being renewal. And social equity businesses is only considered in that second scenario for renewal and not for licensure. And I'm seeing how this could read this way,
And I wonder if that's what you're flagging, Commissioner Stebbins. Is that what you're seeing?
Chair, yes, it is. And again, I know we had a conversation up above where we're talking about HCA negotiations. We're talking about adhere to best practices in HCA negotiations. And that's where I think, and I got to go back and find the language, but I think that is where we had added social equity businesses in that paragraph. It just seems to make sense to reflect it here also.
I agree. I think that it's a little clunky right now. The intention is to include that entire universe, but it's not reading in the way that it's intended. So I thank you, because you're flagging something that would have otherwise been missed. So I'll read the section out again. Also, I'm sorry if you're hearing that beeping. I will fix it if I need to take a step back, but tell me if you hear any loud beeping. All right, so the section currently reads, a host community shall prioritize negotiations of HCAs with equity parties. The equity party in a negotiation of an HCA for an application for licensure, and this I read as licensure, initial licensure, is a licensed applicant that has been designated as a social equity program participant, an economic, will insert empowerment priority applicant, or both. This does not speak to social equity businesses or someone who would qualify as a social equity business. So I'll put a pen there. The next line, the equity party in a negotiation of an HCA for an application for renewal of licensure is a social equity business. The equity party may also be an individual or entity pre-verified pursuant to 935 CMR 500.1017. Oh, now I'm misreading this. Wait a minute now. Okay. I will paraphrase the way that I'm interpreting this now that I've said it out loud. Reading out loud sometimes is really helpful. We're saying that the first step, there are SEPs and EEAs. After they've been licensed, at the point of renewal, they become social equity businesses, or at least in our universe, they are considered social equity businesses. And the final line says that a party, period, whether it be for licensure or renewal, can be someone who is pre-verified or who is an equity party may also be an individual or entity who's pre-verified pursuant to 935 CMR 500.101 subsection 7. And okay, Director Potvin.
Thank you, Chair. So when I guess the universe of pre-verified or verified as a social equity business, the major distinction there is whether they're licensed or not. So I guess from a policy perspective is if they're not licensed, the pre-verified aspect of that is more essential during the initial application for licensure, if you're intending to give benefits. If they are renewing, I do see a scenario where they could be verified through 500.101.7. They could already be verified, but I also see a scenario where they're not, in fact, they haven't sought verification. They're still pre-verified. So regardless of the definition, they might not have that actual determination in their hand. So I do see a scenario where there's new license applications, pre-verified is essential, if that's your policy objective. And for license renewals, if your policy objective is to ensure access and to ensure benefits, to include pre-verified and verified to make sure that we capture the entire population that's possible.
Commissioner Roy.
Thank you, Madam Chair. Director Potvin, so let's say in a community, you have a designated, a certified social equity business that has a retail establishment and they have a host community agreement. And now they want to open a product manufacturing, which could have different impacts, and they may need a separate host community. Shouldn't those folks be prioritized as well? And are we capturing it? Are we maybe I just want to make sure we're capturing folks that are already established as SEBs, that they're not a new licensee and it's not a renewal of their existing license. They're going for another license. And I just want to make sure that they're in there. We don't miss these folks.
Madam Chair, may I?
Yes, please, Director Buckley.
I think that's definitely one way to interpret that, because when they're applying for that second license, that supplemental license, they are in fact an applicant. However, there could be room to also include pre-verified and verified small social equity businesses, just to ensure that it's clear and abundant and that nobody is left behind. But ultimately, I will defer to EC Lopez or Associate General Counsel Baker for some type of legal analysis on that.
EC Lopez.
What is the legal question? If someone could just state it, please.
Madam Chair, may I?
Yes, please.
Thank you. So EC Lopez, essentially it's under it's essentially pertaining to the prioritization of negotiations of HCAs with equity parties, whether it's new license applicants or licensees that are already in existence to come into compliance, whether based on 500-1017, whether we should include pre-verified social equity businesses and verified social equity businesses, or some type of combination in both instances. And one of I think for essential clarity and to ensure that we are not, at least from a policy perspective, if the commission so chooses, that they're not incidentally negating a population based on that policy change that happened a couple of days ago. One recommendation would be to include, if the commission so chooses, to include both pre-verified and verified social equity businesses, both for new license applications and renewal license applications.
So whether to include the pre-verified group for in terms of whether these equity standards for negotiations should apply to the pre-verified group in both HCA negotiations relative to the initial application and the renewal application?
And the reason why, and I think I know where you're going, because the definition of a social equity business is a licensed marijuana establishment, but it's the fact that they might have gotten pre-verification as a decision from the commission. And never saw actual verification from the commission once they were licensed.
So now now we're imagining a pre-verified group that has gotten licensed. Wouldn't they be a social equity business?
They would be definitionally, but they would not have necessarily applied or sought actual verification in a decisional type of situation. So the thing that they're holding in their hands from the commission, at least from a determination, is that they're pre-verified, and once they got licensed, they never sought actual verification. So the thing that
I don't think that matters, because if they haven't gotten verification from us as a social equity business, oh, I see. Wait, you're saying a pre-verified individual or entity gets a license, decides they want another license. But before they go for that other license, they don't come back to us for verification as a social equity business. So they don't have the advantage of bringing that into their negotiations for the second license.
Exactly. So to ensure that everybody that qualifies for this, at least from a commission policy point of view, if the commission so chooses, to make sure that the actual people that are intended to get the benefit, regardless of technicalities, to include pre-verified and verified social equity businesses based on the status of what they got from the commission, is included not only in new license applications, but also renewal applications in that small population of chance. So that it increases government efficiency and makes sure that the policy that the commission may adopt is actually accomplishing its goals and nobody's suffering from a technicality of language.
But in this second scenario that I just described, that person wouldn't be negotiating for a renewal because they haven't gotten their second license yet. They would be a licensed applicant who's been designated as an SEP or EEA, which would be captured in the current language.
If you think it's covered, that's why that's the legal analysis that I was deferring to.
Okay, well, that's what I was trying to understand is the scenario. So in the scenario we're talking about, person is an SEB. They want to pursue a second license, but maybe they didn't get verified as an SEB. And they're trying to enter into negotiations with an HCA. That wouldn't be a negotiation for a renewal of an HCA. That would be negotiation for a new application for the second license that they're seeking. And in that situation, oh, sorry. In that situation, wouldn't they be a licensed applicant that has been designated as an SEP or EEA?
Potentially. So that's the interpretation question. So yes, by definitional purposes. So I think it's again, technicalities. Let's remove the technicalities and let's make sure that it intends to do what it's supposed to do if the commission so chooses. So they would qualify as a social equity business because they're already licensed. If they were pre-verified, they meet the other criteria, and now they're licensed. Technically, definitionally, they are a social equity business. So I think it's just the technicality of the language.
So I guess my question to that is I thought I heard Commissioner Stebbins say this before, is the thought then maybe that the first scenario, negotiation of an HCA for an application for licensure, is a licensed applicant that has been designated as a social equity program participant, an economic empowerment priority applicant, or both, or social equity business, is the desire to add social equity business to that to kind of cover everything? Because I think a social equity business already has that designation. So a licensed applicant who's a social equity business would already have one of those designations, I believe. So I guess I'm trying to understand what the objective is.
Hold on. Let's pause because Commissioner Stebbins is patiently waiting.
Sure.
Commissioner Stebbins.
Thank you. Enforcement Counsel Lopez, I think what you're suggesting might solve the problem or the question I'm having. I hate to do this, but I think we need to go back and look in our definition section of what a social equity business is. Right now, as I read it, it only speaks to folks who have been in the SEP or economic empowerment. And I don't see the mention of the verification process that we're talking about. And I want to make sure that definition is clear, and maybe that helps clean up some of this.
Somebody want to yell out where that definition is if you found it?
Page 19.
Thank you.
So there are a couple definitions that there's social equity business. There's a definition for verification on page 20. And I will also put my head down. So if anyone's trying to speak, let me know. Okay, and then there's also a separate, there's a definition for pre-verification that does not relate to this conversation, but I flagged that on Monday as well. So right now, the definition for social equity business on page 19 says a social equity business means a marijuana establishment comprised of at least 51% majority ownership of individuals who are social equity program participants or who have been certified as meeting the Commission's criteria for designation as an economic empowerment priority applicant or both. Commissioner Stebbins, do you mind offering your comment again about this definition?
Sure, and there's been a lot of discussion about, a pre-verification or verification process for social equity business. I just want to make sure that we're capturing all that in this definition of a social equity business, because I don't want anybody to look at this as this is just a designation for somebody who's been through our social equity program or previously was certified as an economic empowerment priority applicant. And I think what we're trying to pull into the picture here is somebody who would qualify, but hasn't actually gone through those two steps.
Thank you, Commissioner Stebbins. What I would offer, and this is something, there've been a few different iterations of this draft language, but I guess I'll re-offer it and I'll do it with the entire group, is that we pull from the actual statute, because the statute does have a definition. I'll read it out loud. I don't know if the whole thing went into the chat. Chapter 180 defines a social equity business as a marijuana establishment with not less than 51% majority ownership of individuals who are eligible for the social equity program under Section 22 or whose ownership qualifies it as an economic empowerment priority applicant as defined by the Commission's regulations promulgated pursuant to Section 4. And I think the key words that we should probably inject here are the who are eligible. So what I would propose, and this speaks to your comment, Commissioner Stebbins, is that we amend the definition to read social equity business means a marijuana establishment comprised of at least 51% majority ownership of individuals who are eligible, I guess, who are eligible for the social. But this is what happens.
Chair?
Yes, yes, Commissioner Roy.
Yeah, what if we just reverse the strikeout of or otherwise eligible? Would that, we struck, like, what if we undid that? Would that cover it?
Oh. Send you a virtual hug. Yes.
I'll hug you back.
Okay. Commissioner Roy. Yes, I believe so. Commissioner Stebbins, do you think that I'm like, I know we wrote that somewhere, and lo and behold, it is right here in front of us. It is taken away that strike through.
Yes, if we undo it.
And I apologize. I'm not.
It's
Maybe
so
I'm not seeing it.
Commissioner Stebbins
okay.
on page
in the
19.
hardline version. Yeah.
Yeah, in the hard, yes. Clearly, I need more coffee. So my apologies.
So you're saying, if I may,
Yes, Commissioner.
just so we're on the same page, we're saying that it's stricken right now, but to leave it in.
We're saying you're
Yes. Got it.
Or
Okay.
otherwise
Yeah.
eligible.
Got it. Or otherwise, yeah. It's right there.
Big shout out or hug to Commissioner Roy. The other thing I would suggest, do we need to expand it to mean a licensed applicant or a marijuana establishment? Because I think that might feed into the question I was having around the HCA negotiation.
But I was just gonna make a comment.
Go ahead, Commissioner Camargo.
I'm like, Commissioner Stebbins, give us one thing at a time.
Sure. First, I agree with reinserting the language that's stricken in our hard copy, or at least my hard copy, or otherwise eligible.
Okay.
Put that back in.
Okay.
At the beginning of the social equity business definition, I am asking whether it should be social equity business means a licensed applicant or a marijuana establishment comprised of at least 51% majority ownership. Read out the rest of that. I think that might help us solve our wording around the HCA negotiation, but
So your suggestion is so an applicant can also be a social equity business.
that's the question I'm asking. Yes.
That's what you're asking. Enforcement Counsel Lopez.
Thank you, Madam Chair. That would be an expansion of the definition intended by the legislature. The legislature had a definition of social equity businesses that was limited to marijuana establishments, licensed entities.
Okay.
And Enforcement Counsel Lopez, I'll pose a follow-up question. So the original language was taken from Chapter 180, but I just want to confirm that this would not expand the universe beyond what is prescribed under Chapter 180.
Restoring or otherwise eligible?
Yes.
I'm not sure, because Chapter 180 is saying it's a marijuana establishment with not less than 51% majority ownership of individuals who are eligible, which when we tie that back to marijuana establishment, that implies to me someone who has gone through our social equity program, has been certified as eligible for a social equity program. The follow-up clause is whose ownership qualifies it as an economic empowerment priority applicant, which also implies to me that it's a person who has been reviewed and vetted by the commission and determined to qualify for the economic empowerment priority applicant. So the plain language, who are eligible, whose ownership qualifies it, those are present language terms saying that a decision has been made, a determination has been made, a qualification or eligibility determination has already been rendered, and the marijuana establishment is licensed. So I don't think that the commission has the authority to go beyond the plain language of the statute to use the definition of social equity business to capture another group, which is why I believe that the efforts were made to incorporate the pre-verified language, because what you're doing is you're creating this group and you're still reaching this group. You're just not doing it through the social equity business definition.
So I will paraphrase very quickly. EC Lopez, the strike should remain. That's your legal advice, is to not reinsert the language that was stricken.
That would be my counsel, yes.
Commissioner
Take
Stebbins.
those hugs back.
Commissioner Stebbins.
I'm sorry, I might be jumping the gun a little bit. I'm just going back into Chapter 180. So I'll pass on my hand being raised. Sorry about that.
Okay, were there any other comments? Commissioner Camargo, Commissioner Roy?
Is Attorney Carter here? No, okay, that's fine. No worries. I can ask him later.
Can you hear the beeping? Okay. 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 So we have to keep going. Based on counsel from EC Lopez, I would follow that recommendation, but I want to hear what my fellow commissioners for the definition of social equity business. What your thoughts are. And in Commissioner Stebbins, we came back to this definition. Do you mind refreshing our memory? What was the objective that you wanted us? Why were we? What did you want us to look back at this definition? I'm asking you this because I want to see if there's another way that we can still meet, and satisfy the intentions that you had.
Sure, thank you. I'm looking at the definition in 180, and again, I apologize if I'm.
Madam Chair.
Yes, Commissioner Roy.
So if I understand EC Lopez explanation, it's the term marijuana establishment, which boxes us in as a commission, that boxes us in where we can't put or otherwise.
EC Lopez?
Yes, Madam Chair. Thank you, Commissioner Roy. It's the term marijuana establishment. It's also the phrase who are eligible and the phrase whose ownership qualifies it as. Neither of those are future looking phrases.
Commissioner Camargo.
This may be, I'm just going to ask the question, it doesn't matter. But if we were to add, and again, maybe it's not even relevant, but I'm going to just say it out loud. If we were to add or otherwise eligible, does that include what doesn't even, I was going to say, does that include an ancillary service, like an ancillary vendor? And it may not be relevant to this section, but I'm thinking. It says social equity business means the marijuana establishment is what we're boxed into. So it's nothing beyond a marijuana establishment.
Madam Chair.
Repeat that one more time, Commissioner Camargo.
So here, I was just thinking where it says or otherwise eligible, right? Like, who is that? Who are those? If we were to put that in there, who's that universe? But it sounds from what our legal counsel is saying that we're boxed into marijuana establishment per the statute in terms of the language. So it can't be right. Nothing. It has to be a marijuana establishment, which means any of our licenses.
Yes, Commissioner Roy.
Okay, I'm having a little brain freeze. An ITL is an ME. So an ITL. I'm just trying to find us a window somewhere, But
oh, you're saying an ITL is an ME? Yes, a marijuana establishment. Yes.
Yeah, I'm just trying to get creative and.
But that's why I'm so. We cannot get creative with the statute, right? So that's why I was asking, maybe there is another place here where we're able to satisfy Commissioner Stebbins' objective. That's why I asked sort of the question about what are we trying to get to, Commissioner Stebbins?
Sure, thank you, Chair, and like it when we try to think out of the box. I want to go back to the definition of social equity business, not to revisit this again, but in the statute, it says a marijuana establishment, retailer, cultivator, testing lab, product manufacturer, with not less than 51% majority ownership of individuals who are eligible for the social equity program under Section 22, or whose ownership would qualify it as one of our economic empowerment priority applicants. I think, and I apologize if I missed something in some of the explanations, but I think we need to add back in that or otherwise eligible to comply with Chapter 180. And again, I apologize if I missed something in the other explanations, but
Commissioner Camargo, I see your hand, but I'll ask EC Lopez if she can explain again why this would be an expansion of the statutory definition, please.
Sure. Thank you, Madam Chair. So as I stated before, the marijuana establishment is already licensed. Is already a licensed entity. It's saying here that the individuals in that marijuana establishment are eligible, meaning that the commission has made an eligibility determination, or their ownership qualifies them as an EEA, meaning the commission has qualified them as an EEA. Neither of those phrases are future looking. They're referring to a present status or a determination that has been made. So if you say or otherwise qualifies, that is a future looking phrase. You're saying or that could conceivably hypothetically qualify, and that is not what the statute covers.
Thank you, EC Lopez. And
okay.
I remember your explanation before as well. Commissioner Stebbins?
Sure, and thank you for that. And again, I was probably on this screen doing a little bit of homework and didn't catch all of that. But that who are eligible for the social equity program is missing from the definition we currently are considering.
That's true. We could insert the word eligible to read the same way. Social equity business means a marijuana establishment comprised of at least 51% majority ownership of individuals who are eligible for the social equity program or who have been certified as meeting the commission's criteria for designation as an economic empowerment priority applicant or both. We could do that, but to EC Lopez's point, it doesn't change the narrow interpretation to mean already deemed who are eligible as opposed to who may be eligible.
So, sorry.
Yes, Commissioner Stebbins.
Thank you. So,
and Commissioner Camargo, I see your hand, but yeah. Commissioner Stebbins, yes.
So, Enforcement Council, I just want to go back. So, the way the definition, and I think this will bring some final clarity of this to me. The way the legislature wrote this new definition of social equity business, they are essentially writing it in a way where it's not people who might be eligible, it's people who have already gone through our social equity program and have been certified.
Enforcement Council Lopez.
Your understanding is correct, Commissioner Stebbins. When we are interpreting statutes, we take the language at face value and we rely on the plain language unless it is ambiguous. Here, if the legislature wanted to say might be eligible, then we would have relied on the legislature to say might be eligible. But in this case, the legislature did not say that. They said who are eligible or whose ownership do qualify.
Thank you, EC Lopez. Commissioner Camargo.
Yeah, I want to introduce something, but I think it's probably out of scope and may need to wait for the next regulatory round, but I think it almost relates to Commissioner Stebbins' point right now. But then also it sounds like Rebecca's saying that per statute, it's for people who are deemed eligible. So I want to drop this. I think I can drop this in the chat. Give me 1 second. And it's basically, and I don't know if this will be helpful to us right now, but because we're having the discussion, we're flushing this out. We're almost missing an equity participant definition. And let me just kind of walk you through that. And again, it may be out of scope and it may not have proper place right now, but I think it's a little bit of what I'm hearing Commissioner Stebbins talk about a little bit. So this would be something like an equity participant means an individual who has been certified as meeting the commission's criteria for designation as a social equity program participant and economic empowerment priority applicant, or both, and receives all the benefits of the social equity program the social equity program participants if the business is, whatever, 51% or whatever it is. But I'm introducing this. I'm sorry, I'm not looking at you right. I'm not looking at the screen right now. Did you say something?
No.
Oh, okay. Okay, sorry, I was reading. Because sort of like in this definition, the social equity business means a marijuana establishment comprised of 51% majority ownership of individuals who are social equity program participants. So these are folks that are already program participants, and I know what the statute says. And I think what I'm introducing is out of scope, but I kind of wanted to just put it there to think about it because I think it relates to some of this. And I'll just really briefly, if we had an equity participant definition, it would basically be almost sort of, and in the bottom, I wrote the verification of equity participant. It would almost be the same way we're verifying a social equity business, we would verify an equity participant sort of year round. So they don't have to wait to sort of jump into the cohort. They would be verified as an equity participant in the process. So it could be a little confusing because I'm adding it now, but I put the language in there because I think for the future, because I was told that it's out of scope. So maybe for the future, we can look at this as well. Because when I think of in the language right here in the social equity business, when I think about or otherwise eligible would be an equity participant. That may not let, I'm sorry, go ahead.
No.
Oh,
I'll let you finish.
Yeah, when I see or otherwise eligible, that's what I was thinking, sort of an equity participant that we would sort of pre-verify as a social equity, participant. So I'll stop there because I know it's a lot, but I wanted to just introduce it as well.
Thank you, Commissioner Camargo, and thank you for putting it in the chat, and we can think about that as we continue throughout, our responsibilities and roles. I want us to get forward. So I need to, right now we're at this definition. We've heard from our counsel, from enforcement counsel on our ability here on what we can add, what we can move, what we can shift. I want us to get to the next part now because we still haven't finished municipal equity. We still have agent suitability. We still have to cover a good amount of provisions that are within this draft. And I know it's 5. I told everyone to be comfortable because we'll be here for a while. But the quick, as long as we keep on pushing, we can kind of close things out, hopefully. With that said, I hear enforcement counsel, and I do propose that we continue with that strike through, with that language stricken. And I'll stop here because I see Commissioner Roy. Commissioner Roy?
Madam Chair, I think we changed the threshold in our definition. Unless it's in statute and I missed it, of social equity business, because when I'm reading the EEA, it's over 50%, not 51. So somebody could own 50.01. So we're making the burden harder and higher. Is it 50.01? Why are we putting it to 51?
It's the statute.
51?
51 is within the statute. The statute says that a social equity business is a marijuana establishment with not less than 51% majority ownership.
So then is it at odds with our definition of EEA, which says over 50? Is there a rub?
Director Potvin.
Thank you, Madam Chair. As it stands now, prior to the promulgation of the regulations before you, the changes right now, we have historically, as staff, interpreted majority ownership as anything greater than 50.000%. However, that, because of what Chair Concepcion just stated, that there is now a rub, because now by statute it's 51%. I don't think, based on my experience and based on my knowledge, and again, speaking just off the hip right now, there's a lot of businesses that may be affected, but there are some businesses that may be affected that might have that 50.1% that have gotten benefits and now possibly may not because of statute.
Director Potvin, for EEAs, that would require a statutory change, would it not?
So it depends. So it depends on how you use the term social equity business, how you apply it to different sections of the regulations. So if you're talking about benefits in, say, the fee waiver section of 500.005, if you're talking and you add social equity business or pre-verified social equity business in that sense, it would require 51%. However, as policymakers, the language that's there right now is majority ownership, which would still technically, from a mathematical standpoint, be anything greater than 50.000. Anybody who fell within that gap of between 50 and 51 would not definitionally, legally qualify as a social equity business by the statute, but the policies can still extend to them if you so choose.
Commissioner Roy?
I just wanted to highlight that, Rob. So thank you, Director Potvin.
And Madam Chair, if I may?
Yes, please.
Again, speaking off the hip right now, I do know there is a population of businesses that would fall into the section, but it is not large.
Director Potvin, would we need to make changes within our existing regulations to remove that rub, or can that be done outside of regulations?
So as it stands right now, the things that have been unchanged is, for example, the definition of an economic empowerment priority applicant, which again, just going off my recollection, does require that. It uses the term majority ownership.
Okay.
That would, in fact, in order to get you to let's just use that example, that would require a regulatory change to be 51%. However, I don't know if that's permissible because of whatever definition was in Chapter 55 of the Acts of 2017.
Okay. Commissioner Roy, what are your thoughts?
I think it's complicated. I mean, I don't know. I identified the rub, but I don't know how to necessarily. Is there a Band-Aid that we can put on? Director Potvin?
For consideration, thank you, Madam Chair. For consideration, the Band-Aid is essentially, we're using multiple terms to identify essentially, but a little different, the same population of people, the people who have been harmed by the war on drugs. And there's different criteria for the social equity program that was in statute for the economic empowerment priority applicant. That is also, now we have social equity business. So it's not apples to apples directly. However, if you want a policy to apply, whether it's this section of municipal equity, or whether it's fee waivers or expedited review of applications and inspections, which that right now, because that's unchanged at this point, so I would defer to Acting General Counsel whether that's out of the scope. The solution to it, to make sure that you are capturing the population of people, as many people as possible, which is that majority ownership, anything over 50%, regardless of the statute, is you just include all of those terms. And regardless, that would capture as the definition stands right now for economic empowerment applicant, social equity program participant, where the majority ownership is there, and they're captured already. Now you just throw in social equity business if you want to, but they're already going to be captured. But it might be a little different. So you just connect the terms.
That makes sense. What do you think, Commissioner Roy?
I think that makes sense.
Okay.
I mean, it does make sense. It's good if we can see it. I mean,
We just need a whiteboard. We need a whiteboard. We can just start doing math at 5:30.
I mean, I don't see any other, so we don't lose that population. I don't see any other options right now, right?
Mm-mm.
It's ultimately
another amendment. Yeah, we would probably have to revisit and do some revisions after this regulatory round.
Just one final, Director Potvin, approximately, can you quantify how many licensees you think this would impact?
Madam Chair.
Yes, Director Potvin, please.
Commissioner Roy, it's an excellent question. I don't have an answer for you right now. I can't give you a number. I'm giving you a guesstimate. I'm giving you something that I've seen with every provisional license and final license that's moved to you, and what I see on executive summaries, applications. I've seen 50.1%, which we have honored and by the actual language in the regulations, and I've seen 51%. I know the population, and I am assuming confidently that the population under 51%, but over 50% is small. I don't have a number for you right now.
Are there any other questions, comments, or concerns? So, Attorney Baker?
Sorry, I just wanted to clarify for the record what changes are being made through either the definition or under 4A here. Or have we decided? I just need to double check.
No, that's a good question. So I was moving us away from the definition, and my suggestion was to not make any changes to what we have currently within our draft. And so I wanted to ask my fellow commissioners if we were all in consensus to leave the current definition as is and not make those changes. Commissioner Roy and then Commissioner Stebbins.
I know we don't have a crystal ball, but we don't know when we're going to revisit it, and those folks won't have a safety net. And if that's what we choose, that's what we choose. It's just those folks will fall into that crack until we are able to put it in scope. And if that's what we choose, because we can't take this on right now, that's okay. Those are vulnerable. That's all.
I feel like maybe I interpreted Director Potvin's explanation a little bit differently. I thought that as long as we're referencing as long as we continue to reference not only social equity businesses, the social equity participants and economic empowerment applicants, then we're still accounting for that universe. But maybe I have heard him incorrectly. Director Potvin, is that the correct interpretation of your explanation?
Thank you, Chair. And I apologize because I was listening to you sincerely, but I was also going back to 500-101-7 in the pre-verification versus the verification to be able to recommend a friendly amendment or clarification around the social equity business. E.C. Lopez I agree with her in the sense that it is the statutory definition is that a social equity business is in fact a licensee, and a current licensee that has already been verified through the economic empowerment process or the social equity business. There's two different elements here. Essentially is in the definition, and I agree with E.C. Lopez in the sense that it's current eligibility, which means they've already been found to be eligible. They're in the program, in one of those two programs. The second element is for social equity business is a marijuana establishment, essentially. That means they're already licensed. That right there is going to preclude, from a policy point of view, any benefit or any of the policy objectives that you're trying to get to anybody who would fall into that category but is not already licensed, which from what I'm hearing, that would not accomplish your goal, your policy initiative. When we talked about it, and again, going back to that, looking at the 500-101 subsection 7, where there was this certification of verification or pre-verification, and I'm looking at a stale draft of the regulations without any of those changes, but from my recollection, there was amendments made that there is a verification of a social equity business and a pre-verification of a social equity business. And the only distinction there was that one is already licensed,
right,
and one is not.
And that was to capture more, yes.
That was to capture more, and that was to make sure that we didn't leave anybody behind, and that the policy initiatives with all these other things were going to be available to those initial applicants so that there was a reduced barrier to entry, whether it be through HCA negotiations or any other policies that you would want to adopt.
Mm-hmm.
So in a sense, where we are right now with the HCA negotiations for new applications and renewals, my recommendation for your consideration would be regardless of new applications or license renewals, to make sure nobody is accidentally or incidentally left behind, is that it applies to social equity businesses that have been verified or pre-verified by the commission.
And Director Potvin, this is an amendment to what section of our regs?
Thank you, Madam Chair. Let me now go away from 500-1017 and make sure that I am referencing the right section that I was just at. Just bear with me 1 minute. I
think it's page 77, Director Potvin, but I think.
Yep. I just got there. Thank you so much. It's 500.181 section 4, which is correct. It starts on page 77, and it's 4A. A host community shall prioritize negotiations of HCAs with equity parties. The equity party in a negotiation of an HCA for an application for licensure is a licensed applicant that has been designated as a social equity program participant, an economic priority applicant, that's where we would have to add an empowerment, or both, or has been verified or pre-verified as a social equity business. Just from the reading of the room and my listening to the commissioners and the goal that I think you're trying to get to, I think that is what accomplishes it, and it captures everybody that would qualify with a license or not.
And then would we add that language to the end of this section as well so that it repeats twice?
So my excellent colleague, E.C. Lopez, is working on that right now, I think. Well, at least I think that's what she was saying. Maybe it was a reference to something else. The language could be added to the end of that sentence to include the verified or pre-verified social equity business. It would be added to that second sentence of 4A, and it would also be in the proposal that I'm talking about the next sentence. The equity party in a negotiation of an HCA for an application for renewal of licensure is a pre-verified or verified social equity business.
Okay, now Commissioner Stebbins, because you originally raised this, does this address the concerns that you originally raised?
I'll start with the fact that I have more issues circling around than I can even probably begin to count. There seem to be more airplanes flying around the airport than when I started. I'm really troubled by the fact, or I'm not troubled. I have some general concerns about the social equity business definition given to us in 180, how we're defining it now in our regulations. And if what I'm hearing is that a social equity business is somebody who is, and this term has been brought up, is currently has a status of a social equity program participant or is already qualified as a economic empowerment priority applicant, I'm struggling to understand who we pre-verify.
So that the idea of pre-verification are those who are not currently licensed, is to capture a larger universe outside of that scope. It's people who would otherwise qualify. So instead of, it's essentially that language that needed to be removed from the social equity business definition. It's that, sorry, my window was open. But that's who we're trying to incorporate by having pre-verification.
Right.
Commissioner Roy, and then Director Coffin.
And Madam Chair, thank you. Commissioner Stebbins, because we agreed, like, if the social equity program runs once a year, we don't want folks who are otherwise eligible not to be able to be included. I think that was part of these are like potential folks, right?
Yes.
Yep. Madam Chair, if I may.
Yes, Commissioner Stebbins.
And I appreciate that. And I think that's the goal, the lauded goal that we're looking to accomplish here. What I think I'm hearing is something different, than a social equity business is the snapshot in time that if you're in the SCP or we previously qualified you as an EE applicant, you have to have gone through those programs. You have to currently have been somebody who's been through a cohort or been somebody we previously certified as an EE applicant. We don't have, we're conflicting things here, I think. It doesn't sound like we have the ability to say, oh, yes, you would be eligible, which I love that goal. And I want to see us come to some alignment, because that's not what I'm hearing about how we're currently defining social equity business in our definition.
So there's, I can see the confusion. You're right. Social equity business, and this is, from our attorneys, from, the breakdown of the statute that we have. It would only include those who have gone through the social equity program or who have been accepted, and those who are EEAs. That's the social equity business.
Right.
Pre-verification is for municipalities and their negotiations and their considerations and their benefits that they make available to equity parties. And that's the section we're in now. We're making this larger universe to incorporate, I'm getting tongue-tied myself, but it's so that when, let me just reread the beginning of 4. Equity standards for host communities during HCA negotiations for social equity businesses, licensed applicants, and individuals and entities pre-verified by the commission is to give people the opportunity at the host community level to have benefits, to have license availability, so on and so forth, whatever those host communities put in place for their municipal equity standards, to make sure that those who are pre-verified, those people who fall outside of our licensees, who fall outside of the social equity program, who fall outside economic empowerment, have access to that. Does that answer your question?
Commissioner, you may have just sealed the deal and helped me bring some clarity to that.
Okay. I'm glad, because I know I can.
Yeah, no.
Okay.
And first of all, I appreciate the goal that is Commissioner Roy was highlighting. Folks who have not gone through our SEP program, we don't want to leave behind. We don't want to limit their opportunities to participate in the industry at the municipal level through the section of the regs that we're taking up now. That would kind of, and I understand it now in 4A. Now I'm guessing, because there is that, and individuals or entities pre-verified by the commission. I just want to make sure that it was reflected up top under C, where we don't define those individuals and entities pre-verified by the commission, up above in C.
Now, Commissioner Stebbins, when you are referencing C, do you mean what we've changed to C that at first read B, or are you, I just want to make sure I'm looking and that we're all looking at the same section.
Sure.
Do you mind reading the first line of the section where you're looking?
Sure. Our new letter C,
Okay.
a municipality or host community shall adhere to best practices for HCA negotiations with licensed applicants who have been designated as, I know we changed some language there and I don't have it in front of me, designated as social equity businesses, social equity program participants, or EE priority applicants, including but not limited to the following. Just trying to make sure that we're capturing those individuals and entities pre-verified by the commission.
Madam Chair, if I may?
Yes, EC Lopez.
I believe that we already amended that language to read, a municipality or host community shall adhere to best practices for HCA negotiations with individuals or entities pre-verified pursuant to 935 CMR 500-1017, comma, social equity businesses, comma, and licensed applicants that have been designated as social equity program participants or economic empowerment priority applicants, including but not limited to the following.
Thank you, EC Lopez. Commissioner Stebbins.
Yep. Thank you, EC Lopez. That was language dumped back in the chat. It seems like hours ago now, but I appreciate that. I think I'm all set. I apologize for the question.
No apologies necessary. I'd rather we talk it out and get it right. So, all right, now, are we comfortable with the language where we are? Okay. I see the head nods. Attorney Baker.
So I just want to double check again, though, that was above in subsection 3. So for
Yes.
subsection 4A, are we comfortable with how it reads as is now, or do we want to make amendments to this? I don't know if we have consensus on 4A.
Well, there were edits to 4A now,
Okay.
including the addition of the word empowerment. I think the edit came from Director Potvin. So Director Potvin, do you mind? I'm sorry, EC Lopez, are you asking to provide a comment before Director Potvin restates, or I'll let you go. EC Lopez, please.
I did drop some potential language into the chat in response to Director Potvin's suggestion, so that might be a good starting point.
Okay, can you read it, please, EC Lopez? Actually, I'm sorry, do I see you chewing?
No, it's
take
okay.
your time. Okay. All right.
It reads, a host community shall prioritize negotiations of HCAs with equity parties. The equity party in a negotiation of an HCA for an application for licensure is a licensed applicant that has been designated as a social equity program participant, an economic empowerment priority applicant, or both, or has been verified or pre-verified as a social equity business. The equity party in a negotiation of an HCA for an application for renewal of licensure is a social equity business. The equity party may also be an individual or entity that has been verified or pre-verified as a social equity business. I believe the suggestion was to restate it a second time at the end. That could potentially cause some confusion only because the pre-verified individual may not necessarily be in a negotiation for renewal, but that's just something for the board to consider.
Thank you, EC Lopez. Commissioner Roy.
Thank you, Madam Chair. Based on the language in A, does that make 4 inaccurate or not all encompassing? Are we,
EC Lopez? All right, I'm sorry, Commissioner Roy, is that directed
Yep.
to to EC Lopez?
Yeah,
Tim.
well, anyone who, we're all tired, so anyone that wants to opine on this, I'm not wondering if it's, if 4 falls short based on A.
Okay, I see Director Poppin with his hand up. Director Poppin.
Thank you, Madam Chair. Commissioner Roy, are you talking about the title of the section?
Yes, the title. Is the title fall short based on the language?
Yeah.
Is it not an accurate descriptor of A? Is 4 not an accurate descriptor of A?
Well, A will still exist. A will still be enforceable regardless of whether you change it. But I do see what you're saying. I did notice that as well. One option that could be considered by the commission is to take out social equity businesses and replace it with equity businesses or individuals, equity individuals or businesses, to more align with I'm sorry, the phrase is equity parties. That would align with A more so.
Commissioner Roy.
I love that, Director Pottman. And if we define equity party as more than 50%, would that be a safety net for that group that fell in between?
Madam Chair?
Director Poppin, please.
If we use the term equity parties and we define it,
Yeah, that's what I'm proposing.
It includes social equity businesses, and you tie it to over 50% but under 51%, I think that would run afoul of it would run afoul of the statutory definition for social equity business. But I do think that there is out of the box thinking where a definition could work and accomplish the goal, but I think it would there's a drafting question. But changing the definition, a statutory definition like that in that manner, I don't think is compliant with the spirit or the language of the law.
Commissioner Roy.
I'm not proposing to change the definition of social equity business to conflict with statute. What I am proposing is to substitute or add equity party. So social equity business has the definition per statute, but equity party would fill in the gap. The definition of equity party, could that fill in that gap?
I feel like this might be similar to what Commissioner Camargo suggested earlier around equity participant, and for consideration for another time because it fell outside of the scope. But I am going to let anyone else opine. I see EC Lopez. EC Lopez, please.
I don't have an opinion on that, but to your original point, Commissioner Roy, about bringing the title of 4 in line with 4A, we could just shorten it to equity standards for host communities during HCA negotiations with equity parties. And we would be okay doing that because then in subsection A, we spell out who the equity parties are. So that could be another way to create some alignment there.
I think that's a good suggestion. Commissioner Roy, what are your thoughts?
I love it.
Okay. All right. So do we have consensus to change that header? Commissioner Camargo, are you okay with that?
Can you just repeat the header, please?
It would read equity standards for host communities during HCA negotiations with equity parties.
Sounds good to me.
Commissioner Stebbins.
I'm comfortable with that.
Okay, we have consensus. Are there any other thoughts, comments, concerns in this section or for the header or A? Okay, Attorney Baker.
Thank you, Madam Chair. Moving on to B, a host community may waive. Again, I think time is of the essence now, so we should probably keep moving through if no one has any comments on this.
Attorney Baker, keep on reading and then I'll interrupt
Sure,
you
sure.
if you need to get interrupted. So go ahead.
Thank you. And also sometimes when I'm reading, I can't see. So if you verbally interrupt me, that would be appreciated. Thank you.
Okay.
All right. B, a host community may waive or reduce fees for an equity party to an HCA negotiation, including but not limited to community impact fees, zoning, and occupancy fees. C, required practices. At minimum, a municipality or host community shall take the following actions during HCA negotiations with an equity party to promote and encourage their full participation. 1, engage in an ongoing dialogue by providing multiple opportunities for discussion and negotiation of HCA terms, including, at minimum, 2 conferences with an equity party. 2, including any attorney, authorized representative, or other advocate if elected by an equity party in all negotiation discussions and conferences. 3, promote language access by providing a certified interpreter or translator to assist an equity party who is a non-English speaker during all negotiation discussions and conferences. 4, provide reasonable opportunity for equity party, provide reasonable opportunities for an equity party to review a proposed HCA term or condition outside of negotiation conference, or to seek review or input by a third party of their choice. 5, negotiate the terms of an HCA in good faith, including consideration of flexible terms that may mitigate particular challenges affecting an equity party, such as access to capital, with all terms and clauses conspicuously identified and openly discussed. And 6, allow an equity party to propose an amendment to or seek cancellation of an HCA within 30 days from the date of execution of the HCA.
Okay, Attorney Baker, pause right there. Commissioner Roy.
Thank you, Madam Chair. This question is to EC Lopez. It was recommended in the HCA portion that we remove good faith because it was a different standard. Does that apply here as well?
EC Lopez.
So in this sense, I think this was included just speaking to, again, the implied warranty of good faith and fair dealing in any contract negotiation. So that would be something that they would be bound by. I think the point maybe was to just state it, but the commissioners could certainly choose to take it out if they wish.
I don't propose it. I didn't ask the question to take it out. Why was it not applicable or recommended for HCAs in general, but it is here? I guess you could explain that. That'd be helpful.
I think it's who the determining party. It's who's making that determination. For the HCA component, it would have required the commission. Let me take a step back though. EC Lopez, if you want to also offer your opinion, please.
Thank you, Madam Chair. I believe bad faith versus good faith came up in discontinuing operations. So the question being, okay, can a host community, there was a conversation about, when the host community wants to end that relationship, wanting to kind of impose a good faith requirement, and the bad faith prohibition, which accomplishes the same goal, but just is a little easier to ferret out in the event of an investigation. That was the kind of reason for that being an action taken. I take your point, Commissioner. In terms of this is speaking to affirmative actions that the host community must take during the HCA negotiations with an equity party. So it wasn't phrased in terms of prohibitions, but more kind of affirmative steps that we would want the host community to undertake when they're engaging in the negotiations. So if the bad faith angle were to be explored, it would be more likely under prohibited practices rather than in the actual affirmative actions that the host community is taking during the negotiation process. So I think it's just a matter of the section of the regulations where that is being addressed.
Commissioner Roy.
So can we lift and shift this and put it in the regular negotiations and under the affirmatives, negotiate the terms of an HCA in good faith? EC
Lopez.
I'm sorry, Commissioner, I just want to make sure I understand the question. Are you asking if we could lift the, take out number 5, negotiating the terms in good faith, and instead recast it as a prohibited practice, not to negotiate in bad faith?
No, I was saying leave this,
Mhm.
but mimic it in HCAs under affirmatives for general negotiations that must, municipalities must negotiate the terms of an HCA in good faith. Like if it,
I
can we
see.
mimic it, not in the affirmative?
So included as an affirmative kind of
Yes,
responsibility or requirement in the HCA section, the general HCA section.
yes.
That is certainly something that the commissioners can have the authority to do, if that's something that the body would like to explore.
Thank
Commissioner
you.
Roy, are you
I'd like to explore that. Yes.
okay? Well, that's a new pin.
It's a pin.
It's a new pin that we'll go back to.
Thank you.
That's for the HCA section. Okay. Are there any other questions on this component that we have stopped for around the good faith conversation? I guess this is all under subsection C. Are there any other questions or comments within section C on page 78? I don't see any. Attorney Baker, please proceed.
Okay, so I am now under prohibited practices. All right, so no municipality or host community shall negotiate an HCA with an equity party through the use of undue influence, duress, coercion, intimidation, threats, or any strong arm tactics. 2, no municipality or host community shall threaten the loss of an equity party's position in its local application queue or delay to the processing of an equity party's application. 3, no municipality or host community shall compel an equity party to sign an HCA in any manner that conflicts with the practices required in 935 CMR 500 181 4C.
Commissioner Roy?
Thank you, Madam Chair. EC Lopez. Can we lift and shift from HCAs to prohibited? So we have good faith in affirmations and no bad faith in prohibited. So it's like insurance policy.
EC Lopez?
Both.
Thank you, Commissioner. Which provision are you interested in lifting over into the general HCA?
Sure.
section?
I'd have to scan up, but under HCAs, under prohibited practices, the bad faith clause we put in.
Mm-hmm. Oh, bring that over to this one.
So
right.
We have both. So in affirmations, you negotiate in good faith, and prohibited practices is no bad faith.
I'm wondering, Attorney Baker or Mercedes, do you mind restating for the record that bad faith language? I know our hard copies don't have the edits that we included, so either Attorney Baker or Mercedes, can you state that bad faith language so that we can see how that folds in here under municipal equity?
Sure. So would you like me to start with B for prohibited practices and read down 1 through 6?
Just the bad faith clause.
No, only the one that contains the term bad faith, please. And if you can put it into the chat, that'll be helpful too. So read and add to the chat so we can please.
Sure. And my Word is updating, so just one moment. And Attorney Baker, if you have that section up, if you want to just call to it while mine's getting there. So I have in 5 for bad faith for our host community. A host community shall notify a marijuana establishment if it no longer intends to continue as a host community for a marijuana establishment. A host community shall not discontinue relations with a marijuana establishment in bad faith. On receipt of a notice of discontinuance from a host community, the marijuana establishment shall notify the commission. A marijuana establishment, sorry. A marijuana, sorry, go ahead.
No, I probably made a noise. I didn't mean to stop you.
Okay. A marijuana establishment may submit a request for equitable relief to the commission upon receipt of a notice of discontinuance as described in 935 CMR 500 183 subsection C6. And I will put that language in the chat.
Thank you. Commissioner Roy?
So all I was proposing is that very, very small clause that says a host community shall not negotiate in bad faith. So the rest of it doesn't apply to this situation for negotiations. So I'm wondering if we have good faith in the affirmative and no bad faith in the prohibitions. So if I may, Madam Chair,
Yes, please, Commissioner Roy.
a host community may not negotiate with an equity party in bad faith, like something as simple as that.
I think, oh, go ahead. Thank you, Mercedes. Okay, so this language is helpful. And Commissioner Roy, let's see if this is what you're thinking of. A host community shall not discontinue relations with a marijuana establishment in bad faith. So maybe we would say a host community shall not discontinue relations with an equity party in bad faith. Is that?
Or negotiations, or relations or negotiate, or does it matter?
I think negotiation is the context that that this speaks to.
Okay. So,
Yes.
Commissioner Roy, can you state your recommended language, please?
A host community, are we calling municipalities or host community? I mean, what are we calling them? I want to be consistent.
Host community. Host community.
Okay.
Well, wait a minute.
Okay.
You could say a municipality or host community. Well,
Either one is okay. All right, a municipality.
No. What I mean is we use both because that's aligned with this section. So,
okay. So a host community and or municipality may not negotiate with an equity party in bad faith.
Okay,
Does that work?
Let me, because I want to. So we would say so prohibited practices. And every section here, it starts with no municipality or host community. So we'll continue that.
Yes.
No municipality or host community shall
negotiate
discontinue negotiations.
Or just negotiate in bad faith, not even discontinue, just negotiate in bad faith. See what I'm saying? No municipality or host community shall negotiate with an equity party in bad faith.
Okay.
I don't know.
Thank you, Madam Chair. From what I'm hearing, I think where you were about to go, and I'm sorry if I'm cutting you off and stealing thunder, negotiate or discontinue in bad faith. Was that where you were going to go on that section of prohibited practices?
Commissioner
Or Commissioner Roy?
Yes, but I'm a little tired, so yes.
Oh, sorry. Go ahead, Director Potvin.
No, I defer to EC Lopez.
EC Lopez.
It sounds like then perhaps the language would be that Yeah, no host community may negotiate or discontinue negotiations in bad faith with an equity
With an
party in
equity
bad faith.
party. Yeah,
With
that's
an,
the key.
yeah, with an, so
Yeah,
I can
the key.
write that.
Commissioner Roy, is that what you were, is that the language you were looking for?
Yes, we want to align the beginning. Madam Chair, you had
Yeah, the
no
no
municipality
municipality.
or host community shall negotiate or discontinue negotiations with an equity party in bad faith or something. That's more or less the sentiment.
Director Poppin?
Thank you. Just a real technicality friendly amendment to what EC Lopez just read. I thought I heard may, and I just want to, okay, she knows. Shall not negotiate in bad faith.
Shall not.
So it's mandatory and not permissible.
Okay. I need someone to state it for the record so I can ask for consensus. Attorney Baker, can you state the proposed language for the record, please?
I tried to capture it, so let me, please correct me if I'm wrong, but no municipality or host community shall negotiate or discontinue negotiations in bad faith. And then I took some liberty here, but nor shall it negotiate an HCA with an equity party through the use of undue influence, duress, coercion, intimidation, threats, or any strong arm tactics. Does that sound accurate? I'll throw it in the chat if so.
That EC Lopez, will you have in the chat, no municipality or host community shall negotiate or discontinue negotiations with an equity party in bad faith?
That's it.
Okay. That is the language.
Madam
EC
Chair.
Lopez. Yes.
I didn't know if the commissioners wanted to add that as a new subsection, but I see that Attorney Baker did include it in, combine it with the prohibited practice in number 1. So whichever the commissioners prefer, either one I think works.
I believe the recommendation from Commissioner Roy was to make it number 4, but Commissioner Roy, is that what you were thinking? Were you thinking this would be a number 4?
I was thinking it would, exactly, Madam Chair. I just want to look now, Attorney Baker, just do more language. I just want to make sure we all land. Where are we landing on that number 4? Is that EC Lopez at 6:02 p.m.?
Yes. That's the language is 602 from EC Lopez. The language that Attorney Baker has here is a combination. It's one with your language as well. So that's why we wanted to clarify that you want an additional number, which would be 4, and it would read what EC Lopez has put in the chat, which is no municipality or host community shall negotiate or discontinue negotiations with an equity party in bad faith.
What do you think, Madam Chair? I think it should be a standalone number 4, but what do you think?
I think it's cleaner, but I think it's cleaner. Okay, so now I am in agreement, Commissioner Roy. EC Lopez, please.
Just to try to, limit the pins, I did put in language to Commissioner Roy's other point of wanting to bring an affirmative obligation to host communities in the general host community negotiation process. One way that we could do that is adding in a new 180 subsection 2C, which would
EC Lopez, I'll pause you first.
Sure.
I love it. That's helpful because we can do that now. But I just want to make sure we get this language and consensus around this language first, and then we can go into your recommended language around good faith for HCAs. So for this language, the prohibited, no bad faith language, do we have consensus? Commissioner Stebbins and Commissioner Camargo. Okay, Commissioner Camargo as well. All right, so there's consensus. EC Lopez, now we can go into the language you have for the HCA section, please.
Okay. So what we could do is we could add in 500-180 subsection 2. This would be a new subsection C.
EC Lopez, can you tell us the page?
apologies, page 69. So on page 69, we have our subsection 2, which is general requirements for host community agreements. Right now, as amended, it starts off with a general discussion of the general requirements. Subsection A speaks to the requirements for a license applicant. Subsection B speaks to a requirement, the requirement for renewal applicants. Our new subsection C speaks to the model HCA and what that means for purposes of compliance. So then our new subsection D could be a provision, a good faith requirement or a statement of the good faith requirement, which could read as simply as Commissioner Roy suggested, which is a host community shall negotiate the terms of an HCA in good faith.
Commissioner Roy?
Great, thank you, EC Lopez.
Okay. Commissioner Camargo and Commissioner Stebbins, are you okay with that language?
Yes.
Okay, Commissioner Camargo? Me as well. So there's consensus there. All right. Now, we can go to the next section. What I want is, so my plan here is to break, but I want to just dinner break after we're done with municipal equity. We take a step back, get some food, come back and go into agent suitability standards. So Attorney Baker, please take us to the next section of municipal equity.
Of course. Thank you, Madam Chair. So I am on page 78 of our book here, and it's in 181 subsection 5, equity standards for positively impacting communities that were disproportionately harmed by marijuana prohibition and enforcement. So I will go to subsection A. A host community shall donate a minimum 3% of each community impact fee it receives from a licensee to the Cannabis Social Equity Trust Fund.
You can stop right there. I know we have to talk about this one. I see Commissioner Stebbins, your hand is up. Please.
Sure. Thank you, Chair. It's a very short section. I think, even though we didn't get to it, B is already referenced somewhere else in our regulations. But if I'm not mistaken, first of all, there were comments that were included from DOR that I think would make a host community trying to comply with A very difficult. And they had, I think they had suggested striking A.
Okay, I'm sorry. I thought I heard you said B, and I wanted to make sure we're talking about A. Okay, so you're saying A. You're recommending that we strike the language.
I think I'm suggesting we may be able to strike all of 5 because B is referenced already in our regs, and again, A, DOR is suggesting to us is something that a host community may not be able to do.
Are there any other thoughts? Commissioner Camargo and then Director Poppin. Commissioner Camargo?
Commissioner Stebbins, you said to delete the whole section number 5 because it's already somewhere in there, right? My question is number A, I think it's B1, as it reads, a licensee must have authorization to commence operations to donate to the Cannabis Social Equity Trust Fund as part of their positive impact plan. Is that language specifically somewhere in it, in the regs? Because I think this language here specifically speaks to having authorization to commence like a commenced operation. Licensee is the only one that can, I mean, I'm sorry, you have to be you know what I'm saying. So I'm just, I get striking it because at this point, if it's all in there, it doesn't make sense, but I want to make sure that this language, to commenced operations to donate, again, that's a policy discussion. But I think it makes sense. I'm okay with it. I'm just curious if it's somewhere else.
Commissioner Stebbins, if you have a response to Commissioner Camargo.
Sure, thank you, Chair and Commissioner. The language that I was looking at, this goes back to 500.101, which is page 32 in our hard copy, where it talks about the creation of a positive impact plan. And the language that we added was The marijuana establishment may satisfy this requirement in part by donating to the Cannabis Social Equity Trust Fund, provided that the ME meets the criteria set forth in 500.181.5. We now may need to take that part out because there won't be a 500.181.5. But I think because we use the language of marijuana establishment, that we are talking about something that someone who has commenced operations.
I lost track of whose hand was next. Was it Director Potvin or was, okay, I see Commissioner Roy. Commissioner Roy?
Thank you, Madam Chair. Can we dictate that? Because in statute, we created the language as far as public and private funds. And if, even though someone hasn't gotten, how can we tell someone just because they haven't gotten commenced operations that they can't donate to social equity funds? I don't understand how we can do that.
Commissioner Roy, do you mind repeating that again?
Yeah, so let me just go back to, let me go to the regs. Okay, so Mr. Stebbins is proposing, hold on, I have so many tabs open, just bear with me for 5 seconds. Okay. All right, the last one, B1, Madam Chair. A licensee must have authorization to commence operations to donate to the Cannabis Social Equity Trust Fund as part of their positive impact plan.
Mm-hmm.
Okay, that's what the part I was. That's what I was.
I wonder if that's sorry. Go ahead. Let me let you finish.
No, you go ahead. Go ahead. No, that's okay. You go.
I wonder if that's necessary. EC Lopez. I know that. Do you have any insight or on if this language, if removing it, would have an impact on our positive impact plans or the ability for licensees to make a donation? Just what does this language? What would happen if we removed it?
Well, I'll note that so this was part of the placeholder language that was put into effect in July to make sure that we had covered our statutory obligations in full, because this was not explored as a matter of policy previously. So the statute does require the commission to promulgate regulations establishing criteria for licensees to satisfy their positive impact plan requirement by donating a percentage of their revenue to the trust fund. And so this was a placeholder criteria. It's really for further policy discussion in terms of what that criteria will be, but we do have the obligation to set criteria.
But EC Lopez, the language that Commissioner Stebbins flagged earlier, that's on page 39 around positive impact plans, would that suffice in meeting our obligation under the statute, or is there another? Do we also
page 39?
Yes, page 39. Make sure I'm referencing the right page. Hold on.
32. I think.
32. Thank you. 32. Hold on. I'll pause it. I think Director Potvin has a response to my question. I'll let you provide a response, Director Potvin.
Thank you. There's a couple of things for that I would present for your consideration. I'm pretty sure that on page 32, it's the obligation to positively impact areas of disproportionate impact as applied to applicants and licensees. And that is now required by statute. And it is one of the options now is for the applicant or licensee to donate our percentage to the Social Equity Trust Fund. So that has been amended and considered already, but that is part of statute. This requirement that we're at right now is separate and distinct because there is a provision in Chapter 180 of the Acts of 2022 where there is a requirement to positively impact areas of disproportionate impact that is applied to municipalities in one way to interpret it. And that is in now 94G, General Laws 94G, Section 3D5, and the language essentially is, it requires the commission to promulgate regulations to establish minimum acceptable standards for host communities to positively impact disproportionately harmed communities. And I'm paraphrasing, it's not quote to quote, but it has been interpreted to have host communities have a part to play in positively impacting areas of disproportionate impact. So where, if you want me to stop, I'll stop.
No, I'll pause, and I'm going to paraphrase to make sure I'm understanding what you're saying accurately. You're saying that currently on page 78, 5B is accounted for on page 32, but 5A is not. The reason for 5A is the placeholder language because host communities now have a requirement to have equity standards in general. I know I almost got it, but now go back to you, Director Potvin.
To have a positive impact and to facilitate a positive impact on areas of disproportionate impact, which is a mouthful.
Got it. And that makes sense. So we're saying we're not talking about them impacting potential licensees or applicants. We're talking about areas, disproportionately impacted areas.
Yes. So first, let me address, I think, the minor issue in the situation where you were talking about 5B, where it's licensees who, a licensee must have authorization to commence operations in order to donate to the Cannabis Social Equity Trust Fund. Two things with that, and I think this is where Commissioner Roy was going, is we don't want to prohibit or eliminate the possibility of somebody who has a final license or a provisional license from donating to that. That I think that's unnecessary. So, and right now, but as a matter of interpretation and established process, there's an understanding right now that in positive impact plans for applicants, for licensees who have not commenced operations currently, that there's some expectation that they're going to stop fulfilling the majority of their goals once they commence operations, is where they're starting to get that revenue if they're making a donation. So I think there was a good faith intention to have an implication there to identify that that's when it's really going to stop making a change. But it does, the language as is limits, it does shrink that population to those who just commence operations. So yes, one recommendation is to in fact shrink that. Yep. But going to the, do you want me to continue, Madam Chair?
Well, actually, you might not need to. I'll tell you why, because I'm thinking a couple of things. First off, I'm mindful of the time. I know that I'm getting pinged. I know that we're sort of reaching a point now where we might need to refresh ourselves. And I feel like this is a conversation. We might have to inject some really substantive language here. So what I want to do is kind of take a pause, and I want to sort of feel out the room to figure out best next steps for the remainder of the day. We can take a break and then come back and continue to go through the draft. We have provided notice for tomorrow. I did that just in case, and it looks like we might need to utilize it. So, but the notice was provided beginning at 1 tomorrow. It's a virtual 1. But I want to kind of open this up to figure out what everyone is thinking. I want to get a feel for the room. Commissioner Camargo, Commissioner Roy.
Thank you, Madam Chair. If we reflect back, now we're on day 4, and we haven't even gone through like the entirety of 2 sections. So to cram in an entire finish that we have to contemplate B1. We have to go back to the pin, the big pin in municipal equity before we can even begin suitability. So haste makes waste. I don't want to like rush this process. to say we completed it, and thank you for posting tomorrow, because I feel it's necessary, honestly. I mean, I don't know how my colleagues feel, but I just feel there's still a lot to contemplate here. And then we have a whole other section, and it's taken us 4 full days to get through, you know, not even 2 full sections. So thank you.
Commissioner Stebbins?
Sure. Thank you, Chair. My suggestion would be, and again, I'm going to be really bad at projecting how long it may take us to wrap up this section and make some decisions on 5. But I'd like to try to dig a little bit more into 5, but then suggest that once we have a discussion about it and where it might lead, that after that we stop for the evening and take up the rest of the work that we have to do beginning tomorrow at 1.
Commissioner Camargo?
I agree with Commissioner Roy. I also know that we have a team producing behind the scenes. And I know they're watching each other's back, and I know that our legal team as well is putting out a lot of brain power right now. And I don't want any risks when it comes to our legality. So I think we should definitely I think maybe we could try to exhaust a little bit more of this section, and then start up again tomorrow. I think it also gives us time in the morning to connect with staff if there's any questions that we may have, and some of the pins or some of the stuff that we have left. But you know, this policy is so important, and I want to make sure that we're all not creating exhausted policy. So.
Okay, so if I'm hearing the room correctly, we continue the discussion on 5, and then we take a pause until tomorrow at 1 o'clock after that. And I'm looking at EC Lopez, Director Potvin, Attorney Baker, Attorney Carter, because I know we're all here, and I can't see you, Mercedes Erickson, but I'm gonna assume you're probably nodding too, because I know you are typing like a mad woman. Okay, all right. So let's wrap up. Let's go into let's continue the conversation around 5. Commissioner Roy.
Thank you, Madam Chair. I agree wholeheartedly with Director Potvin that we strike 1, and because we're going to hurt the fund and unintended consequences, we will hurt the fund. Because some folks stay in the provisional phase for a long time, and they may have the resources to donate, and they will want to donate, and we are going to say you can't. So an unintended consequences, we're going to hurt this fund. So I limit the universe that can donate to. So I agree with Director Potvin. We should just strike number 1.
I agree.
What can I ask you, what number 1 are we referring to?
5.
5B1.
Okay.
Thank you, Madam Chair. So is the commission ready to have a conversation of about what that criteria will be? Because we need to have criteria. So, and to some degree, there has to be some criteria that you decide on as a body for licensee who wants to donate. It doesn't have to be limiting in terms of the universe of those who can donate, but in some ways, I mean, a criteria will kind of do that, but it doesn't have to be as drastic as 1. 1 was just a placeholder, but criteria is the obligation under the statute.
Madam Chair.
Commissioner Camargo.
Yeah, and I think Commissioner Roy. I don't know, Commissioner Roy, if you had your hand up before, but I'll go really quickly. Let me just kind of, because we've talked a lot about this section. So Commissioner Stebbins had recommended we delete the section. It sounds like we're back to keeping the new A1, but trying to figure out some criteria for those who want to donate to the equity fund.
Commissioner Camargo, can you restate that?
Just say it again, please.
Yeah. Basically, Commissioner Stebbins had recommended we just delete the whole section because in some place, in some form, it's there. It's implied. But now it sounds like we're talking about leaving the last section here, which I think is now A1. Licensee may satisfy their positive impact plan. A licensee may have authorization to commence operation. So it sounds like to me that we are trying to figure out everyone can donate to the equity fund, not just folks who have commenced operations, but then trying to figure out a criteria. So I'm a little confused because there's been a lot of conversation. So
yeah, I can help. So yes, originally Commissioner Stebbins recommended striking the section in its entirety. And EC Lopez redirected us because of the statutory requirements specifically for host communities to positively impact areas that have been disproportionately impacted by cannabis prohibition and enforcement. So this is a statutory requirement. Both components speak to the requirement, both for licensees and for host community agreements, for host communities. However, B is somewhat captured on page 32 on the language around positive impact plans. Does that answer your question?
yes, but I guess my further question is, Rebecca, you said that we need to figure out a criteria. So criteria for what? For people to donate to the thing? Go ahead. I'm sorry.
Madam Chair?
I'm going to make an executive decision. I think this needs more time. I think we're going to put a pin in this tonight so that we can flesh this out, because we are talking about creating criteria for municipalities to follow for entire communities as well as licensees. And I just want to make sure we're doing this with fresh minds. I can see us sort of getting a little confused as we go on. So I recommend that we take a break here, and we have 2 pens now in HCA's, one being this section, and the other, Attorney Baker, do you mind refreshing my memory on the other? Oh, the other pen was around the cap.
The caps.
You know, what happens when a cap is removed and the requirement for a certain portion of licenses to go to social equity businesses. So Attorney Baker?
Madam Chair, Mercedes and I just have one follow-up question from language. Mercedes, if you have the language in front of you, would you mind reading it?
Is this for section 5? Okay.
We just want to circle back before the, sorry.
Yep, no worries. This was for the addition from Attorney Lopez's added language for 182D, a host community. I have the full set of regulations, so
Okay.
I don't have.
Okay, 180.
Madam Chair, this if you.
Oh, it's the HCA good faith
Bad
language.
faith. Yep.
Okay. Yep. All right.
So I just have a question of under 2D for where that is being added.
Commissioner Roy, this originated from your recommendation. Do you remember where you were recommending this language be inserted?
Was it the good faith or the bad faith, Mercedes?
This is the good faith.
For the HCA's goes under the affirmative, not the prohibitions, but the affirmative. And I think it was just the maybe the last one, a standalone number.
What section is that?
Chair, if I may.
Page 30 something. I forget.
So the good faith, the affirmative good faith obligation would actually go, Mercedes, if you go to 500-180 subsection 2, you have A, B, the new C was the model host community provision. So this would be the new D after that.
Okay. Is this on page 69?
Yes.
Lopez?
Yes. Yeah.
And That's accurate, Commissioner Roy.
It is. Mercedes, can you just restate the addition, please? Thank you.
Sure. Yes, so this will be a new 2D. A host community shall negotiate the terms of an HCA in good faith.
Thank you. I just have a request. Mercedes, as you're making these edits, so like we're working off a copy, at least I am, that doesn't have the new additions electronically. I don't want to put undue burden or stress on anybody. Do you have one that you could send to all of us? Because we keep doing old D, new D, you know what I mean? Like if we had the updated version we could look at, that would be enormously helpful.
Yes, after this meeting, I can save a read-only copy and share it with you all. And Andrew, sorry, I saw your hand up.
Thank you, Mercedes.
Acting General Counsel Carter.
Yes, if I may, Madam Chair, and thank you, Commissioner Roy, for that request. It was going to be my suggestion that based on the significant discussions that we've had for 4 days, that we circulate a copy this evening in a read-only version so the commissioners are able to see the updates that have been made thus far.
Any other questions or comments? All right. It is 6:32. I will entertain a motion for us to adjourn until tomorrow at 1 o'clock. We will be virtual. I think that will give us enough time to think through these pens and prepare for the suitability conversation. Do I have a motion? Oh, I just made a motion. I'm making the motion. Oh, I'm entertaining a motion. See, that's all the more reason why we need to take a break.
So moved.
So
Second. Moved. Thank you.
Second.
Motion by Commissioner Stebbins, second by Commissioner Camargo. I will now do a call of the roll. Commissioner Camargo.
aye.
Commissioner Roy.
Aye.
Commissioner Stebbins.
Aye.
The chair votes aye. Everyone, thank you so much for all of your hard work. Thank you, thank you, thank you. Let's all get some sleep, and I'll see you all tomorrow.
Thank you, everyone.
We are
Thank you, everyone.
all right.